taken to the stand to explain, or rather to argue and call for the expansion of the affidavits that had been sworn in by some of the prosecution witnesses who had not turned up to the Senate just to be examined and cross-examined, and that the Speaker making a ruling on it. And afterwards, Paul Mwite was instructed, or rather told, to bring to the stand his sole witness, that being Deputy President Rigathi Gachagua. And he did excuse himself from the House, that the Speaker did allow him to do so. And minutes later, he came back to the Senate, informing the Senate that he had just received information that his client, Deputy President Rigathi Gachagua, had been hospitalized, seeking for the House to adjourn until 5 p.m. when he can be able to tell the House in a clear way and manner where the situation about his client. And after discussion and deliberation between that is the Speaker of the Senate, together with the minority side and the majority side, or rather the leadership of the minority side and the majority side, the Speaker did rule that, having considered both sides, that is the majority and the minority, directed that the sittings of the Senate during this impeachment process of Deputy President Rigathi Gachagua be suspended till 5 p.m. Well, again, dear viewer, if you're just joining us, it is that the Senate has suspended its sittings till 5 p.m. later in the day. This is to allow the defense side, that is Deputy President Rigathi Gachagua's side, to bring its sole witness, that is Rigathi Gachagua again, who, according to his lawyer Paul Mwite, he says that Deputy President is reportedly, or rather reportedly, has fallen ill, and they needed more time to check on the situation of the Deputy President, and they will be getting back to the House at 5 p.m. to update the Senate. And the Speaker has allowed this and directed that the House suspend its sittings to convene at exactly 5 p.m. And we are here at TV47. We are still keeping tabs on that to ensure that you get these details as they happen. But just to bring you up to speed on the events that did take place earlier, starting yesterday when the process began, that is on Tuesday, when the prosecution side, that is the National Assembly, did present its case, and as of today, that is by 2, it did conclude presenting its case by calling some witnesses, and did not manage to call all the witnesses as listed by the National Assembly. On some of the witnesses, it will call before the stand to give finer details to this particular matter. Dear viewer, just to give you to prick your memory, is some of the witnesses the National Assembly had listed to appear before the Senate to help prosecute the 11 grounds that had been leveled against Deputy President Rigathi Gachagua for impeachment, included Ecomas Mwengi Mutuse, who is the mover of the motion at the National Assembly, and also the Member of Parliament for Kibwezi West. Also, he did appear, that is from late afternoon, that is on Tuesday. And later in the evening on Tuesday, we had Andrew Mulwa, who is the former Chief Executive Officer for the KEMSA, Kenya Medical Supplies Agency, did appear on behalf of the National Assembly as a prosecution witness. And we had EACC appearing through a representative, Abdi Mohamud. And we remember earlier on, the side of Rigathi Gachagua at some point did say that this was a trial by ambush, by bringing in EACC to this matter. But also in the list of the National Assembly, some of the people who were to appear but did not appear were Johnson Sakaja, the governor for Nairobi, Masiwe Njau, who is the secretary to the cabinet Peterson Njomo Moshera. But these three had sworn an affidavit which had been included in the impeachment motion and the bundle of documents that had been submitted at the Senate during this impeachment process. Now, elsewhere, and today, it is when the side of the prosecution did conclude, or rather the National Assembly did conclude its case. And at 2:30, it was expected that Deputy President was to take the stand as the sole witness to this matter to defend himself against this impeachment motion, whereby 11 grounds have been laid against him. But as if you're joining us as of now, it is to tell you that this particular sitting has been suspended till 5 p.m. later in the day. This is after after Paul Mwite, representing Deputy President Rigathi Gachagua, did inform the House that the Deputy President had fallen ill and reportedly in hospital. All right, now we link up with our Parliamentary Affairs reporter, senior reporter, that is Elizabeth Mtuku, to bring us up to speed on the situation. Liz, what is the current situation at Bunge?
Namna bila shaka ni mchakato ambao umeendelea katika bunge la Seneti. Alasiri adhuhuri ya leo alikuwa anatarajiwa kuwepo naibu wa rais Rigathi Gachagua kuchukua nafasi ya kuweza kuwahutubia Wakenya kuhusiana na masuala ambayo yanaendelea, na swala hilo na mchakato mzima wa kubanduliwa kwake ni swala ambalo baada ya bunge kurejeana katika vikao vyake vya kawaida, kila kitu hakikuenda jinsi ambavyo ilihitajika, na hili lilitokana na yeye kukosa kufika kwenye vikao vya jioni ya leo, na ambavyo vilitarajiwa kuanza mwendo wa saa 2:30, na hilo linajiri wakati ambapo mawakili wakiongozwa na wakili Paul Mwite walielezea kwamba wanahitaji muda kidogo kuhusiana na kufahamu alipo naibu wa rais Rigathi Gachagua. Na labda nikujuze ni kwamba mchana wa leo, wakati wa maankuli ya mchana, naibu wa rais aliondoka kama kawaida na kama ilivyokuwa jana kutoka majengo haya ya bunge ya Seneti na akaelekea kwa maankuli ya mchana. Lakini jinsi ambavyo ilivyoratibiwa na ilivyopendekezwa na ilivyotarajiwa na wengi ni kwamba hakurejea katika vikao hivyo vya jioni. Na wakati mkao huo ulipoanza, Spika Emerson Kingi wa bunge la Seneti sawa na maseneta walionekana kukereka zaidi kuhusiana na shughuli nzima na yeye kukosa kufika kwa wakati ambao ufaao. Wengi wa maseneta wakiwa na maswali kuhusiana na lile ambalo lilikuwa linaendelea. Seneta, ujambo? Huyo ni mmoja wa wale maseneta ambao walikuwa wanazungumza wakati huo. Nilikuwa nadhani atanipa nafasi nizungumze naye, na wakati ambapo alikosa kufika, wakili ambaye anaongoza mawakili wa upande wa naibu wa rais Rigathi Gachagua ambaye ni Paul Mwite, alielezea spika wa bunge hilo la Seneti kwamba angependa kufahamu alipo. Na wakati ambapo spika amekuwa akizungumza, kuna jambo ambalo ameelezea kuwa alikuwa anafahamu kwamba kulikuwepo na mashauriano kabla ya mkao kwamba huenda hajisikii vizuri, na ni baadhi ya yale ambayo yaliangaziwa katika masuala hayo. Lakini baadaye Paul Mwite akaielezea bunge hilo kwamba hawezi kuendelea na shughuli za kufika mbele ya kamati hii, kwani naibu wa rais popote alipo na baada ya kuondoka ni kwamba hajihisi vizuri, amekuwa mgonjwa. Na mkao huo wenyewe kutokana na maseneta ambao tumepata nafasi hata kuwasikiza, wengi walikuwa na maswali kuhusiana na vikao vyenyewe. Na wakati huo wote haya yote yakitendeka, nimepata nafasi kutafuta baadhi ya mawakili kutaka kujua endapo naibu wa rais hatarejea kama ilivyoamrishwa na spika wa bunge hili ambaye ni Emerson Kingi. Nilitaka kufahamu ni kipi ambacho kinatendeka, na wengi wakisema kwamba endapo hili litatendeka tutarejea katika kifungu cha 145 cha katiba kuhusiana na mchakato mzima wa kumbandua naibu wa rais, wakisema kuwa endapo mswada huu sio mswada bali hoja hii ilikuwa inahitaji siku 10 mwanzo baada ya kutoka katika bunge la kitaifa, na ilikuwa inahitaji siku hizo kisha kwa kuundwa kwa kamati kulingana na kipengee hicho cha 145 cha katiba, na kamati hii ingechukua muda wa siku 10 kuendeleza shughuli hiyo, na wengi wakawa na maswali endapo siku 10 zimekwisha. Ni baadhi ya yale ambayo nimepata kutoka kwa mawakili, lakini kumbuka kwamba nimeona mawakili ama kikosi cha mawakili wa naibu wa rais Rigathi Gachagua kikiondoka katika bunge hili la seneti, hawakutaka kuzungumza na wanahabari, lakini kulingana na wakili Paul Muite ni kwamba wangeenda kufahamu alipo naibu wa rais Rigathi Gachagua hospitali gani na maradhi ambayo anaugua miongoni mwa mengine, na hili litaweza kubainika endapo watarejea katika mkao huu saa 11:30. Ni baadhi ya yale ambayo tunafuatilia moja kwa moja. Kumbuka awali ambapo vikao hivi vilianza, naibu wa rais kwa kawaida na katika picha zetu za moja kwa moja asubuhi alifika kama ilivyo jana na siku hii ya leo katika bunge hili la seneti, na vikao vikiendelea alikuwa yupo ndani. Miongoni mwa yale ambayo tulikuwa tunashuhudia, na awali kulikuwepo mawakili kutoka upande wa sio mawakili bali wale ambao ni witnesses kutoka bunge la seneti ambao la kitaifa ambao walifika mbele ya bunge la seneti kuendelea kaguliwa kuhusiana na hoja yenyewe ya kumbandua naibu wa rais Rigathi Gachagua, na wengi akiwemo Mwengi Mutuse mwenye hoja katika bunge la kitaifa, japo hoja hii kwa wakati huu ni ya bunge la kitaifa kwa pamoja, akiulizwa maswali kuhusiana na baadhi ya yale ambayo yalikuwa yameibuliwa kama mashtaka dhidi ya naibu wa rais Rigathi Gachagua, na wale ambao wengine walitarajiwa kufika akiwemo Masi Wanjau ambaye ni katibu katika baraza la mawaziri, na pia mmoja wa wale ambao walijumuishwa hiyo jana wakikosa kufika siku hii ya leo, na pia mawakili kutoka upande wa naibu wa rais wakitaka kufahamu iweje hawajafika kuweza kuulizwa maswali kuhusiana na ushahidi, kwa lugha ya kizungu wanasema affidavit, ambayo waliwasilisha katika bunge hili la seneti. Ni baadhi ya yale ambayo yaliibua mchakato na yaliibua maswali kutoka kwa upande wa naibu wa rais Rigathi Gachagua wakiongozwa na Paul Muite na vile wakili Ndegwa Njiru kuhusiana na hayo, lakini spika wa bunge hili la seneti akiashiria kwamba ni sawa, lakini baadaye nitakuwa nikiwapa mwelekeo kuhusiana na yale ambayo yametendeka katika hao ambao wako fika. Mwingine ambaye hiyo jana alikuwa kuanzia asubuhi wengi wana matarajio kwamba angefika ni pamoja na gavana wa kaunti hii ya Nairobi, anafahamika kama Johnson Sakaja, lakini pia yeye alituma ushahidi wake pamoja katika bunge lile la kitaifa na hivyo hakuweza kufika. Lakini baadhi ya yale ambayo mpenzi mtazamaji tunafuatilia moja kwa moja katika vikao hivi ni kwamba maseneta wengi hawajatoka nje, hawajaondoka katika vikao hivi, wapo ndani, lakini wachache ambao wameondoka tumepata nafasi kuwaona tu wakiwa wanapita katika maeneo haya. Na mpenzi mtazamaji, moja kwa moja picha ambazo unapokea ni za bunge hili kutoka makao ya bunge kuanzia lango la kikuu. Baadhi ya maseneta ambao walikuwa bado wameondoka ndio wanarejea katika vikao hivi. Na awali tumewaona kama nilivyosema baadhi ya wale ambao ni seneta wachache ambao waliondoka na wengi hawakutaka kuzungumza, isipokuwa tu seneta mmoja ambaye nimezungumza naye, Daniel Manzo, na ambaye ameonekana kukimbia kuelekea kwingine akisema kwamba yupo radhi kwenda kufahamu jinsi ambavyo mambo yanakwenda kabla hajakuja kuzungumza kwa namna yoyote kuhusiana na masuala ya sheria. Na picha ambazo unapokea wakati huu ni za moja kwa moja kwa viongozi mbalimbali wakiondoka katika makao haya ya bunge, lakini kama nilivyosema awali ni kwamba wengi wa maseneta bado wapo ndani katika vikao hivyo, wakitaka ama wakiendelea kujadiliana kuhusiana na yale ambayo yamezungumziwa moja kwa moja.
Naam, shukran sana. Huu ni mwenzangu Liz Mutuku. Sijui kama bado tuko naye. Do we still have Liz on the line? All right, we'll get back to Liz in a short while. That is Liz live from Parliament buildings, just bringing us up to speed on really what transpired between when Senate did adjourn for lunch to 2:30 when they did reconvene to ready to have the side of the defense to take to the stand. That is the Deputy President Rigathi Gachagua's team, whereby the sole witness was the Deputy President Rigathi Gachagua. Dear viewer, if you're just joining us, is to inform you that the Senate has suspended its sittings until 5 p.m. That is later in the evening. This follows whereby it is reported Deputy President Rigathi Gachagua has been hospitalized. This according to his lawyer, Paul Muite, who a few minutes ago informed the House that he had gotten reports that the Deputy President was unwell and requested the House to adjourn until 5 p.m. just to give a clear statement and also a clear happening of what really transpired. Now we now have Liz back on the line. Liz, if you can hear me, maybe just to the benefit of our viewer, if you could bring us up to speed and maybe explain then what happens, because the Deputy President had been allocated 2 hours to put up his defense. This is by the Senate. What happens to these 2 hours that had been allocated to him, noting that 1 hour, the remainder of the 1 hour, he had used to cross-examine the prosecution witnesses? Liz.
Thank you so much, Moige William, for that update from the studio. But I have been camping here in the Senate from morning. I've been following what has been happening since morning. And there is a critical question which you've asked, what exactly happens after the 2 hours? But considering the ruling of Speaker of the Senate, that is Amason Kingi, a few minutes ago, that they still got their time because they've been given at least the 2 hours to deliberate, and we've seen the council from the Deputy President exit the chambers and the gates of the Senate in a bid maybe to go and check the whereabouts of the Deputy President who has been taken ill, and later on they will be able to come back. That is because the Speaker of the Senate, Amason Kingi, has given them that time, and by around 5:30 they should be back in the chambers with information. Remember also, while making his ruling, Speaker Amason Kingi has made it clear that they can still proceed without the Deputy President present in the chambers, and they can also as well have him back in the chambers. But according to Speaker, this is a time-bound process, and therefore they have, by all standards, proceed. But I got an opportunity, Moige, to speak to some of the lawyers, and I will go back to the process of impeachment, and majority of them were referring me to Article 145 of the Constitution in regards to the impeachment of Deputy President and the process. Remember, after the motion has been executed, debated in the National Assembly, the Speaker of National Assembly has 2 days to communicate, and therefore they make a deliberation on whether to go committee way, that is 11-member committee, or even to go plenary way, the way they did. And therefore some of the lawmakers and not lawmakers but senior lawyers are arguing that there is still time, and this also if the deputy president doesn't come back, and in the event they decide to proceed. Some of the arguments I've gotten from lawyers is that he still has lifeline in the courts in regards to this, but we are waiting to see what exactly happens from this from the chambers. That is around 5:30. Remember yesterday as well, Deputy President Rigathi Gachagua was here, and he went for lunch normally around 1:30 after the chambers went on break. And today it was also almost the same thing, because around 1:45, that is when he exited the chambers and the gates of this Senate to go for lunch, and whatever happened is what Senior Counsel Paul Muite, and who is his lead counsel, has communicated to us. I will be following definitely what is happening from the chambers, but as I said, we've seen just a few of senators exiting the chambers and the gates of this Senate, and majority are in there deliberating what happens after this. Moige, back to you.
All right, Liz, indeed you have painted the picture on the happenings of what really happened, and thank you for that, for bringing us up to speed. But before Speaker of the Senate, that is Amason Kingi, did adjourn this particular session until 5 p.m., just to bring you up to speed on how the schedule of the day did look like. This according to the schedule and the program that had been outlined by the Senate. And between 9 a.m. to 9:30, which happened, were the questions / request for clarification by senators. And earlier in the day, we did see a number of senators did pose questions towards the prosecution side, that is the National Assembly, and the defense team, that is the deputy president's side. And these questions and queries were responded to. And between 9:30, according to the schedule that was put out by the Senate, between 9:30 and 10 or 10:35 a.m., there was a continuation, that is evidence by the National Assembly, whereby the evidence of witnesses, if any, cross-examination and re-examination. That is the 20 minutes for the National Assembly and 45 minutes for the Deputy President cross-examination. And dear viewer, in the morning, in this particular segment, we did see that is the former KEMSA boss, that is Andrew Mulwa, who did appear yesterday as a witness, also this morning did appear as a witness, and we saw this continuation of being examined and also being cross-examined. But yesterday, through the lead counsel of Rigathi Gachagua, they did ask that part of their 3 hours which had been allocated to them to prosecute their defense today be donated towards cross-examination. And the Speaker did rule that they be part of their time, that is 1 hour, was being allocated to cross-examination. And today they had been allocated 45 minutes in this particular schedule to do cross-examination. And now between 10:35 to 1 p.m., this was the time that it was allocated for evidence by his, that is the Deputy President, whereby witnesses, if any, and cross-examination. But this did not happen before that, because the Senate did adjourn and break for lunch. And this was to happen this afternoon, whereby Paul Muite, that is the lawyer for Deputy President Rigathi Gachagua, has just told the Senate that his client is unwell, and called on the House to adjourn for until 5 p.m. And we have seen the Speaker of the of the Senate rather did make a ruling that following the consultation between the majority side of the Senate and the minority side that is going to happen, and we expect this House to continue with its business as from 5 p.m. But between 2:30 and 4 p.m., where it was scheduled, where the Deputy President to give his evidence, it was to happen during this time. And between 4 to 5, that was also the senators were to be given some time to do question and request for clarification from the side of the Deputy President. But we can just take a look at what Paul Mwite had to tell the Speaker of the National Assembly and the senators to the situation of the Deputy President. Take a look.
May I start first and foremost by expressing apologies and regrets that the Deputy President is not here, and by not being here, the inconvenience and delay caused to Mheshimiwa Speaker and to honorable senators. The position, Mheshimiwa Speaker, is that during that period that I went to try to find out why he wasn't here, because as Mheshimiwa Speaker knows, the Deputy President has been coming here absolutely punctually every day. The sad reality is that the Deputy President, the Republic of Kenya, has been taken sick, very sick, and as I address Mr. Speaker in this honorable House, senators, he is in hospital, Mheshimiwa Speaker. That is a sad reality.
Right, and you have heard it from lawyer Paul Mwite, quote unquote, stating that sadly, the sad reality, he is in hospital, referring to Deputy President Rigathi Gachagua. That was moments before he was expected, Deputy President, to take to the stand and give his defense and evidence to this particular whole issue. And 11 a motion whereby 11 grounds were leveled against him that was moved by the Member of Parliament from Kibwezi West, that is Mwenge Mutusem. So, if Senate then has adjourned until 5, from what we're having, that is the schedule of the Senate, what is expected to happen once it adjourns, if the President will be present, he will be, the Deputy President rather, if he will make it back, that is if he will make it back to the Senate, he is expected to give evidence, and whereby later on senators will seek clarification or rather ask questions. And after that, what will happen will be the closing statement on behalf of the National Assembly, that they will be given 60 minutes. And after that will be closing statements on behalf of His Excellency, the Deputy President, whereby he had been allocated another 30 minutes. So this is some of the businesses that will take place. This is after the Senate resumes its business. And after that, there will be a 1-hour closed session of the Senate. And after that, there will be the special motion that is on the proposed removal of office by impeachment of His Excellency, the Deputy President, Rigathi Gachagua, Rigathi Gachagua, will be debated by the senators. Later on, final submissions, if there will be any, that is from the side of the Deputy President, and later on the voting process to take place on the 11 charges that had been leveled against him. But quickly, just to give you a reminder on some of these charges that had been leveled against Deputy President in the impeachment motion, whereby a good number of members of Parliament did give the members of Parliament, that is, did vote overwhelmingly to this particular issue. But before I give you the 11 grounds, I'll rather read to you and give you a remainder of the 11 grounds. Let's just take a listen to what the Speaker of the Senate, Amason Kingi, did say before adjourning the Senate.
Please take your seat. Now, honorable senators, we are facing a very unprecedented situation. At the rise of this House at 1:15, I indicated that upon resumption, we were going to hear the Deputy President. Upon resumption, Senior Counsel Paul Mwite, for and on behalf of the Deputy President, when I asked him to usher in the Deputy President for purposes of presenting him to give his evidence in chief, the Senior Counsel indicated that even him, he was unaware of the whereabouts of his client, and he asked for a few minutes to go fetch him wherever he was. After a few minutes, Senior Counsel Paul Mwite came back to the chamber and indicated that he had gotten information which he was yet to verify, that his client had fallen sick, and indicated that he needed time to go look for him in whichever hospital he is, and that he should be given up to 5 p.m. today. The Counsel for the National Assembly, in response, indicated that this is a time-bound process. He referred to the Senate to Rule Rule 11 of our Rules of Procedure, that where the Deputy President fails to appear, the Senate can actually proceed, or for exceptional reasons to be recorded, permit a later appearance before the Senate of the Deputy President. Having considered the two sides, my directions are as follows: that we will suspend this sitting and resume at exactly 5.
All right, that is the Speaker of the Senate earlier on giving directions that the Senate has been suspended until 5 p.m. This is in relation to the recent development that Deputy President has fallen ill and has been hospitalized. Now, allow me to bring in an advocate of the High Court, that is Kevin Sifuna, just to make sense of this development. Kevin, if you can hear me, what does this mean to this whole impeachment process, that the Deputy President has fallen ill and the Senate has suspended its sittings until 5 p.m.?
Okay, well, pertaining that the Deputy President, Rigathi Gachagua, has fallen sick and he cannot be subjected to the impeachment process as we speak, there is what he had done earlier. He had put in his response, which now can be relied with the Senate as his evidence and his defense for the matter to proceed, or for the Senate proceedings to proceed despite his absence. And with the, if you are familiar with the court process, is that maybe if I may use the court process, for example, if you be served with the document or with the summon from the court that you need to appear before this particular court on this particular day, then you opt to appoint an advocate for representation who puts in your defense and also your statement. Then you automatically fail to appear before that particular court. The court will proceed despite you being present. So with the deputy president situation is that the Senate shall proceed with the proceedings despite his absence, and they will only rely on the evidence that has been submitted by the defense, by the deputy president. Then automatically from 5 maybe to 6, the Senate will proceed and do their votes. Then from there, automatically, if any of the allocations, the 11 grounds of impeachment shall say, if one sails through, the deputy president shall automatically cease to hold that particular office. Then the notice shall be forwarded directly to the register of gazettement for gazettement to be done immediately, so that we have a new appointment of the DP. But at the moment, deputy president has only an avenue of proceeding and do an application, if need be, maybe to the High Court, to get some orders that the Senate proceedings should not proceed until his health status is in good condition, so that he can come and be heard. But unfortunately, that also with the Senate standing orders, the Senate only has 7 days to make this particular decision. So we only have today and tomorrow. So Deputy President has no that legal aspect on how to evade this particular situation. It is all about that. No matter what, the Senate proceeding shall proceed, and the verdict shall be made by the Senate, by the senators appending or rather making their votes. So at this moment, whether the deputy president is absent or present, it does not affect any. It will not affect these proceedings. The Senate shall proceed, and they will make a decision, considering that already he had submitted his defense, and he had also availed his document to rely on, so that he used those documents to defend himself.
Sifuna, you have talked about that this does not affect the proceedings, but one would ask then, what of the final outcome? Does this situation affect that?
This situation will not affect. That's why I'm saying that already there is a defense that the deputy president had submitted to the Senate, which is in possession with all senators for verification, and for them also to make a firm decision that indeed, with the documents that have been submitted before this particular Senate, we make a viable decision to really vote, considering that vote to impeach the president or vote not to impeach him, or depending that all the grounds have been tabled, and also the defense team has already represented the deputy president, and they have already submitted the viable documents for reliance. So it won't affect anything.
All right, I hear you, Sifuna. But then the Speaker of the Senate, Amason Kingi, has said that, or rather he has directed that the process will continue as from 5 p.m. Then what changes in the schedule and also the program of the Senate if these situations happen? The Deputy President turns or does not turn up or does not turn up. What happens to the schedule and the timeliness of prosecuting this matter?
I think the Honorable Speaker, Mr. Amason King, has just made he has made a decision to suspend, which also he has that power within the Senate standing orders to temporarily suspend for a certain period. Then they will come from 5, as he has indicated that they will be back from 5 p.m. for them to proceed. So whether the deputy president will be present or not, the Senate shall not be barred not to proceed unless there is a court order directing over the same. But since there is no any application or there is no any court order, maybe stating that the deputy president will not be appearing because of this, and there is this interim orders to stop this particular process until he avails himself. The Senate has no, or as we speak, within their standing orders, they have no objection. They will still proceed despite the deputy president not being present. And I have already indicated that they work within the time frame. So also the Senate has only today and tomorrow. That's why you see they are already now they have already set another time frame of 5 p.m. so that they deal with this issue in its entirety.
All right, Wakili, just to pick your mind also on this, because Deputy President had 2 hours allocated to him for examination and cross-examination, taking into consideration that he had already donated 1 hour for cross-examination on the prosecution witnesses. Then, if this sitting resumes and these 2 hours are still intact, as you say, what happens if the Deputy President does not come back to the Senate?
Okay, that's why I've indicated that you see when there is already a defense on record, the Senate will be at liberty to proceed and rely on what the DP had already submitted for his defense. So whether he has appeared to testify and put more light on what he had indicated as per the court, as per the documents that he has submitted, the Senate shall be all right to proceed and make a verdict. So whether he appears or whether he fails to appear, still the Senate has sufficient grounds to proceed with this particular impeachment process.
Mm-hmm. All right, because
then again,
yes, proceed.
Maybe it is a strategy that the deputy president might be deploying, that he might fight maybe if there is a plan for him to go to the court to allege that now that material time that I was to appear before the Senate, I was unwell and I was under medical attention, so I was not fully heard. But that one, it is under also the court's discretion to also the court has a discretion to agree with such assertions, which most of the court decisions cannot maybe cannot tolerate such a defense, since you had already submitted the sufficient evidence for you to defend yourself. So it won't in any ways affect the impeachment process.
All right. Wakili, what you're trying to put across, if I'm getting you clear, is maybe whatever is happening currently could be more or less of a tact that the deputy president side is trying to use.
Sorry, maybe. Sorry, if you maybe pardon on, so
yes,
that I can clear your question.
If I've gotten you clear from whatever you've said, is that whatever is happening right now could be a tactic that the deputy president could be using to buy time, or rather an avenue to go to the court?
Yeah, it might be, especially that maybe he feels that maybe these are predetermined process that it has already been calculated. So he might be also just to use also what is within the law to at least get another avenue of punching back, or as his punch killers that he might use, so that he comes back lively, saying that, you see, I was ready to appear because in the first process I appeared, but on this particular time I failed to appear, and the reasons that were given by my advocates in the Senate were valid, and they might also produce some documentation to support the same. But ideally now, I have already indicated that it is now upon the High Court to determine whether the reasons given by the petitioner, or rather by the DP, is really convincing, and it has a threshold to really uphold the same. But that one we leave it to the court for if there will be such an application.
All right, Wakili. Also, Wakili, yes, something interesting that has come up. Before the Speaker of the Senate gave a ruling on adjourning the House, he did say that before making that decision, he needs to consult both the majority side and the minority side. Why was this important?
It was important because you see such a process. These are special motion, which has never been seen maybe or practiced within our country. So it is a test of our constitution, and it is something that maybe the Speaker have never been associated with. So there was a lot of there was need for him to consult for that to happen, because also his worry maybe could have been the issue of time frame, considering that now the deputy president has failed to appear. What is the legal aspect concerning such an issue? But majority of the opinion that maybe there is a lacuna, but it is something that in court it happens. Once you file your documentation, whether you are present or not, the court can proceed and make a judgment. So in this particular situation also, the Senate can proceed and make a verdict. But it was prudent for him to consult, because they are dealing with a very sensitive special motion that it has never been evident across the country.
All right, Wakili, you are an advocate of the High Court. So matters law, you are conversant to them. The situation being as is, what is the best option out of this case for Deputy President Rigathi Gachagua?
Politically, if we look at the provision of the law, if you are duly impeached by the Senate, you have not the capacity to hold any public office, and that one, considering that our Deputy President is a leader who is respected across the country, his opinion, or is the best option he could have done, is to maybe to resign before this particular vote is done by the Senate. If he resigns, he has a political future, and he can come back. He can bounce back by 2027 with a lot of support from the Kenyan people to support. And also, you see, with the Kenyans, mostly they vote with the issue of, you see, you have punished Kenyans have mercy. Majority have mercy to feel that it was not what maybe what the deputy president is being. This process is not what it was to be subject to the deputy president.
Wakili, if I may interject, because you have talked about resigning. At this point, is that option available?
At this moment, you see, within the law, it is not closed. They say that the deputy president can resign at any moment, any time, once he writes a notification to the president. So it was not closed. So you might rather say that this particular constitution was not that much strict with some issues. We didn't oversee.
So what you're saying is the deputy president, as of now, has the option to resign.
If he feels, because he still have maybe ambitions to be a leader, he has that option. Although within the law also, he might be barred for that particular action, considering that this procedure has already been laid. But also, you can argue that the same provision or an option of resigning was not that much restricted. That once the impeachment motion has been laid, you can no longer now run away from it. So that is where, if you keenly read it, you might note that there is a back and forth battle that has never been addressed. All right.
Wakili,
yes.
I hear you, but the deputy president, since the onset of this whole process, he was clear on this matter of resigning. That being the case, what is the best option for him as of now? Because time is ticking.
Politically, people make. I think the DP has his own advisors, and he will make an affirmation after maybe getting to understand whether this is a predetermined thing, and he might opt to resign so that he bounces back as a next candidate for presidency. So things might happen before the time that they have allocated from 5 p.m. maybe we can get another breaking news considering his silence or why he failed to appear in the Senate for cross-examination. But that one is upon him to make that particular decision.
So all you're saying, between now and 5 p.m., it is a crucial time and the country should expect anything out of this whole situation.
Yeah, exactly. Because as we speak, the country does not understand whether the issue that has been raised by Senior Counsel Paul Mwite is really something that is authentic and verified. So by 5 we can see some good news, or we can see something different, depending that politics in Kenya is always evolving, and things might turn anytime that we as the Kenyan people cannot expect.
All right.
Because the formation of this government, since it was formed, we had a lot of back and forth, but ideally, you see, we have a broad-based government. So anything can happen, as I said. Anything can happen at any time.
But one would ask, because anything can happen, and we expect the Senate to get back to its normal sittings due to these proceedings. But one would ask, will it be fair for the Senate, because you have said the Senate will continue with or without the Deputy President, to vote and make a ruling on the 11 grounds leveled against him without hearing from him? In as much as we are talking about this process is time-bound.
Well, as I have indicated, is that once you be served with any document requiring you to appear for you to defend yourself, then automatically you fail to appear. At times it weakens your defense. At times already it is a way that maybe you are admitting that what is alleged, it is what is true. But all this impeachment process will be interpreted if maybe the Deputy President, if he is going to be impeached, for example, he can challenge the same decision in the High Court, and we shall get to understand whether the threshold of impeachment was reached or was arrived by the Senate. So all this process is a process that can be interpreted by the High Court. But politically, by 5 we might see some changes that we don't expect.
Okay. Wakili, just stay on the line. I'll get back to you just in a short while, just to bring up to speed our viewer. Just if you're joining us at this moment, is to bring you up to speed that the Senate has suspended its sittings. This is during the impeachment motion process of Deputy President Rigathi Gachagua. This is after his lawyer reported to the Senate that his client had fallen ill. It is reported Deputy President is currently hospitalized, and Paul Mwite had requested for 2 hours to locate and also find the situation of the Deputy President Rigathi Gachagua. Rigathi Gachagua was expected this afternoon to take the stand as this evidence in chief of the defense team, noting that this process had been taking place since yesterday, and today was the day of the defense. And the examination and cross-examination was to take place. Wakili, getting back to you, because before Paul Mwite broke the news to the Speaker and the Senate, he had brought an argument about some affidavits. Remember, in the list of the witnesses, we expected, or rather, National Assembly had listed Mercy Wanjau, Secretary to the Cabinet, Johnson Sakaja, that is the Governor of Nairobi, and Peterson Jomo, a businessman, to appear as part of the prosecution witness. But they did fail to appear. And the three of them had sworn an affidavit which had been included in the bundle of documents presented to the National Assembly, to the Senate, as part of the National Assembly's evidence towards President Rigathi Gachagua. What do you make of that argument?
Okay, well, some of the evidence or some of the witness statements or affidavits sworn might be dispensed off or dispensed. They might be struck out, considering that And that one is agreeable if both parties agree that we don't need maybe Sifuna to appear before this honorable Senate to really prove what he indicated as per the witness statement. But with those affidavits, I think it was struck out. That's why it was not relied on. They were not maybe summoned to appear. So it is also a discretion that the Senate has, and also some of majority of in court. It is something that if you don't need a certain witness, you just dispense of, then it automatically what he had written cannot be relied by the courts or by the Senate to make a determination. Mm-hmm. So I think once they have failed to appear, their witness statements, their affidavits won't be used by the Senate for arriving to a just decision considering or concerning this particular impeachment process. So for them to fail to appear it is not something that can also damage the case.
All right.
It was in support of the impeachment, but since they have failed to appear, it means that they had no serious evidence to adduce before the Senate, and there was no need for them now to appear.
Mm-hmm.
Yes.
That being the case, as you say, Wakili, and remember some of the argument that Paul Mwite, representing Rigathi Gachagua, was calling for. He wanted, for example, Nairobi governor's affidavit to be expunged from that particular matter. Will this apply when it comes to Deputy President if he does not appear before the Senate?
No, because you see, for the Deputy President, it is the one that is accused. Mm-hmm. Is the one that is accused, and what he has put in defense is the one to be relied on. So for him, he must what he has submitted must be considered. But for a witness, if a witness, for example, I can give an example that, for example, if you file a suit in court, then you expect that you have your witnesses around 3 of them, then one fails. You are at a discretion to expand that witness statement so that it won't be used. So it is within the law that Deputy President must be his document must be verified, must be considered by the Senate for them to arrive at a just decision when they will be casting their votes. Mm-hmm. So for that one, there is an exception that for a witness just to appear to testify on that material day, when he fails or she fails to appear in court, then you as the petitioner or you as the complainant, you make a decision that, Your Honor, I do not intend to use this particular witness statement for this particular witness. That witness statement will be expunged out and it won't be used. But for the defense, once you put a defense, that is it. Whether you are present or not, your document shall be considered when the verdict is being deliberated or is being drafted for delivery.
Yes, okay. We still have Wakili Sifuna on the line. And Wakili, you have, one of our viewer might question, why do you keep saying the High Court, and also you're comparing the High Court and the process which is currently taking place in Senate? Why so? To the benefit of our viewer.
Sorry, maybe if you pardon?
Yes, Wakili, if you can hear me, I'm asking to the benefit of our viewer, because I've heard you mention quite a number of times the High Court. You're comparing this process of the Senate together with the High Court. And a viewer might ask, why the comparison? Why the Senate and the High Court and not the Supreme or rather the Court of Appeal?
Okay, I do the comparison because what the Senate is dealing with, it is something that it is entirely deals with the rights, human rights, specifically the right, whether the rights of Honorable Deputy President will be subjected to a fair hearing or a fair. It is like Senate is dealing with something that we call administrative issues. So what they will be dealing with all along will be subjected to the court that has the jurisdiction to hear such issues matters affecting the human rights is the High Court. That's why I do the comparison. So the Senate should ensure that all the grounds laid that they have deliberated on have the threshold to be considered with the High Court, that indeed where the Senate made a justice or it made a verdict, considering that this verdict was within the threshold of impeachment. Then the only court that has a jurisdiction to entertain such issues or such cases is the High Court. That's why I'm doing that comparison. Okay.
That is clear. Now we have approximately 17 minutes till 5 p.m. The House will get back to its business. What are some of the options, or likely what is to play out at that moment when the House returns?
What
is likely to play out once the House returns to its business at 5 p.m. because it's approximately 17 minutes before they return to business?
I think they are just coming to deliberate on the final stages. Then they will also maybe proceed and admit the defense that was, or the reply that was submitted by Deputy President. Then from there they will proceed maybe to cast their votes, whether they agree that the grounds really fit the threshold of impeaching the Deputy President. Those are the only things that are remaining, to confirm and to admit the defense or the reply by the Deputy President because he's absent. Then they will proceed and cast their votes, considering as per the grounds laid.
All right. Basically, so what you're saying is this process will stick to its time bound.
I don't know because sorry.
Wakili, can you hear me?
Yes, I can. Yeah.
Yes. So what I'm asking is basically what you're saying in a nutshell is the Senate will stick to the time bound of this whole process.
Yeah, exactly. Because also, as I have indicated, that the Senate always have 7 days when they receive a special motion. They have 7 days to deliberate and make a verdict. And as we speak, we only have now we only have today and tomorrow for the 7 days to complete. And this process, as we speak, I think it will end today. Then tomorrow it will be the issue of if they impeach the Deputy President. Tomorrow, what will happen is to have a gazette notice, notifying the Kenyan people and the world that Deputy President, the Deputy President Rigathi has been impeached and is no longer holding the office of the Deputy President of Kenya. Yeah, so that is basically what will happen if he is impeached today.
All right. Wakili, something interesting is coming up here. Let me just read it to you. That is Rule 11 of the Rules of Procedure for the Removal of Deputy President. At the tail end, it says, and I quote, but that is... Let me read the whole section in whole, whereby Rule 11 of the Rules of Procedure for the Removal of a Deputy President or a President by impeachment, but in this case, the Deputy President, where the National Assembly or the President chooses not to appear before the Senate, that fact shall be put on record and the Senate shall proceed with its investigations without further reference to the National Assembly or the President, in this case, the Deputy President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the National Assembly or the Deputy President. Basically, what is this whole rule of procedure trying to put across?
Okay, considering with the section that you have read, it gives a light, or it gives an avenue of having a review of the process. But now, because of the time frame that is within the standing orders of the Senate, I think they will not have that time to entertain issue of second appearance.
All right. Thank you.
As time is of essence.
All right. Thank you so much. There is Wakili Sifuna, an advocate of the High Court. Kevin Sifuna, an advocate of the High Court. Thank you so much, Wakili, for your time as you try to make sense of this whole situation. All right, just to bring you up to speed once again, the Senate has suspended its sittings. This is after the lawyer to Deputy President Rigathi Gachagua did inform the House that he is reportedly in hospital, or rather had fallen sick. And that particular matter did brought to the attention of the Speaker. The Speaker, in consultation with the minority and the majority side, did opt to adjourn the sittings of the Senate until 5 p.m. It is now exactly 4:48, 12 minutes to 5 p.m. before the Senate resumes to its sittings. But if Manu, my director, could just play, we play you a clip earlier on of what Paul Mwite, the lawyer to Deputy President Rigathi Gachagua, did tell the House, but I'm told we'll play that clip for you in a few. But to bring you up to speed also on this particular whole process, it was expected that Deputy President Rigathi Gachagua was set to appear before the Senate for cross-examination and also examination in the impeachment motion against him, whereby Member of Parliament Mwenge Mutuse had leveled 11 grounds seeking the removal from office through way of impeachment for Deputy President Rigathi Gachagua. But this did not happen, and we're expecting this process to get back on the road at 5 p.m. But let us get to listen to what the lead counsel for the National Assembly, that is Governor for Siaya, James Orengo, had to say about this whole issue before the House adjourned.
A wise men and women.
Speaker, can I just say a word?
Yes.
I've heard what Senior Counsel Paul Mwite has said. And Mr. Speaker, you have made it quite clear that these proceedings are time-bound. It's not so much about the situation in which His Excellency the Vice President finds himself. It's about the Senate complying with the provisions of the Constitution. That within that time frame, you must make a decision. Reading the standing orders that my learned friend, Mr. Rick Gumbo, has referred to, it would be useful to this House if Senior Counsel Paul Mwite could probably give us a way forward in terms of the time limitation that the Senate has. I'm saying this because we don't want somebody to say that the Deputy President was not given an opportunity to be heard. I think the Senate will want him to be heard. But knowing the time limitation, what suggestions does the Senior Counsel have to ensure that we keep within the time parameters? At the same time, the Deputy President is given his space to defend himself.
So we have two sides. We have the minority side and the majority side. I will only allow.
All right, that is the lead counsel for the National Assembly and also the governor for Siaya, that is James Orengo, calling on the Speaker of the Senate, Amason Kingi, on matters adjourning the House. Remember, this was following the revealing by Paul Mwite that the Deputy President had fallen ill and needed immediate attention. And the Speaker, through consultation of the majority side and the minority side, stating that the House had been adjourned until 5 p.m. And now it is 8 minutes. We're expecting to see this process getting back on the road. But remember, Gachagua indeed was scheduled to deliver his statement and undergo cross-examination, that is through the lawyers representing the National Assembly were to cross-examine him this afternoon. And you can see live pictures from your screen. Those are live pictures from Parliament buildings. But through Paul Mwite, and I quote whatever his verbatim to the Speaker of the Senate and also to the senators, where he did say, quote unquote, apologies and regrets that the Deputy President is not here, and the inconveniences and delays caused to the Speaker and the Senate. And also that the position is that during the period that we went as I tried to find out why he's not here, the sad reality is that the Deputy President has been taken sick and is in hospital. That is the verbatim of Paul Mwite. And he did request that they be accorded until 5 p.m. so that they can report back about their clients' status, their clients in this situation being a Deputy President Rigathi Gachagua. However, we had the argument of that is the National Assembly's lead counsel, James Orengo, stating that indeed this process is time-bound and it is expected to come to an end tomorrow. All right, if we can turn to the screens, just some of the live pictures are coming live from Parliament buildings. Some of the councils representing Deputy President Rigathi Gachagua. I can see one familiar face, that is of Advocate Ndegwa Njiro, making their way to the Senate. And also together with him is other advocates who are representing Deputy President. Remember, any moment from now, or rather not any moment, in 6 minutes, this process should continue. It is the impeachment motion of Deputy President Rigathi Gachagua. So indeed, the Speaker did opt to suspend the sittings until 5 p.m., but noted that this process is time-bound. Live pictures from outside Parliament buildings. I can see Wakili Tom Masharia, among others, Ndegwa Njiro. They have just entered the gate of the Senate. 5 minutes till the resumption of the sittings of the National Assembly, of the Senate rather. I beg your pardon for that. And this was occasioned after Paul Mwite, representing Deputy President, did inform the House through the Senate Speaker Amason Kingi that Deputy President Rigathi Gachagua was taken to the hospital during the lunch break, that is of his impeachment trial today on Thursday, the 17th of October. Deputy President was expected to take the stand to be examined and cross-examined by the lawyers led by lead counsel James Orengo, representing the National Assembly, on this impeachment trial. And Gachagua, through the lawyer, Gachagua did explain that he had fallen ill and needed medical attention, and the Speaker did grant the request by lawyer for Gachagua, Paul Mwite, that the sittings be adjourned until 5 p.m. And the clock has been ticking since then. We expect to hear from Gachagua's side through the lead counsels, through the counsels on what really had taken place and the situation. All right, currently we have, who do we have? All right, we have Kennedy Chesa, just to help us make sense of this whole situation. Chesa, welcome on board. Just what do you make of this situation that has transpired?
Thank you very much. What has transpired is a normal situation in any trial. Why am I calling it normal? Because the account of sickness is natural. You cannot determine when to become sick. And because a deputy president became sick during the impeachment process, should not send any bad signal. It is a normal thing, and we're expecting that at 5 p.m., the advocate for the deputy president will either produce him and say he has now been cured and is well, or they'll be seeking an adjournment to be given another time to appear so that they can present the accused person before he can make his own defense.
HSA, you're talking about adjournment, but clearly we did hear from the Speaker of the Senate stating that this whole process is time-bound. And talking of timeliness, it is set to come to an end tomorrow. Then what happens if Deputy President Rigathi Gachagua seeks for an adjournment?
You see, the Speaker is an adult of sound mind, just like me and you. The Speaker should take the Constitution and read Article 145. Article 145 provides the procedure and the process for the removal of a president or deputy president by way of impeachment. And the time frame anticipated, if you read carefully, is about 17 days. Because it says that once a deputy president has been impeached by the National Assembly, the Speaker of the National Assembly shall within 2 days communicate to the Speaker of the Senate. The Speaker of the Senate, having gotten the communication, shall have 7 days within which the Senate will make a resolution either to try the Deputy President by way of appointing a special committee of 11 members to carry out investigations on the charges and advise the plenary of the Senate. Or they can go the plenary way. If they were to choose the committee way, the committee will have 10 days as per the Article 145. So that alone will give you 17 days within which you can do the impeachment process at the Senate level. So which timeline is the Speaker talking about? There are no timelines. The timelines we are seeing from the Senate is a creature of the House Business Committee, which drafted the itinerary for the impeachment of a deputy president. Those are Senate resolutions, and Senate can vacate its resolution when circumstances change. So the Speaker should not talk about timelines. There are no timelines in the Constitution. What exists as a timeline is what is created by the Senate by dint of its standing order.
Well, indeed, you're bringing in quite a complex argument into this whole issue. But the situation being as is, we had the Deputy President being allocated 2 hours to being examined and also cross-examined as he puts up his defense to this whole impeachment process. Then what happens to these 2 hours, to the benefit of our viewer, if he fails to appear or appears?
If he fails to appear, what the Senate should do is to ask for reasons. If they are told that he is unwell, they should simply ask for documentation. And documentation, again, you may not get it as a matter of urgency. Documentation may be required perhaps at the time of discharge or once he has been diagnosed. So the only plausible thing to do once Rigathi has failed to appear at 5 p.m. is to adjourn the Senate. But remember that impeachment is a political process. It is being driven from a political will. And therefore, the senators may ignore the provisions of the rules of natural justice and the rules of fair trial and proceed with the impeachment. In that way, they will assume that Gachagua has failed to turn up. He has not given any plausible reason. They'll close the defense case and they'll go in for voting. Remember that the right to fair trial under our Article 25 of the Constitution is a non-derogable right. It's a right you cannot limit, be it the court, be it the Senate, be it the state. That is a right that should not and cannot be limited.
All right, just stay on the line. Dear viewer, just those are live pictures inside the Senate. Remember, the Senate was to resume its sittings at exactly 5 p.m. What you can see are senators streaming in. But earlier on, we did give you live pictures of a section of lawyers representing Deputy President Rigathi Gachagua making their way into the Senate. Among them was Ndegwa Njiro. We had seen Tom Masharia. We had seen also Elisha Ongaya, some of the lawyers representing Deputy President Rigathi Gachagua in this whole impeachment motion. We still on the line. We have you, and if all right, yes, I've gotten the name. Still on the line, we have Kennedy Echesa. I had forgotten the name, but in this whole issue, and we're expecting any minute from now, the Senate will resume, and there were a number of a bundle of documents and papers that had been presented to the Senate in relation to the defense of the Deputy President. And we had talked about the possibility of the Deputy President not appearing before the Senate. What then does it mean for whatever materials Deputy President Rigathi Gachagua had submitted to the Senate?
You know, in a criminal trial, there is something called cross-examination. When you provide evidence on oath, that evidence must be tested. How is this evidence tested? It is tested through cross-examination. You have said this, a person cross-examines you, the adverse party cross-examines you. That is why the Deputy President ought to be in Senate so that he can be cross-examined to test his own evidence, to test the veracity of his evidence. In his absence, you will not cross-examine him. In his absence, even if you will proceed with the trial, the materials, the huge materials that have been brought to the Senate will be of little probative value and will not add to his case that much. And I'm even sure that once an adjournment is refused, the lawyers will not present themselves. The lawyers cannot sufficiently present this defense because they cannot be cross-examined. They are not the ones who swore the affidavit. They are not the ones who produced the documents that have been produced. So in the absence of Rigathi Gachagua, it becomes very difficult.
All right, Kennedy. Let me just cut you short because we're having the Speaker of the Senate addressing senators. Let us cross over to the Senate and listen to Amason Kingi.
That we may proceed with these proceedings. Senior Counsel Paul Mwite, you may now inform the House so that we proceed.
Mheshimiwa Speaker, through you, I would like to inform honorable senators that I've been able to contact the doctors at Karen Hospital. There are a number of doctors, a team of doctors who are looking after the Deputy President. Because of his condition, I was not able to directly talk to him on the advice of his doctors. He said he must have complete rest for the time being. I was, however, informed by his doctors that he is currently suffering intense chest pains. I did not want to inquire beyond that, Mheshimiwa Speaker. But just in order to perhaps save the time of this Honorable House, let me, as I sit down, invite Mr. Speaker and the House to look at Article 145 of the Constitution, sub-Article 6. Mheshimiwa Speaker, sub-Article 6 of Article 145 says, if the special committee reports that the particulars of any allegation against the President, of course it applies for the Deputy President. If you go to B, have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. Mheshimiwa Speaker, we are aware that this Honorable Senate made a decision to hear the charges in plenary, so that what we are doing in these proceedings, I would suggest and submit we are proceeding under sabbatical 6B. And under sabbatical 6B, this House, by the Constitution, is obligated to accord the Deputy President an opportunity to be heard, which is why Rule 11 of the standing orders of this House specifically provides, Rule 11, where the National Assembly or the President chooses not to appear. And I would like to submit that the Deputy President has not chosen not to appear. The choice of the language chooses to appear in Standing Order number 11 is to be read with the Constitution Article 145, Sabbatical 6, which obligates this Honorable Senate to accord the Deputy President an opportunity to be heard. So I do leave the matter in your hands, Mr. Mheshimiwa Speaker and Honorable Senators. I would suggest Article 145, the sabbatical, I've read sabbatical 6B, doesn't have a time limit of 10 days. Give the Deputy President, in the interest of justice, given the weight of removing a Deputy President from office, give him a couple of days. I thank you.
So if I get you correctly, Senior Counsel Paul Mwite, it is your application to the Senate that your client be given a couple of days. Now, a couple of days doesn't mean much.
That is the application. What I had in mind, I would add the word humbly requests Mheshimiwa Speaker and this Honorable House, the Senate, a couple of days I had in mind up to Tuesday. We should be able to know when the Deputy President is able to come and defend himself. I thank you.
Counsel for the National Assembly.
Mr. Speaker, sir, permit me to start by registering our greatest sympathies and empathies and from the team, the National Assembly. Of course, issues to do with health are issues that are beyond our control. Mr. Speaker, sir, that said, we also would want to be cognizant of the fact that we are dealing with a constitutional moment. We are dealing with an item whose timelines are prescribed within our Constitution. Mr. Speaker, sir, contrary to what learned Senior Counsel, Mr. Paul Mwite, would want to persuade this House to believe, the proceedings before this House have not been the subject or have not been transacted pursuant to Article 145(6). Mr. Speaker, sir, on the 9th of October this year, this House did pass a resolution pursuant to the provisions of Article 145(3). Mr. Speaker, sir, pursuant to that resolution, there was a Gazette notice which very clearly indicates that this House was not going to determine that the matter at hand from a committee perspective, but that the whole House would then be determining the matter. It then follows, Mr. Speaker, sir, that the provisions of Article 145(6) would not be applicable. Mr. Speaker, sir, in the same Gazette notice, you did gazette the 16th and 17th of October to be the days assigned for the hearing and determination of the motion that is before you. That said, Mr. Speaker, sir, we appreciate the place of fair hearing and an opportunity to be accorded the chance and the facilities to be able to defend one's self in a motion such as this. Mr. Speaker, I would want to add that the opportunity to be heard does not have to be oral. The rules of this House permit that parties appearing could elect to be represented, they could elect to come in person, they could file documents. Mr. Speaker, sir, His Excellency the Deputy President has participated robustly in the proceedings, both before the National Assembly, where they filed a very, very detailed replying affidavit and a response. Mr. Speaker, sir, if my memory serves me right, let me just make a quick reference. Before the National Assembly, His Excellency the President did file a response dated the 8th of October 2024. When the proceedings before this House began, His Excellency the President, the Deputy President again filed a very robust response dated the 12th of October 2024. Mr. Speaker, sir, up to this point in time, His Excellency the Deputy President, together with his team, have had a beautiful opportunity to present their case. They have had an opportunity to cross-examine in great detail all the witnesses that we presented before this House. If anything, Mr. Speaker, sir, if any prejudice were to be occasioned in the course of this, hearing this matter, that prejudice would be on us, because our expectation would be that His Excellency the President would be able to attend and avail an opportunity for the National Assembly to cross-examine him. Mr. Speaker, sir, taking into account the circumstances that we find ourselves in, having also very keenly heard learned senior counsel speak, matters held are not matters to be taken lightly. On the same tone, Mr. Speaker, sir, matters held cannot be given timelines. There cannot be certainty that if an adjournment were to be given even for 1 week, then there is clarity and certainty that we'll be able to proceed on that assigned day. Mr. Speaker, sir, we would urge that we borrow practice that has accorded to other similar organs created by the Constitution. I have the courts of law in mind. Mr. Speaker, sir, because I earlier on submitted that Article 50 provides for an opportunity, provides for the right to fair hearing, and that fair hearing does not necessarily have to be oral, we have had practice in our Supreme Court where dealing with some of the most important decisions of our lifetimes, including decisions arising from presidential elections, have, in all the elections that we have had parties file submissions and their documents, and that their advocates have had an opportunity to appear before the courts to highlight those documents and pleadings that have been filed. In this occasion, because His Excellency the Deputy President has had an opportunity to present all the material that he ought to or he wanted to present, and also had the opportunity to cross-examine all the witnesses that he wanted to cross-examine, all that is left on their side is highlighting. on our part, Mr. Speaker, sir, the part of the National Assembly, so that then we are able to give progress to this matter. We are willing to take the painful decision to forgo the cross-examination of His Excellency the Deputy President and only proceed with highlighting submissions in relation to the documents that we have filed before this House. It is our humble view that no prejudice would have been occasioned to His Excellency the Deputy President. Mr. Speaker, sir, we urge that if I heard my learned senior colleague, Mr. Paul Mwite, Senior Counsel, well, he seemed to have been imploring this House to consider adjourning. Mr. Speaker, sir, let me end by drawing the attention of this court to Rule 12 of the proceedings, the rules governing the proceedings currently underway. Mr. Speaker, sir, Rule 12 of those rules dictates that once the hearing has commenced, it shall proceed up to the end. It does not provide for an option for the House to adjourn. If that is the dictate, Mr. Speaker, sir, of the rules governing the proceedings before this House, we urge that being a country, being an organ of a constitution that is that is controlled by the rule of law and the Constitution, you direct that we proceed with the hearing as had been planned. I am most obliged. Mr. Speaker, sir, just before I leave the ground, maybe I would want to invite my leader, Mr. Honorable James Orengo, Senior Counsel, to also just add one word before you give your directions. I'm most obliged.
Mr. Speaker, just briefly, in these proceedings, we are governed by Article 145. And there is a very unique provision in Article 145 that you don't find in legislations to do with even litigation in the courts. But because the makers of this constitution knew that these proceedings are time-bound, there is under Article 145, Subarticle 5, a very important provision. And I think that article is not there for cosmetic value. That article is there to deal with a situation like we find ourselves in, because the makers of this constitution knew that when processes are time-bound, there must be a safety valve. Article 145, Subarticle 5, which applies mutatis mutandis in relation to the removal from office by way of impeachment of the Deputy President, states as follows. The President, and for that matter, it should be read, the Deputy President, shall they have the right to appear and be represented before the special committee during its investigation. Now, the point that I want to make, that not in a lot of legislation you find the right to be represented highlighted, because the Deputy President can elect to be represented either by his advocate or by him appearing in person, or having both the Deputy President and his advocate to appear. Now, I want to put before the Senate, because a lot of you have this problem a lot of time during the elections. If, in accordance with the election law, you are required to subscribe your nomination papers on a certain day, and you fail it, you're running for president or deputy president, and you're told that you must present your nomination papers on a certain day, as it is there in the law, would you feign sickness and fail to represent your nomination papers on that particular day? And I can tell you, if you fail to do so, the law will not give you any accommodation. You'll be out, and there are a lot of decisions on this matter. I want to talk to this Senate very frankly, that Senior Counsel Mwite was basically giving evidence. He has not told us where, or if he has told us, the medical institution where the Deputy President is. But for the Deputy President to fail to bring evidence, credible evidence before the House that has been admitted, even that evidence that has been admitted to a medical institution, we don't have it. We will rely on the evidence from my senior counsel, Paul Mwite. That is evidence. But in practice, I can say without a fear of contradiction, there are many times where people are represented even in medical documents, and later on they've been found to be fake, if I may use that word. I think that the Deputy President should have done, we should have had one of the doctors here, at least to tell us about his admission and about his condition, because up to 1:15, the Deputy President was here. He was not evacuated from here in an ambulance. And if I can give evidence from the bar, he went to his office, and again, there's no evidence that he was evacuated in an ambulance. He went to Karen Hospital in himself to check at the hospital. So I think our constitutional duty is to live by what the Constitution requires of us. The greatest prejudice, for me, I was looking forward to cross-examine the Deputy President. But unfortunately, the story that has been told does not include cross-examination of the evidence of the Deputy President, which is on record. But because we are time-bound, and as my London friend Eric Gumba said, we are prepared to go by the evidence in record. The prejudice is to us. The sickness of the Deputy President is affecting us more because we would want to cross-examine him, but he has evidence in record which we cannot test by the way of cross-examination. And there's no assurance that on Tuesday, the Deputy President would be here. Finally, we can also say from here that there are many cases that have been filed all over, including in Malindi today, that has to do with the proceedings that are going on here. So I am in a position to say that this health condition in which the Deputy President is, and I sympathize, may be opportunistic in the absence of medical evidence from a doctor. It may be opportunistic. And I saw him when he came in. I'm not a doctor, but there was nothing to suggest that he was in the condition that Honorable Counsel has been talking about. So do the senators now turn into a jury to make a decision on the basis of evidence presented from the bar by senior counsel without no documentary proof of where the Deputy President is and what ailments is suffering for? I think the more important duty for this Senate is to comply with the Constitution. And we urge you to comply with the Constitution and proceed with the hearing of this impeachment proceedings. Thank you.
Senior Counsel Paul Mwite.
Mheshimiwa Speaker, honorable senators, we all live in Kenya, and I would like to make this submission. These gadgets we have here capture every word uttered accurately, so that if I was found tomorrow to have lied to these senators, sanctions can be brought on me. And I would have thought that that fear of telling a lie to this honorable Senate, to me, is more powerful than even bringing a medical report. We've had many medical reports generated outside hospitals. We see them in courts almost on a daily basis. Mheshimiwa Speaker, you will remember the rush that was there when I was asking to be given up to 5 p.m. And it was a rush. Was I to fail to come back to this honorable house at 5 p.m., waiting for a medical report when the doctors there are busy attending to their patient, the deputy president? Medical reports I can bring. If I've told lies, that is something that can be established. And my learned friend, Mheshimiwa Honorable Orengo, talks about giving evidence from the bar. When I was learning, they are seated down when he's giving evidence from the bar about some cases filed in Malindi that I'm not aware of. Perhaps he should have given us a copy of that. Mheshimiwa Speaker, Article 145, Sub-Article 6 is clear, and I do not want to take time of this august House, Senate. Going back to it, it applies, and I would plead with you and with honorable senators to give us until Tuesday to see whether the deputy president will be well enough. No one decides when to get sick and when not to get sick. I am sure many honorable senators here will have a story of their shock because of having spent an evening with somebody, then the following day they hear that the person is gone. Yet that person was looking good and healthy. Let's be humane. Let's be compassionate. Tuwe na utu kidogo. Tuesday, the heavens are not falling down to join with the earth. I thank you, Mheshimiwa Speaker.
Senior Counsel, Paul Mwite. There is a hypothetical question that was raised by Senior Counsel Orengo. Assuming, and it's just an assumption, assuming the Senate is inclined to grant your client up to Tuesday, and by Tuesday, your client is unable to attend Senate, what then will be the way forward?
Mheshimiwa Speaker, I would submit the best thing is for this honorable House, honorable Senate, to make a decision on facts rather than assuming what may or may not happen. Point number one. Point number two, Mheshimiwa Speaker, is the importance of honorable senators seeing with their own eyes how a witness withstands cross-examination. There are many times when different impressions you'll be given by a written document. And yet, when cross-examination takes place, individuals change their minds. One can only make a decision on whether this witness is believable or not believable when they see his demeanor in person. So there's nothing to replace orality through cross-examination. There are many witnesses whose statements will be impressive, and yet when they begin to give evidence orally, that impression changes completely on the mind of the jury. The Deputy President wishes to subject himself to cross-examination, wishes under oath to deal with the evidence given adverse to him by witnesses here, so that honorable senators can have an opportunity of making a decision. Is it the Deputy President we shall believe, or is it those other witnesses? That opportunity can only come through orality and through cross-examination. So what this House elects to do, that decision, this House, Mheshimiwa Speaker, they will make on Tuesday. I am always an optimist. So I am living in the belief that the doctors may be able to put whatever is wrong with the Deputy President back in place so that he can be here on Tuesday, Mr. Speaker. Yeah, let that decision of what this Honorable Senate will then do be made on Tuesday. That is a humane way of going about a matter about no one had control of. I thank you.
Now, honorable senators, having listened to the counsel for the Deputy President, as well as the counsel for the National Assembly, I need to consider those arguments and give my considered ruling in this matter. I will therefore suspend for 5 minutes. 5 minutes. 5 minutes, and I'll be back. Arise.
You are watching live pictures from the floor of the Senate, where the House has briefly adjourned. The Speaker of the Senate is expected to come back and give a ruling on the way forward. The council representing the Deputy President has requested that the team be given until Tuesday so that the Deputy President can be given the opportunity to be heard before the Senate takes a decision on the impeachment motion that was forwarded to the Senate by the National Assembly. The National Assembly, through its council, has submitted to the Senate that the evidence that was adduced by the President in writing has submitted to the Senate that the evidence that was adduced by the Deputy President in writing be considered in this matter. The National Assembly, also through its legal counsel, has also told the Senate that it is willing to forego the cross-examination of the Deputy President, who was to appear as the sole witness in this historic trial in the Senate. The National Assembly did forward to this House 11 grounds of impeachment, which it believes that it has presented enough evidence to warrant the impeachment of the Deputy President. Among the grounds that the National Assembly did advance is the gross violation of Article 10, Sub-Article 2A of the Constitution, and B and C, Article 27, Sub-Article 4, Article 73, Sub-Article 1A, and Article 2B of the Constitution. The National Assembly, in its submission during this trial, did say that the matter of constitutional compliance, the Deputy President of the Republic of Kenya, who is the principal assistant to the President of the Republic of Kenya, is required to promote constitutional core values such as peace and unity of all Kenyans in the context of ethnic, cultural, and religious diversity, patriotism, national unity, rule of law, democracy and participation of the people, equity, social justice, inclusiveness, equality, human rights, non-discrimination and protection of the marginalized, and good governance. To also respect and uphold representation of Kenya's multi-ethnic and culturally diverse society through the promotion of equality and affording equal opportunities to all Kenyans in appointments to the public service and allocation of public resources, and to promote and implement public policy decisions that do not discriminate against any Kenyan based on conscience, ethnic or social origin, language or birth. In its argument, the National Assembly said that on diverse dates throughout the last 2 years, His Excellency the Deputy President has persistently made utterances threatening to discriminate, exclude and unlawfully deny sections of the people of Kenya and regions of the Republic of Kenya equal opportunities for public service appointments and allocation of public resources. Besides, the utterances are highly inflammatory and insightful and significantly undermine national unity and the peaceful coexistence of Kenya's diverse communities. In forwarding its evidence to the Senate for the purpose of this trial, the National Assembly did illustrate instances where it believes the deputy president has been on record committing the said violations. Ground 2, gross violation of Article 147, Sub-Article 1, and Article 152, Sub-Article 1 of the Constitution. The National Assembly states that Article 147, Sub-Article 1 of the Constitution provides that the Deputy President shall be the principal assistant of the President and shall deputize for the President in the execution of the President's functions. In addition, Article 152, Sub-Article 1 of the Constitution states that the Deputy President is a member of the Cabinet. The National Assembly argues that on various dates throughout the last 2 years, His Excellency, the Deputy President, undermined the President and the Cabinet and the effective discharge of the national government's executive mandate by making unilateral public statements that were inconsistent with policy positions collectively adopted by the government. Under this charge, the National Assembly has moved to illustrate instances and occasions in which it deems the Deputy President to have committed this offense. That on or around 30th of April 2024, the Cabinet passed a resolution for the evacuation of people residing along the Nairobi River. Shortly after that, His Excellency, the Deputy President, made a public statement opposing the Nairobi River riparian evacuation orders, which the National Assembly argues that the Cabinet had sanctioned for public safety and climate change mitigation. His Excellency, the Deputy President, made contradictory public statements despite being a member of the Cabinet and being assigned the function of superintending the Nairobi River riparian evacuation order. In addition, the National Assembly argues that His Excellency, the Deputy President, has on several occasions throughout the last 2 years made public statements contradicting the President on critical matters of governance and the exercise of the President's functions as a symbol of national unity. It has also tried to illustrate that in March 2023, at a public forum in the Nyanza region, the President said Kenya belongs to all, notwithstanding how people voted in 2022 general elections, and that he would ensure the government does not discriminate against anyone. However, His Excellency, the Deputy President, speaking after the President at another public forum, contradicted him by saying that Kenya is a company in which the provision of government services is based on shares. That His Excellency, the Deputy President, has made numerous other utterances at public forums where he publicly restates the division narrative that Kenya is a company in which the rights of citizens are based on shares determined by how various ethnic communities voted in the 2022 general election. The National Assembly argues that the Deputy President's unilateral, divisive, and insightful public statements are impeachable offenses to the extent that they undermine the effective discharge of the national government's executive mandate, that they violate the doctrine of collective responsibility, and that they are equivalent to insubordination of the President, which is incompatible with his constitutional status as the principal assistant to the President of the Republic of Kenya. Ground 3, gross violation of Article 6, Sub-Article 2, Article 10, Sub-Article 2A, Article 174, Article 186, Sub-Article 1, Article 189, Sub-Article 1, and the 4th Schedule to the Constitution, this quote-unquote undermining devolution. The National Assembly, in its submission in this trial, argues that Article 10, Subarticle 2A of the Constitution provides that devolution is a fundamental national value and principle of governance. In addition, Article 6, Subarticle 2 of the Constitution provides that government at the county and national levels are distinct and interdependent and shall conduct their mutual relations based on consultation and cooperation. These provisions, the National Assembly argues, that are supplemented by Article 189, Sub-Article 1 of the Constitution, which provides that governments at each level shall perform and exercise their powers in a matter that respects the functional and institutional integrity of government at the other level. Under paragraph 7A of Part 2 of the 4th Schedule to the Constitution, county governments are responsible for trade development and markets as an exclusive function. Moreover, the Deputy President chairs the Intergovernmental Budget and Economic Council, which the National Assembly argues is an essential organ for consultation between the two levels of government. In its submission before the Senate, the National Assembly, through its legal representatives, say that on or around 20th September 2024, His Excellency Rigathi Gachagua, recklessly unmindful of the high calling and dignified status of the office of the Deputy President of the Republic, unlawfully interfered with the running of Nairobi City County Government by holding a public rally in which he incited citizens against lawful directives of the Nairobi City County Government on the planning and the location of markets. Further, the National Assembly argues that His Excellency, the Deputy President, publicly disparaged the leadership of the Nairobi City County Government and its decisions. Moreover, the Deputy President has interfered with the proper discharge of county government's constitutional functions regarding alcohol and control and regulations. His Excellency, the Deputy President's insightful and demeaning public statements and conduct are impeachable offenses to the extent that they undermine devolution. This is according to the submission by the National Assembly, and that they undercut the functional and institutional integrity of county governments. They unjustifiably vilify and ridicule the leadership of county governments, especially the Nairobi City County Government. Consequently, His Excellency Rigathi Gachagua, according to the National Assembly, has grossly violated Article 6, Subarticle 2, Article 10, Subarticle 2A, Article 174, Article 186, Subarticle 1, and Article 189, Subarticle 1 of the Constitution, as read with the 4th Schedule to the Constitution. Ground 4, the National Assembly accuses the Deputy President of gross violation of Article 160, Sub-Article 1 of the Constitution, which talks about the undermining of institutional and decisional independence of judges. In its submission, the National Assembly argues that Article 160, Sub-Article 1 of the be subject only to this Constitution and the law, and shall not be subject to the control or direction of any person or authority. Many international law instruments, treaties, and principles require the guarantee of the judiciary's independence and require all government officers and institutions to respect and observe it. In 2023, His Excellency Rigathi Gachagua, according to the National Assembly, recklessly and mindful of the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, and the need to respect, protect, and uphold the independence of the judiciary, made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition for the removal of the said judge in gross violation of Article 160, Sub-Article 5 of the Constitution. The Honorable Judge, according to the National Assembly, had presided over a case in which His Excellency Rigathi Gachagua was a party and had, in the lawful performance of a judicial function, ordered His Excellency the Deputy President to forfeit to the state the sum of 200 million shillings, which she had found to be proceeds of corruption and money laundering. His Excellency Rigathi Gachagua's public attacks, according to the National Assembly, are impeachable offences to the extent that they undermine the functional and decisional independence of judges. If you're just joining us, these are live pictures from the Senate chambers where the trial has taken a short break. The Speaker has gone to draw a ruling on the way forward for this trial, where the Deputy President has been unable to appear to take to the witness stand. His legal representative, led by Senior Counsel Paul Mwite, has asked the Senate to give the Deputy President until Tuesday next week and thereafter make a decision on the way forward. The National Assembly, through its legal representatives, led by Senior Counsel James Orengo, urged the Senate to consider the evidence that has already been forwarded by the Deputy President. Quoting the law, the National Assembly, through its legal representatives, argued that having forwarded the evidence in writing, there may be no need to have the Deputy President give his account. The team argued that this Senate can make a decision on that, and it is willing to forego the cross-examination of the witness, who is the Deputy President of the Republic of Kenya. So we are waiting for the Speaker to make a ruling on this request by the Council representing the Deputy President. Ground 5 of the that the National Assembly believes is an impeachable offense is the gross violation of Article 3, Sub-Article 1, and Article 148, Sub-Article 5A of the Constitution, which talks about the breach of the oath of office and allegiance. The National Assembly, in impeaching the Deputy President, argued that His Excellency Rigathi Gachagua's actions and utterances outlined in Ground 1, 2, 3, and 4 constitute a gross violation of Article 3, Sub-Article 1 of the Constitution, which requires every person to respect, uphold, and defend the Constitution. Further, the actions and utterances of His Excellency Rigathi Gachagua grossly violate Article 148, Sub-Article 5A of the Constitution, which prescribes the oath of allegiance of the office of the Deputy President that obligates the Deputy President to obey, preserve, protect, and defend the Constitution. There's also serious reasons, according to the National Assembly, to believe that the Deputy President has committed a crime under national law pursuant to Article 150, Sub-Article 1B, Part 2 of the Constitution. Under Ground 6, the National Assembly, in its submission, argues that there's serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Sections 13, Subsection 1A, and Section 62 of the National Cohesion and Integration Act. Section 13 of the National Cohesion and Integration Act provides that it is an offense for any person to use threatening, abusive, or insulting words or behavior where the person intends to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. The section also makes it an offense to use such words or engage in such behavior when having regard to all the circumstances ethnic hatred is likely to be stirred up. The National Assembly argues that besides, Section 62 of the National Cohesion and Integration Act states that a person commits an offense when the person makes statements that are intended or are likely to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. His Excellency Rigathi Gachagua's persistent, inflammatory, reckless, insightful public utterances over the last 2 years, according to the National Assembly, details of which are set out in grounds 1, 2, 3, and 4, establish serious reasons to believe that he has committed crimes under Section 13, subsection 1, and Section 62 of the National Cohesion and Integration Act. Ground 7. Serious reasons to believe that His Excellency Rigathi Gachagua has committed crime under Sections 45, subsection 1, Section 46, Section 47A, Part 3, and Section 48, subsection 1 of the Anti-Corruption and Economic Crimes Act, and Section 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. That for the past 2 years, His Excellency the Deputy President has inexplicably amassed a humongous property portfolio estimated at 5.2 billion shillings, primarily from proceeds of corruption and money laundering. The value of the property and wealth that His Excellency Rigathi Gachagua has acquired, according to the National Assembly, over the last 2 years is incompatible with his non-legitimate income, that is 12 million shillings per annum or thereabouts. That His Excellency Rigathi Gachagua has acquired the above-mentioned property and wealth using his 2 sons, Kevin Rigathi Gachagua, or Kevin Gachagua, and Keith Ikenu Rigathi, and other close family members and associates as proxies. The National Assembly argues that His Excellency Rigathi Gachagua and his proxies, especially the 2 sons, have used a number of companies to massively launder money, conceal proceeds of crime, corruption, and benefit from influence peddling. Anytime from now, we will hand you over to the live proceedings of the Senate, where we do expect in a couple of moments the Speaker of the Senate will walk into the chambers to deliver that much awaited ruling on the way forward. The senators are making their way into the chamber, taking their seats, signaling probably the imminent arrival of the Speaker of the Senate. Just a quick recap. The Speaker adjourned the sitting briefly to draft a ruling on the request by the senior counsel Paul Muite, representing the Deputy President in this historic trial. The senior counsel told the Senate that the Deputy President had fallen ill and he had been in contact with his doctors at the current hospital, and he also did indicate that he didn't speak directly to the Deputy President on orders by the doctors who are continuing to examine the Deputy President. And in response, the National Assembly, through its legal team, argued that they do not need to cross-examine the Deputy President, who was scheduled to take to the witness stand. But the Senate should consider using the evidence presented by the Deputy President in his submission to make a decision. The National Assembly, through its legal representatives, argued that the matter before the Senate has strict timelines, and so it should be dispensed with. And that is the decision that we are now waiting for the Speaker to make. Ground 8 is serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. That His Excellency Rigathi Gachagua has continuously misled members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. The National Assembly has illustrated in its submission to this trial that sometime in January 2024, His Excellency Rigathi Gachagua made a sensational but false accusation that Honorable Justice Esther Maina, Judge of the High Court of Kenya, had engaged in corruption. He publicly, according to the National Assembly, said he would present a petition for the removal of the said judge, which he has not done to date. But this was amended during cross-examination yesterday of the mover of this motion, Honorable Ekamas Mwengi Mutuse, who said that he has been made aware that the Deputy President has indeed presented a petition for the removal of the said judge. There on your screen is the clerk of the Senate. And now we await for the arrival of the Speaker of the Senate. Currently, the bell is being rung, and we now await the arrival of the Speaker. Ground 9. And there is the Speaker of the Senate, who is now walking into the chambers. This broadcast is brought to you by the Parliamentary Broadcasting Unit in conjunction with the Kenya Broadcasting Corporation.
Order, honorable senators. Let me apologize, I've taken more than the 5 minutes. The matters that had been raised are weighty, but I'm ready with my ruling and I proceed to deliver it. Honorable senators, ladies and gentlemen, as you will recall, before the rise of the Senate at 1:15 p.m., the Senate had concluded the hearing of the case of the National Assembly. This included the evidence laid by the National Assembly, including the calling of its witnesses who were examined, cross-examined by counsel for the Deputy President, and re-examined. As the House adjourned, I directed that, as contained in the hearing program in this matter, of the determination of the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on resumption at 2:30 p.m., the Senate will hear the case of the Deputy President for 2 hours, comprising examination in chief and re-examination, while the National Assembly will have a period of 1 hour and 55 minutes for cross-examination. When the Senate resumed at 2:30 p.m., when the opportunity came for the Deputy President's side to commence its case, Senior Counsel Paul Mwite, counsel for the Deputy President, informed the Senate that he did not know the whereabouts of his client and sought to be allowed a little time to establish where he was. Thereafter, he informed the Senate that he had learned that his client had been taken ill. Asked how he proposed that the Senate proceeds, counsel for the Deputy President requested for time, possibly up to 5 p.m., to try to meet his client before advising on the way forward. Counsel for the National Assembly, when asked to comment on the circumstances, argued that unfortunate as the situation was, this being a constitutionally time-bound process, it was imperative that pursuant to Rule 11 of Part 1 of the second schedule to the Senate Standing Orders, the proceedings proceed. Now I'll read Rule 11. It provides thus: where the National Assembly or the Deputy President chooses not to appear before the Senate, that fact shall be put on record, and the Senate shall proceed with its investigations without further reference to the National Assembly or the Deputy President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the National Assembly or the Deputy President. Now, honorable senators, it is also noteworthy that Rule 12 provides as follows. Subject to these rules, the hearing of the evidence, once it commences, shall proceed and continue until the Senate conclude the hearing of the matter. Following the representation made by counsel for the parties, I suspended the proceedings of the Senate up to 5 p.m. to allow counsel for the Deputy President to report the status of his client. When the sitting of the Senate resumed at 5 p.m., Senior Counsel Paul Mwite informed the Senate that indeed he had contacted doctors at Karen Hospital who were attending to the Deputy President. He further stated that owing to the condition of the Deputy President, he had not been able to access the Deputy President or talk to him. Senior Counsel then proceeded to cite Article 145(6), observing that although the Senate had opted to proceed by way of hearing the matter in plenary, and while Article 145(6) provides for the hearing of the matter by way of special committee, the provision obligates the Senate to accord the Deputy President an opportunity to be heard before a vote is taken on the impeachment charges. He further cited Rule 11 of Part 1 of the second schedule to the Senate Standing Orders, stating that in accordance with the provisions, the Deputy President had chosen to appear and be presented in these proceedings. Counsel for the Deputy President further submitted that the right of the Deputy President to be given an opportunity to be heard under Article 145(6)(b) of the Constitution is not limited by the 10-day timeline otherwise provided for in this matter. In the end, relying on these provisions, counsel for the Deputy President requested that the Senate adjourns the matter to Tuesday, the 22nd of October 2024, to enable his client time to be attended to by his doctors. In response, counsel for the National Assembly, Mr. Gumbo, registered his sympathies to the Deputy President. On the other hand, he noted that the health matters are matters that are beyond human control. However, he noted that the matter at hand was one that was governed by constitutional timelines. Counsel further indicated that Article 145(6) of the Constitution applied to impeachment proceedings in committee and was not therefore relevant to the present proceedings, which had been convened by dint of Article 145(3) of the Constitution. Counsel observed that the dates for the hearing had, by Gazette notice, been set at 16th and 17th of October 2024. Counsel therefore went ahead to observe that His Excellency the Deputy President had robustly participated in the proceedings by filing detailed responses to the allegations as set out by the National Assembly and through various submissions made in the course of the hearing, including cross-examination of witnesses. Counsel then indicated that if any prejudice was to be suffered by the failure of the Deputy President to testify and be cross-examined, this will be on the part of the National Assembly, which had the legitimate expectation of testing the evidence of the Deputy President through cross-examination. Counsel then referred to the practice in the courts, including the Supreme Court, where parties are allowed to file respective submissions, and the advocates are then allowed to appear and highlight their submissions. Counsel argued that noting the Deputy President had filed detailed responses and had the opportunity to cross-examine the witnesses of the National Assembly, the health status of the Deputy President, and the constitutional timelines, and borrowing the practices of the courts, the National Assembly was willing to forgo the cross-examination of the Deputy President and requested that both parties be allowed to highlight their submissions during their closing statements. Senior Counsel James Orengo had similar sentiments and cited Article 145(5) of the Constitution, arguing that the right to appear and be represented include the right to be represented by counsel. He argued that the Senate that the greater duty was to comply with the Constitution, and that the Senate could not accordingly go outside the timelines as set out in the Constitution. It is noted that the present hearing was convened via Gazette Notice 163, Volume CXXV1, dated the 9th of October 2024. Via that Gazette Notice, I appointed Wednesday, 16th October 2024, as the date for the commencement of the hearing, and further that the hearing will run up to the conclusion of the hearing on Thursday, the 17th of October 2024. As presently convened, therefore, today at midnight, unless midnight finds the Senate in the course of division, marks the end of the period for the hearing of the present impeachment matter. As this process is time-bound by the Constitution to be concluded in not more than 10 days, pursuant to Article 145 as read together with Article 150 of the Constitution, and noting that the period provided for ends on Saturday, the 19th of October 2024, the only window open to the Senate, if it so oblige the request for adjournment sought by counsel for the Deputy President, will be to gazette Saturday, the 19th of October 2024 as a further and final day for hearing of this matter. Now, honorable senators, ladies and gentlemen, such a request is not made to the Speaker, but to the Senate, and is accordingly a matter for the Senate to determine. To facilitate this decision, I direct the Clerk of the Senate to circulate a supplementary order paper incorporating a notice of motion and a motion for adjournment sought. This being a procedural matter, the motion, if carried, will result in the Speaker gazetting Saturday, the 19th of October 2024 as a sitting day to conclude the hearing and determination of this matter, this being the last day allowed by the Constitution of Kenya for these proceedings to conclude. Needless to say, if the motion is not carried, the decision of the Senate will be that this hearing continues to conclusion in the manner provided for under Rule 12. In such event, the hearing will continue as set out in the program, with the parties moving to make their closing statements. Now, honorable senators, ladies and gentlemen, in conclusion, let me take this opportunity on my own behalf and on behalf of the Senate to convey our sincere sympathies and best wishes for a quick recovery to His Excellency Rigathi Gachagua, AGH, the Deputy President of the Republic of Kenya. Next order, Clerk. Now, honorable senators, you have been circulated with the supplementary order paper. That is the order paper that we are going to use from now going forward. Clerk, now, honorable senators, this being a procedural motion, you don't need to give notice. So when the order is read out, the majority leader will be called upon to move. Clerk, call the order, please. Honorable Senators, please let us be seated.
Order number 2, procedural motion to hold sittings on Saturday, 19th October 2024.
The Senate Majority Leader.
Mr. Speaker, sir, I rise to move this procedural motion, which is for the Senate to hold sittings on Saturday, the 19th of October 2024. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least two-thirds of all the members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution and the Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, be removed from office 025, dated the 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, and on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas vide Kenya Gazette number 137/18, volume CXX V1 number 163, dated 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday the 16th of October 2024 and Thursday the 17th of October 2024 as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, by plenary. Further, whereas pursuant to Article 145 as read with Article 151(b) and 2 of the Constitution and Standing Orders number 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by way of impeachment of His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145 as read with Article 151(b) and 2 of the Constitution and Standing Orders number 178, and Standing Order number 78 and 79 of the Senate Standing Orders, the Senate also had the counsel for His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses for the National Assembly on the grounds of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, 17th October 2024, further noting that counsel for His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, to appear and give evidence, if any, on grounds for his proposed removal from office by impeachment. Further noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves as follows. 1, to adjourn today's afternoon sitting on Thursday, the 17th of October 2024, and pursuant to Standing Order number 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 until the conclusion of business in the order paper on that day. In order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Mr. Speaker, this is a self-explanatory procedural motion that, in light of the request of counsel for the Deputy President, this House adjourns until the closest time possible without violation of the Constitution within which we can sit and conclude on this matter. As I move this motion, though, Mr. Speaker, I must note that the request that came from counsel for the Deputy President, Senior Counsel Paul Mwite, is that we actually sit on Tuesday. I am sure he knows very well the 10-day provision, but I don't know why he is that we actually sit on Tuesday. I am sure he knows very well the 10-day provision, but I don't know why he wants this House to violate the Constitution, Mr. Speaker, or at least send us into a constitutional crisis. Be that as it may, Mr. Speaker, I want to urge my colleagues that let us sit on that Saturday, despite the fact that I know there are quite a number of Adventists, but duty calls, Mr. Speaker. And this is an important exercise that has a breadth of the country holding still while watching what is happening in the Senate of the Republic of Kenya. Therefore, Mr. Speaker, with those very many remarks, I want to request the minority leader, Senator Justice Stewart Madzayo, to second this motion. I thank you. Justice retired Stewart Madzayo. Sorry, my apologies.
Order, 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 honorable senators. You know, it pays to be attentive. I've just said this is a procedural motion. It does not require notice. Senator Karungo.
Asante Mheshimiwa Spika. Kwanza nataka kuunga mkono hoja hii ya kwamba tuweze pia kupata nafasi ya kuweza kuketi ama kusikiza maoni haya siku ya Jumamosi, kuanzia leo mpaka Jumamosi, kupewa nafasi hiyo. Bwana Spika, tunaelewa ya kwamba hii ni kesi muhimu sana na macho yote katika nchi hivi sasa yanaegezwa katika bunge la Senate. Nataka kumpatia pole sana kupitia kwa wakili ambaye ni senior counsel wetu na ni wakili mkubwa katika Kenya, ndugu yangu Paul Mwite, kwamba yule client wako amekuwa mgonjwa wakati huu. Najua ni ugonjwa ni kitu cha Mwenyezi Mungu. Hatuwezi sisi tukasema ya kwamba mtu hawezi kuwa mgonjwa. Mtu yote anaweza kuwa mgonjwa. Kwa hiyo nataka umpatie pole. Senate imempatia pole na kwamba tunamtakia kila laheri aweze Mwenyezi Mungu kumpatia nafuu, alafu tuweze kumpata hapa. Bwana Spika, tuko katika panda mbili hivi sasa. Ni mgonjwa na tuendelee, ama ni mgonjwa na tusiendelee. Tumpatie nafasi. Kama binadamu naweza kusema kwamba ni nafasi nzuri tuonyeshe binadamu kama maseneta ama nyumba ya Senate kwamba tumpatie nafasi ya yeye akiwa yuko hospitali aweze kuweza kupata nafuu katika matibabu yake. Bwana Spika, mswada huu umekuja wakati mzuri na kwamba tunaweza kumpatia hiyo nafasi. Naunga mkono hoja hii. Asante sana Bwana Spika.
Now, honorable senators, I'll proceed to propose the question, which is that aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2) as read with Article 151(b) and 2 of the Constitution and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into brackets 025, dated the 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas via Kenya Gazette number 13178, volume CXX V1, number 163, dated the 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday, the 16th of October 2024, and Thursday, 17th of October 2024, as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, in plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate heard the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses for the National Assembly on the grounds for the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, the 17th of October 2024. Further, noting that counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves the following: to adjourn the afternoon sitting of Thursday, 17th October 2024, and pursuant to Standing Order 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, the 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, honorable senators, we have been here before. This is a procedural motion. We rarely debate procedural motions. It's either we agree with it or we don't agree with it. And therefore, with your consensus, I may move to put the question. Very well. I will now proceed to put the question. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution, and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into brackets 025, dated the 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas via Kenya Gazette number 13178, volume CXX V1, number 163, dated the 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday, the 16th of October, 2024, and Thursday, 17th of October, 2024, as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, in plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses of the National Assembly on the grounds of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, the 17th of October, 2024, further noting that the counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October, 2024, at 9 a.m. to allow His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of the Deputy President must be concluded within 10 days from the date of the hearing of reading of the charges, which period in this case expires on Saturday, the 19th of October, 2024. Now, therefore, the Senate resolves, 1, to adjourn the afternoon sitting of Thursday, 17th of October, 2024, and pursuant to Standing Order 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, the 19th of October, 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? Nay. The nays have it. Now, honorable senators, the motion having been defeated, we will proceed with the hearing program as had been circulated this afternoon, in which case then we will move to closing statements by the parties. Yes, Senior Counsel Paul Mwite.
Mheshimiwa Speaker, through you, let me recognize the right of this Honorable Senate to decide any issue, any question put to it democratically, which, Mr. Speaker, is what has happened. Arising from that decision of this Honorable Senate, Mr. Speaker, we as the legal team representing the Deputy President are not able to continue appearing without instructions. So we humbly and with a lot of respect take your leave, Mr. Speaker, and the leave of this Honorable House. Thank you.
Now, honorable senators, we shall move to hear the closing statements by counsel for the National Assembly. Clerk, you may now proceed to read the order.
Order number 3, hearing and determination on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
Counsel for the National Assembly, the floor is yours. You have up to 60 minutes.
Thank you very much, Mr. Speaker, sir.
Statement.
On behalf of the National Assembly, we have a total of 4 advocates who would be sharing the time that is allocated to us. Leading the pack, Mr. Speaker, sir, is Senior Counsel Otiende Amolo, to whom I will cede the floor.
Honorable Speaker, honorable senators, I thank you. And this being my maiden appearance on this matter, I sincerely hope I did not drive my learned friend and his team away. But honorable Speaker, Kenya is indeed a mature democracy. We are so mature that, Mr. Speaker, we gave ourselves the most modern constitution in recent history 14 years ago. We are so mature that 7 years ago, we had the nullification of the only presidential election.
Honorable senators, Senator Fernandi, take your seat. Senator Kipsang, may the Counsel for the National Assembly be heard in silence.
Thank you, Mr. Speaker. 7 years ago, we had the nullification of the only presidential election known to history. And today, Mr. Speaker, we are conducting impeachment proceedings unknown to this continent outside of the removal proceedings in a parliamentary system in South Africa. Mr. Speaker, I want to thank you and the Senate for demonstrating the maturity of a democracy. So much so that even when the Deputy President is unable to appear without anything on record, this Honorable Senate has accorded the Deputy Speaker the opportunity, the Deputy President, the opportunity for his counsel to be present, and they have voluntarily exited. The right to appear in person or by counsel is a right under Article 145. But like every other right, you can choose to exercise it or not to exercise it. The idea and the fact of these impeachment proceedings being open as they are and being so democratic, even to vote on the procedural motion, shows how mature our country has become. Mr. Speaker, before the 2010 Constitution, we would not have been here for this process for 2 days. We would not have been taking this process in the National Assembly. The President would sack the Vice President at whims, including for not liking the color of his shoes. The fact that we are here in a situation where to impeach a Deputy President, we have to go through these processes, Mr. Speaker, it shows our maturity. But let it not be mistaken, Mr. Speaker, as some people have, that the process of impeachment is a criminal trial. When you hear people ask the mover of the motion, do you have any proof? Can you demonstrate? It means they are confusing this process with a criminal process. It is not a criminal process. Mr. Speaker, what we have in impeachment is a halfway house between the whim before 2010 and the beyond reasonable doubt proof in a criminal trial. In the words of Article 50, all you have to show is reason to believe. Reason to believe. What the lawyers would call just a prima facie case. You do not have to demonstrate beyond reasonable doubt. So all the questions that I had my learned friends putting to the mover to prove, to demonstrate, they look good to the public gallery, but they add no value to the test for impeachment. Mr. Speaker, impeachment is like a vote of confidence or a vote of no confidence. Just the same way when you vote the president and the deputy, no one asks you to justify why, because you exercise your discretion. When you lose that confidence, no one should ask you to demonstrate why. That is why it's a political process. Otherwise, it could have been a judicial process or a religious process. Mr. Speaker, it is important to make two distinctions. First, that in this process, you do not have to prove anything beyond reasonable doubt. That's number one. The beyond reasonable doubt can come later when the other processes come in, like the investigative agencies. Number two, Mr. Speaker, in courts, our courts use an adversarial system where you bring all the documents and you are restricted to what you have brought. The process in this house is inquisitorial under Article 145 all the way to 149. And therefore, it allows this house to go beyond what the mover has brought or beyond what the other witnesses have brought. And this house has exercised that jurisdiction quite maturely. Mr. Speaker, I want to suggest that the idea of impeachment is one which is legal in process only, legal in process, but political in content and merit. As long as all the legal processes for fair hearing are observed, it is not open to anyone to question the merit in terms of the decision of the National Assembly or this Senate, because the safeguard is in the numbers. That is why before you move it in the National Assembly, you need 117 members. For it to pass, you need at least 2/3. Even in this House, you need 2/3. That is the safeguard. The safeguard is not in the legal technicalities. Mr. Speaker, for that reason,
so when the Senate
while
decided to take
it
that
looks
approach,
juicy and it looks
we decided to
very
take
good,
leave because we'll be sitting in an act, or rather we shall be perpetuating an illegality if we were to sit in Parliament without adequate instructions from our client. So we also take this opportunity once again to wish the Deputy President quick recovery.
What next, Wakili, now with this decision?
What next? Course of action will be decided as and when time is ripe.
What is the condition of the Deputy President as of now? And we also failed to provide medical reports. Why is so?
The matters of the health of the Deputy President are matters of the state. The only person who can inform the state on the status of the health of the Deputy President is the head of state. We lawyers, our instructions are limited to representing him in the Senate. We have executed our legal and civic duty. We await to hear from the President of the Republic of Kenya as to the status of the health of his Deputy President, if he thinks that it matters.
If he's ousted, are you going to move to court and this will form a ground?
The next course of actions will be decided as and when the same is ripe.
Okay, Wakili, you have the opportunity to represent your client as his lawyers. Why didn't you take that route? Because you have that option apart from himself presenting himself.
The proceedings have been, and the conduct has been, that the witness must be examined, both in chief and cross-examined. That has been the practice. The law does not contemplate a situation whereby you are going to be tried in absentia. Even in normal criminal courts, if you're to go to Kibera or to Milimani or to Makandara, there is no possibility that a court of law can proceed in the absence of an accused person because of the right to a fair trial and the right to be heard.
Wakili, there are plans perhaps to have a new Deputy President be sworn in tomorrow or on Saturday. Are you seeking to block this from happening?
We believe that we live in a proper constitutional dispensation where the Constitution has spelled out what should and should not happen. So we shall continue to cling to the four corners of the Constitution, and we shall seek leave and crave any relief from the Constitution.
I think I will agree with what my colleague has said. The issues of health. First is family. Then second, because of the status of the person who is unwell, was taken ill, who is the Deputy President of the Republic of Kenya, then of course the government comes in. And I think it's only fair that the rights, privacy of His Excellency the Deputy President be respected. The question that has been decided at the Senate, I think there are provisions in law, the Constitution, standing orders, which we don't want to interpret because they are subject to many interpretations. Our colleagues on the other side, they will interpret what suits them. Of course, we'll interpret what suits our client, but I think we made it clear. Our lead counsel, senior counsel Paul Mwite, did cite Article 145, 6B. He also cited Standing Order 11. And when you read those two provisions together, you find there's room. So it is a question of the Senate, the Speaker of the National Assembly, the senators, to deliberate and come up with what they think suits not only them or selfishly, but also the country and the family. So I think it's unfortunate that the majority voted against the motion which was put before them. I hope that at the end of the day we'll consider the importance of this country.
What would you describe is happening now?
Well, of course you heard what the Speaker said. They are proceeding, right? And I hope that we'll consider generally the great nation of Kenya, the people of Kenya, and let's see how things unfold.
At the National Assembly, you had an issue with the presiding, citing the Speaker being biased. How would you rate the presiding of the session at the Senate?
And just to add on that, do you think that Gachagua has been afforded a fair hearing as it is required in the law of the Senate?
Well, I think you saw that our client cooperated all through. It's only unfortunate that he got ill at the tail end of it. But we've been there. We prosecuted our case properly, right? And the issue of bias, that always will be tested after the conclusion of the matter. So it's not a matter for us to discuss right now, but I think it's unfortunate, the decision that the Senate has taken, and we wait to see. Thank you.
Those who are saying the Deputy President is taking advantage, is an opportunist. What do you have to say about that?
Come again? What did you say?
They are saying that he's an opportunistic.
No, I don't think I want to comment on that. I think we have given you...
Your fellow colleagues are in the Senate continue with the proceedings. Why did you deem it fit to walk out?
It's a very sad day for this country that when the Deputy President of this republic is indisposed and send the lawyers to request for time so that when he recovers, he comes to appear before the Senate. And he has been here for 2 days. This is a very, very active Deputy President who is always in the office, who is always working. But he sat for almost 16 hours yesterday. So probably something happened. And I want to take this opportunity to wish him a quick recovery, because I was with him even at lunchtime. And he was okay. He was to come to the Senate. But when we got in there, we were told he has been rushed to the hospital. Now the question is, what is the rush with the Senate? We had tomorrow, Friday. We had even up to Saturday. Where do we want to conclude this issue today at night with the absence of the Deputy President, who is the accused, who is supposed to present his case? And Kenyans have understood, have seen these as allegations. We have questioned the Mutuse guy. We have asked him question. We ask him, tell us this. He says, I think, I don't know, I'm assuming, I imagined. So it is a sad day for this country, because we believe that as a Senate, which is the upper house, we should be very patient, wait for the Deputy President, because things happen. You know, people are trying to portray it might be a trick, but remember how many times you're with your friend and you give the stories the next day in the morning. I was with him, he was laughing, and then he's no more. But we are saying the doctors are taking care of him, and he was willing, even if he was to come here in his hospital bed, he is willing to testify. So it is very sad to see that the Senate is in a rush to determine the case without listening to the deputy president. So what we are saying is that Kenya has, we have seen how the process has been. We have seen how the deputy president has been treated. Of course, being treated with allegations that are not able to be substantiated. Kenyans have seen. So it's up now to the Senate to listen to the councils who have now been given 60 minutes to give their closing remarks. And those who have been given the closing remarks are members of parliament. They have taken over the Senate. The person who is speaking as we speak, or as I left the house, is Otiende Omolo, a member of parliament. There is another honorable member there, I don't remember his name. They have taken over the Senate. So what we are saying is that we had gone well as an upper house. And I would implore to my colleagues, the senators, please, we should not crucify somebody who is in hospital, in his hospital bed. At least let the man stand up and allow him to come to the Senate so that we can listen to him. Otherwise, it is a sad day for this country. I don't know what they rush for, and I believe for them, the councils of the deputy president will do what is necessary. And also as a senator, I will do what is necessary.
You left the stage instead of fighting on. What is the end game in this?
No. I'm still fighting on. I was just walking out with the councils for the deputy president just to understand exactly what's going on. It doesn't mean that I'm running away. I am not afraid. I don't fear. I have to go back to that house and I have to make sure that I'm heard, because I believe that if we run away, we will also not be giving justice to the deputy president. But what I'm trying to say is that I do not understand what's the hurry for. Why don't we want to see tomorrow? The members of parliament who are the National Assembly, they are sitting on a Friday, tomorrow. And they were expecting our results today so that they can see tomorrow and execute a business that we do not understand. You know, we do not understand what they're planning. So the plan, and I wish this country can be efficient as they are with impeachment. You impeach somebody, and I'm telling you this, and I'm not a prophet. After we vote in that house, you will see a gazette notice at night. You will see somebody to be vetted by the National Assembly tomorrow in the morning. And you will see somebody being sworn in without following the due process of the law. So I am telling my people and the country, let me talk to the people. You don't have to stop me talking to the people. I have to talk. Imetosha where? Where? Who are you? Nini Imetosha? Yeah. Okay. So this is what I'm talking about. We cannot even express ourselves freely in a country that expression under Article 33 is given by the Constitution. I'm told Imetosha. Tosha what? Tosha where? That is where they want to quicken this process. They want to make sure that they kick out the deputy president. By the time he's kicked out, they bring another one. They go to the National Assembly, they vet one, then they go swear them in. Is this a country that we have a constitution? Is this a country that we have a constitution that we passed in 2010? That is the question. But nevertheless, I ask everybody, especially Kenyans, be peaceful. Be peaceful and be peaceful. Thank you very much.
Still, all is not lost. Do you have the numbers to defend Gachagua at the Senate? Because that's still a question. You have not voted yet.
We'll get to know about the numbers when we vote. Because you see, there are so many people who are so painting as I am. And maybe they are not able to speak. But let's cross the bridge once we get there.
There are concerns of bribery at the National Assembly. Is it the case for the Senate?
I do not want to anticipate or make allegation that I cannot substantiate. But let me tell you, the investment is heavy. It is heavy. Very heavy. Let me go back to Parliament. Thank you.
Of the cabinet and the presidency. There was an argument that was raised that some of the alleged misconduct on the part of the deputy president were actually committed when he was not the deputy president, and therefore do not apply to the proceedings before this House. Reference is made to Article 151B of the Constitution, which provides that the ground for impeachment would only be serious consideration of serious reasons to believe that an offense has been committed. There is no time limit that is set, because once there are reasons to believe that an offense has been committed, then that stretches back to whatever time that offense would have been committed. This is to say, if in the pendency of the life of the presidency or the deputy president, it is discovered that before you assume the office, you committed an offense, that forms a ground for impeachment. This leads me to the next argument, which are the admissions that the deputy president actually made before the House. Clearly, he admitted that the issue of shareholding in Kenya was live, and he was part and parcel of it. Therefore, Kenyans were shareholders. He actually admitted in the House and also in the press in the country that he believed the president was behind this motion. He also admitted that he had actually gone against the principle of collective responsibility on the basis that the cabinet had made unconstitutional decisions, which decisions he had to disobey. He also went on to dismiss this parliament as a theater of the absurd, and that he did not expect much from here. The question is this, and that, honorable senators, you have to grapple with. If the deputy president was actually to be saved by this House, with whom would he work? He would not work with the Kenyans whom he has antagonized with his shareholding notion that he has spread across the country. Number two, he would have difficulty serving with his boss, whom he has accused of being behind this motion. He would not actually work with the cabinet, where he is responsible for everything that is done in the cabinet and the sub-cabinet committees brought together by the principle of collective responsibility. He would not be able to work with this parliament, which he has called a theater of the absurd. With whom would he work? This is the question you have to ask yourselves. What we have before us today is like a marriage. And I have to draw that analogy because actually the position occupied by the subject of the discussion and the motion, the Honorable Rigathi Gachagua, is now untenable. He cannot hold that position because his position is irretrievable. He cannot work with any of the organs and bodies he's supposed to work with. Therefore, the position being irretrievable, then it means actually he has to be impeached. And I implore upon you to actually do so. Where a marriage is irretrievably broken, you cannot apply any law. The marriage is gone. Whichever law you try to apply, it does not matter. For the deputy president today, we cannot apply any measure of legalese because this is not likely to assist us in any way. The position remains, this is a political process, these political offices they are holding, and therefore they are irretrievably broken. As I pen off, honorable senators, honorable speaker, sir, I'll refer you to a biblical book in the Old Testament, the book of Jonah, chapter 1. And when the senators retire, they can actually look at that, the entire chapter. What happened here when Jonah disobeyed the command from his superior, and that was the deity? He actually had to flee. And when he fled, he took a ship to a different city, not where he had been commanded to go. What remained was, on the journey, the waters were faced with tempest, And eventually, the tempest had to be calmed by tossing Jonah out of the ship. The ship here is actually the presidency. The ocean is actually Kenya. Jonah is the insubordinate deputy president who actually cannot work with the entire government and the country, and whose position today, as he holds, is untenable. With those remarks, I urge you, honorable senators, to actually uphold this motion, and to the best of my belief and conviction, not only ground 11, which I have submitted, the rest of the grounds have been approved. Thank you very much. 2 minutes to Honorable Zamzam, who is also going to make a statement and a submission. Thank you very much.
Mheshimiwa Spika, kama mwakilishi wa bunge wa eneo bunge la Mombasa na bunge la taifa la Kenya, Mheshimiwa Spika, leo nimekuja hapa kuwaletea yale mashtaka ambayo yameonekana katika bunge letu. Mheshimiwa Spika, Mheshimiwa Spika, mengi yamezungumzwa. Mimi si mwanasheria, lakini mimi nazungumza kama yule Mkenya ambaye yuko pale chini, hajui sheria, hajui nini, anaomba amani katika taifa. Mheshimiwa Spika, Mheshimiwa Spika, video zimechezwa katika bunge hili. Tumeona Mheshimiwa Naibu wa Rais akijipiga kifua, hasa kule Taita Taveta. Nimeona Mheshimiwa Spika akiwaambia kuwa hawana shares, na akawaambia nyinyi kama mnataka hisa muongoje 2027, manake hata rais akinambia mimi niweze kuwaletea maendeleo, na mwambia kwanza subiri niangalie kwenye mfuko wangu wakiwa kama wako kwenye orodha ya kupewa maendeleo. Mheshimiwa Spika, Mheshimiwa Spika, ifahamike kuna wakati mmoja Kenya iliingia kwenye vita sana. Mheshimiwa Spika, tuliona maiti ya kina mama, mtoto hajui mama amekufa, mtoto alikuwa ananyonya matiti. Mheshimiwa Spika, Mheshimiwa Spika, hatuwezi kutaka taifa hili lirudi kule tena. Mheshimiwa Spika, Mheshimiwa Spika, ndani ya Mombasa nina wajane ambao wananitegemea sana. Mheshimiwa Spika, uniletea malilio yao, na leo mimi kama mama kaunti wa Mombasa nalia kwa sababu ya mayatima ambao waliachwa na ndugu ya naibu wa rais. Mheshimiwa Spika, haiwezekani kuwa leo mimi na mume wangu tutafute mali yetu na tuna watoto wetu, kisha akifa aende mbele ya Mwenyezi Mungu nije nipokonywe mali yangu, niache na watoto wangu wakihangaika. Mheshimiwa Spika, ukiangalia umri ya hawa watoto wa ndugu yake Mheshimiwa naibu wa rais, wametoshea kupewa urithi wao. Mheshimiwa Spika, lakini hata kuna tetesi mwingine yoozea kule kwa jela. Mheshimiwa Spika, kwa hiyo Mheshimiwa Spika, mimi nasema, nilisikia mwanasheria akisema to save makanga. Mimi nasema makanga ameiba pesa ya abiria, dereva hana pesa ya kupelekea mwenye gari. Kwa hiyo mimi nasema wamwache dereva apeleke abiria mpaka station ya mwisho, kisha akifika kule atajua atatafuta makanga mwingine namna gani. Mheshimiwa Spika, hatuna sisi uchungu na watu wa mlima, lakini tunachosema, tulikuwa na Uhuru, tulikuwa na Kibaki, tulikuwa na Kenyatta, hatukuwahi kuona mambo ambayo tumeona kwa deputy president. Mheshimiwa Spika, huyu ni sumu, atavuruga Kenya, ataharibu Kenya. Naomba bunge hili la Seneti, amani ya Kenya iko kwenye mikono yenu, na waomba mtoe uamuzi wa uhakika. Huyu jamaa hapendezi kabisa kuwa katika nafasi ambayo yuko ndani sasa, na waomba kwa heshima na taadhima tuweze kumtimua leo, Kenya iweze kupata mtu ambaye atamsaidia rais kufanya kazi akiwa ameweka amani na umoja wa Kenya mbele. Asante sana Mheshimiwa Spika.
Mr. Speaker, sir, very briefly, I will wrap up the submissions on the part of the National Assembly. I'll endeavor not to repeat what has already been captured on the record, across the world and across other democracies. Mr. Speaker, sir, I've had occasion to look at the history, particularly of the United States of America, from the days of Andrew Johnson in 1868, Richard Nixon, 1974, Bill Clinton, 1998, and Donald Trump, 2019. Mr. Speaker, sir, I asked myself, what does impeachment proceedings seek to serve in a democracy? In my reflections, one of the clear conclusions is that it is a check and a balance through which the populace can then hold their leaders accountable. It is an avenue through which the populace can ask their leaders whether they're doing that which is in keeping with the social contract or the understanding that they had at the point of election or delegating their direct powers to those elected leaders. So in the context of Kenya, where then do we find impeachment? Mr. Speaker, sir, our history has taught us very bitter lessons. We remember the events that bedeviled our country after the 2007 elections. It is after those events that we gave ourselves a new constitution. In that new constitution, Mr. Speaker, sir, we found it necessary to, in an unprecedented way, speak about our values, speak about the fabric of our society, the things that pull us together, the things that we share as a people. The preamble to our constitution, in particular, paragraph 3, reads, "We, the people of Kenya, proud of our ethnic, cultural, religious diversity, and determined to live in peace and unity as one indivisible sovereign nation," and continues so on and so forth. From those words, we realize what the thinking of the Kenyan people was right from page 1 of framing of our constitution. We then went to substantive provisions. A lot has been said about Article 10 of our constitution, to the extent that it speaks to the values that as a people we want to be associated with. We have dedicated a whole chapter of our constitution to the questions around leadership and integrity. It then tells us how central the values that we hold are to each other as a nation. Now, if we look at impeachment from that lens, then we realize and appreciate that impeachment then comes in to hold our leaders at an even higher pedestal, so that we have a tone at the top that is acceptable, a tone that gives us what has been called elsewhere political hygiene. We have had occasion in this country where people who have been in positions of leadership have been treated in what other people have thought has been harsh treatments. But it is because when there's a tone at the leadership to be set, it must be clear, it must be vibrant, and it must be the right tone. We've had leadership, people from the leadership who've lost their office because of having pinched somebody. We have people who have lost their offices because of utterances that were considered inappropriate. A slap has gotten somebody to go through a fairly painful process. It is because the slap is not necessarily the issue, it is the message that it sends. And so similarly, when we talk about our leaders, we then must ask ourselves, what does one wrong word do to the fabric of our society? It is on the basis of that background that we then consider the impeachment motion that is currently before this House. My colleagues who have spoken before me have taken us through the provisions of Article 150, 1B, which then speaks to the very grounds that this House should consider in whether to impeach His Excellency, the Deputy President, or not. I wouldn't want to go into those grounds because the record before this House contains material in support of those grounds. I would urge, Mr. Speaker, sir, that now that His Excellency, the Deputy President, has had occasion to present material before this House, that this House could consider in response to the motion for impeachment. When you retire to debate, to deliberate, we urge that you take into consideration the entirety of that material. We also ask that you also take time to look at what the mover of the motion presented before this House, as well as all the witnesses, including what came from public participation. That would give us an opportunity to, in a very objective way, reflect on what and how to deal with the questions that have been presented. I need not go into the specifics of each of the charges, but if I was to give examples, when we have a leader occupying the high office of the deputy president of this country, somebody who is required by the Constitution to take an oath confirming or affirming to Kenyans that they will not divulge whatever comes out of secrecy, out of confidential conversations that come to their knowledge by virtue of the office that they occupy. If that person then defies that bond or that commitment that they've had with Kenyans, it is a gross violation. Similarly, when we have somebody occupying the space of the high calling of the office of the deputy president, admitting issues that would amount to conflict of interest between his personal interest, his family interest, and which have financial implications. Again, our laws then dictate that those are reasons that would would be sufficient to impeach such a deputy president. We've had examples that have been given about utterances that have been considered to be unpalatable. Again, looking at the entire framework of what our Constitution anticipates, looking at what those words would mean to a man off the streets of Nairobi, off the streets of Mombasa, or any other place. If we all come to the understanding that those words taken in their natural meaning could cause some measure of discomfort, they are considered to be divisive, they are considered to be of such a nature as to bring or sow seeds of discord between us as people in this country, then it is the responsibility of this House to speak, and to speak on behalf of the people of Kenya, because it is one way of ensuring that there are checks and balances that flow from the constitutional powers vested in this House. Mr. Speaker, sir, as has been demonstrated through the many tons of documents that have been availed before this House, the cross-examination that has attended to the witnesses that have been before this House, and the material that has been placed by the mover, by all the parties who've had an opportunity to participate in the proceedings of this House, we have absolutely no doubt that this House is perfectly capable of making the appropriate decision in each and every of those counts. And just for emphasis, Article 150, Subarticle 1B gives us 3 grounds. We do not have to have beyond 1. Any one of those is more than sufficient to make the call or to pull the trigger on an impeachment motion. Mr. Speaker, with that, I rest, and we thank you for according us this opportunity this evening. Most obliged.
So, are you done now with your submissions?
Yes, Mr. Speaker, sir.
Thank you.
We are done.
Thank you. Now, honorable senators, I'll refer you to the program. You will notice that after the closing statements from the parties, the Senate is supposed to move to a closed session to deliberate on the issues that have been raised. And that is pursuant to our rules of procedure. That is demanded of us by the rules of procedure. So at this juncture, I will allow the parties to retire as the Senate moves to a closed session. That closed session will take us not more than half an hour. After that, we'll come back. Once we are back, there's going to be a special motion contained in an order paper. That is the motion that will allow debate culminating into honorable senators getting the opportunity to cast their vote on each of those charges, of the 11 charges. So, Counsel for the National Assembly, you may now retire. Once we resume open session, of course, you'll resume your seats.
Thank you very much, Mr. Speaker, sir.
The media and live broadcast has to cease forthwith.
Hey there, friends. Welcome to Kids on the Block, where fun and imagination come alive. We dive into magical world filled with exciting adventures and awesome friends.
What position were you in? I was number 2. What position were you? Number 1.
He decided to cross the bridge by his house and look for food on the other side.
We're going to do half cup of chocolate chips, and the other one, we're going to do half cup of the blueberries.
So, grab your imagination hats and get ready to explore with us. Join us every Saturday at 9 a.m. for new friends, amazing stories, and tons of laughter.
Join us as we explore the journeys of those who defy the odds and break barriers. We dive deep into the stories of triumph.
Sometimes when parenting a child with a special need or whatever disability, family life becomes a bit complicated and you may end up raising the child on your own.
Here, we inspire.
I have a farm which one we showcase with other dyslexic youths and autism, how to farm.
Motivate.
It's never easy, but what we do, the best thing is to work with another parent who has an elder child than yours.
And break through the barriers one story at a time. Push your boundaries beyond the limit. Saturdays at 8 p.m. The Grind, where business meets brilliance. It's not just about the ideas.
I was working as a shampoo boy. I used to wash clients' hair on the sink.
It's about making them happen. From big wins.
In primary school, when we would be asked what people want to be, I was categorical that I want to be a nurse.
To hard lessons.
The consoles change, the gaming equipment keep changing.
We cover it all. Tune in to The Grind, where every episode is packed with insights.
The person who is serving customers, always be a customer-centric.
Strategies.
When you pay attention to detail, you get luxury items.
And stories to fuel your ambition. Don't just dream it, grind it. Mondays at 7:30 p.m.
Hujambo mpenzi mtazamaji popote ulipo, tunaendelea kukupakulia matangazo moja kwa moja kutoka chumba chetu cha matangazo. Wanakwetu wananiita Joashon Sare, ambapo tunazidi kuliangazia swala la kubanduliwa kwa naibu wa rais Rigathi Gachagua. Matukio mbalimbali mtazamaji yamekuwa yakijitokeza siku nzima kutoka maeneo mbalimbali. Hisia mseto vilevile zimekuwa zikijitokeza kutoka maeneo mbalimbali, washikadau na vilevile wataalamu wa masuala ya sheria pia wakizungumzia masuala hayo kwa kina, matukio ambayo tumekuwa tukiyafuatilia. Na mwendo wa saa 8 saa 9 hivi naibu wa rais kuweza kufika katika bunge la Seneti ili kuweza kujiwasilisha na vilevile kuweza kutoa ushahidi kuhusiana na yale madai ya kubanduliwa kwake, na ndiposa vikao hivyo vikaanza kujikokota. Lakini swala ambalo limeweza kufanya kuwe na vikao vya faraga vingi tu ambavyo vimeweza kufanyika, na hata hivi sasa bunge la Seneti liko kwenye kikao cha faraga kuweza kujadili mawili matatu kuhusiana na mchakato mzima wa kubanduliwa kwa naibu wa rais, na ndiposa tunakujuza matukio hayo kadri muda unavyozidi kusonga, kwa kuwa wanahabari wetu wamepiga kambi maeneo mbalimbali ili tukujuze matukio hayo kwa kina. Uzidi kumakinika na endelea kusema nasi kupitia mitandao yetu ya kijamii ili tukujuze zaidi pale kwenye Facebook TV47 Kenya, na vilevile tuweze kukujuza mengi zaidi. Na naarifiwa mwandishi wetu Elizabeth Mutuku yuko katika majengo ya bunge akifuatilia matukio haya na tunaungana naye moja kwa moja. Elizabeth Mutuku, ni yepi yanajiri katika majengo ya bunge kuhusiana na masuala haya ili mtazamaji wetu azidi kufahamu, na ni kipi vile vile anatarajia kuhusiana na kubanduliwa kwa naibu wa rais? Liz Mutuku.
Naam, Joshua Onsare, kama ulivyosema ni kweli, mchakato huu wa kumbandua naibu wa rais Rigathi Gachagua umekuwa ukiendelea katika bunge hili la Seneti kuanzia asubuhi, mambo mbalimbali yakiendelea kutukia, lakini la mno ni lile ambalo limetukia kutokana na ugonjwa wa ghafla wa naibu wa rais Rigathi Gachagua baada ya kwenda mkao wa mchana ili kurejea kikao cha jioni, na hili ni mojawapo la mambo ambayo yamesababisha bunge hili kufikia mahali walipo, ambapo wapo katika mkao wa faragha kuweza kuzungumzia namna ya kusonga mbele na jinsi ambavyo wataendeleza shughuli za kumbandua naibu wa rais Rigathi Gachagua kupitia hoja ambayo ipo mbele yao kupitia bunge la kitaifa. Na labda ni kujuze Joshua Onsare, ambayo ametukia katika dakika kama 20 ambazo zimepita, ni pamoja na uamuzi ambao baada ya kikao hicho kurejea mwendo wa saa 11:30 walijadiliana zaidi kuhusiana na iwapo wangependa kuendelea na mkao huu, na ambaye ni wakili kutoka upande wa naibu wa rais Rigathi Gachagua, Paul Mwite, akipendekeza bunge hili kumpa kipindi ama kumpa naibu wa rais wakati wa siku chache hadi Jumanne wiki ijayo kuweza kufika mbele ya bunge hili ili kujitetea dhidi ya mashtaka 11 ambayo yamewasilishwa mbele ya bunge hili kabla ya hoja yenyewe kupigiwa kura, ama kabla ya kila shtaka kupigiwa kura na uamuzi wa kumbandua kuweza kuafikiwa. Ila baada ya majadiliano ya dakika 5 hivi kutoka maelekezo ya Speaker wa bunge hili Emerson Kingi, ni kwamba baada ya kipindi hicho cha dakika 5 walirejea na hoja ya kuweza kuendeleza vikao, kuahirisha vikao hadi siku ya Saturday ili kuruhusu siku 10 ambazo zimewekwa katika kipengee cha 145 kikatiba zisipite kuelekea Jumanne ambayo ilikuwa imependekezwa. Lakini baada ya pande zote, kiongozi wa chache na kiongozi wa wengi, kuwataka maseneta kukubaliana na hili na kumpa nafasi naibu wa rais kufika katika bunge hili siku ya Saturday kuweza kujibu mashtaka ama kuweza kujitetea dhidi ya mashtaka ambayo yameibuliwa dhidi yake. Baada ya kukubaliana kwa hoja ile ya kukubaliana au kukataana, walio wengi wakapendekeza kwamba mkao huu unastahili kuendelea kwa siku nzima kama ilivyoratibiwa hadi saa 6, endapo ndo wakati ambapo watakuwa wakimaliza. Lakini mawakili wa naibu wa rais wakaondoka katika mkao huo wakisema kwamba jinsi ambavyo mambo yamekuwa sio ambavyo walikuwa wanatarajia. Lakini vikao hivi vilikuwa virejee, na kwa sasa tunarejea humo ndani kuweza kufuatilia yale ambayo yanaendelea humo moja kwa moja.
A/DLP/TBO/MTS/2024 025 dated 8th of October 2024 and received in the office of the Speaker of the Senate on 9th of October 2024. The Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. Further, whereas pursuant to Article 145 as read with Article 151B and 2 of the Constitution and the Standing Order 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, and further whereas pursuant to Article 145 as read with Article 151B and 2 of the Constitution and the Standing Order 78 and 79 of the Senate Standing Orders, the Senate also had His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, on the grounds of his proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, therefore, pursuant to Article 145, as read with Article 151B and 2 of the Constitution and the Standing Order 78 and 79 of the Senate standing orders, the Senate resolves to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, on the following grounds. 1. Gross violation of Articles 10(2)A and B and C, Article 27(4), 73(1)A and 2B, 75(1)C, and 129(2) of the Constitution, and Article 147(1) as read together with Article 131(2)C and D of the Constitution. Ground 2, gross violation of Articles 147(1) and 152(1) of the Constitution by undermining the President and the Cabinet and the effective discharge of the national government's executive mandate. Ground 3, gross violation of Articles 6(2), 10(2)A, 174, 186, 189(1), and the fourth schedule to the Constitution by undermining devolution. 4, gross violation of Article 161 of the Constitution of the Constitution on the institutional and decisional independence of judges. Charge 5, gross violation of Articles 3(1) and 148(5) of the Constitution on the fidelity to the oath of the office and allegiance. Charge 6, serious reasons to believe that His Excellency the Deputy President has committed crimes under Section 13(1)A.
Give the Majority Leader the microphone.
So let me take that again. Charge 6, serious reasons to believe that His Excellency the Deputy President has committed crimes under Section 13(1)A and 62 of the National Cohesion and Integrity Act. Charge 7, serious reasons to believe that His Excellency the Deputy President has committed gross economic crimes under Section 45(1), 46, 47(3), and 48(1) of the Anti-Corruption and Economic Crimes Act, and Section 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. Charge 8, serious reasons to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Charge 9, gross misconduct that is incompatible with the high calling and dignified status of the office of the Deputy President and a member of the Cabinet and the National Security Council. His Excellency the Deputy President has publicly attacked and undermined the work of the National Security, Intelligence Services and its officers. Charge 10, gross misconduct by openly and publicly insubordinating the President, who is the head of state and government. And finally, charge 11, gross misconduct by persistently bullying state officers and public officers. Mr. Speaker, this is a very difficult exercise that the House of the Senate is being called to undertake. It's the first time in the history, actually, of this country that this is happening. Though under the old Constitution, pre-2010, Mr. Speaker, such an elaborate process wasn't available. To the best of my recollection, I don't remember this kind of an exercise where the Senate is being invited to agree to charges initiated by the sister house and confirm them after listening to both parties that appeared before us in the National Assembly versus His Excellency Rigathi Gachagua the last 2 days. Mr. Speaker, I do this with a heavy heart because His Excellency the Deputy President is somebody that is well known to me. I consider him, Mr. Speaker, more than a colleague in the leadership of this country, more even than just a normal acquaintance in social circles.
Majority Leader, you are called upon to give notice.
Notice? Oh, okay. Apologies. Mr. Speaker.
Next order.
Order number 5, special motion, proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya.
Senate Majority Leader.
Mic, please. My apologies, Mr. Speaker. I now hereby move the motion, which is a proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all the members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution and the Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by letter, reference NA/DLP/TBO/MTS 2024 into bracket 025, dated 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. Further, whereas pursuant to Article 145, as read with Article 151 and 2 of the Constitution and the Standing Orders 78 and 79 of the Senate had the National Assembly on grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Order 78 and 79 of the Senate Standing Orders, the Senate also had His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on the grounds of his proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, therefore, pursuant to Articles 145, as read with Article 151(b) and 2 of the Constitution and the Standing Orders 78 and 79 of the Senate Standing Orders, the Senate resolves to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on the following grounds. 1. Gross violation of Articles 10(2)(a), (b), and (c), Article 27(4), 73(1)(a), and 2(b), Article 75(1)(c), and 129(2) of the Constitution, and Article 147(1), as read together with Article 131(2)(c) and (d) of the Constitution. Charge 2. Gross violations of Articles 147 and 152 of the Constitution by undermining the President and the Cabinet and effective discharge of the national government's executive mandates. Charge 3. Gross violations of Articles 6(2), 10(2)(a), and 174, 186(1), and 189(1), and the fourth schedule to the Constitution by undermining devolution. 4. Gross violations of Article 161 of the Constitution on the institutional and decisional independence of judges. 5. Gross violations of Articles 3(1) and 145(5)(a) of the Constitution on the fidelity to the oath of office and allegiance. Charge 6. Serious reasons to believe that His Excellency the Deputy President has committed crimes under Sections 13(1)(a) and 62 of the National Cohesion and Integration Act. Charge 7. Serious reasons to believe that His Excellency the Deputy President has committed gross economic crimes under Sections 45(1), 46, 47(a)(3), and 48(1) of the Anti-Corruption and Economic Crimes Act, and Sections 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. Charge 8. Serious reasons to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Charge 9. Gross misconduct that is incompatible with the calling and the dignified status of the office of the Deputy President and a member of the Cabinet and the National Security Council. His Excellency the Deputy President, that has publicly attacked and undermine the work of the National Security Intelligence Services and its officers. Charge 10. gross misconduct by openly or publicly subordinating the president, who is the head of state and government. 11, gross misconduct by persistently bullying state and public officers. Mr. Speaker, I have observed that this is such a momentous task ahead, and I never imagined a few years ago, Mr. Speaker, that it will be possible after the journey that we have traveled with His Excellency, the Deputy President, in the political side that I belong to, that hardly 2 years down the line, I will have the difficult task of having to move the impeachment motion against him after listening to this case brought to this House by the National Assembly, in the case titled the National Assembly versus His Excellency Rigathi Gachagua. And the last 2 days, Mr. Speaker, together with other Kenyans, we have watched with lots of bewilderment, hard to believe pronouncements, and difficulty, Mr. Speaker, to believe that here is where we find ourselves as a nation. Despite the many challenges that we have gone through over the years, it was our hope, Mr. Speaker, that public officials would have picked up a lesson or two, especially those that are slightly older than yours truly, and many that are younger than me in this House, Mr. Speaker, and that in their conduct, they will reflect better the skills, demeanor, pronouncements of a leadership, Mr. Speaker, that this country continues to yearn for. Unfortunately, Mr. Speaker, listening to the case that has been brought to us by the National Assembly, I have reason to believe, beyond any doubt in my mind, Mr. Speaker, that they have justified the case that they have brought before us and have been able to ably demonstrate to us and to the country, Mr. Speaker, that there is no other cure by design of our Constitution to the challenges, either political or legal or otherwise, that are being faced, Mr. Speaker, by the workings and the working relationship between the President and his deputy, other than by way of impeachment. And the National Assembly has moved this House, Mr. Speaker, on 11 charges, blow by blow, with citations and examples in broad daylight, Mr. Speaker, showing and mapping, Mr. Speaker, that each charge, how it has been committed, Mr. Speaker, and how it violates either the Constitution or various laws of the Republic of Kenya. And therefore, Mr. Speaker, we are left with very minimal options. I have observed before this House, Mr. Speaker, that the Deputy President is personally known to me. I consider him a friend. I have had the opportunity to interact with him, learn a lot from him, Mr. Speaker, listen to his wise counsel sometimes. But this evening, Mr. Speaker, duty calls. And when duty calls, Mr. Speaker, there is very little that we can do. I am afraid, Mr. Speaker, that as legislators, as servants of the people, we have to listen to what the people are telling us. Mr. Speaker, we must appreciate that in 2010, when Kenyans went to the polls and brought about change via the new constitution, it was a call for us to have a better republic served previously since 1963. And there are various high ideals, high demands that have been placed in all of us that are in leadership. And I must add quickly, Mr. Speaker, that as you rise in stature from a member of a county assembly to a member of the National Assembly, senator, governor, deputy president, and eventually even as president, Mr. Speaker, that as you ascend in the hierarchy of leadership, the demands by the Constitution are even more. Number one, because you occupy greater public space, you represent more people. When you speak, Mr. Speaker, you say things that can affect either positively or otherwise the lives of millions of citizens. And therefore, Mr. Speaker, listening to the case that has been laid before us since yesterday by the lawyers of the National Assembly, reading through the bunch of documents that have been presented to us, attached with evidence, Mr. Speaker, I can confirm both to this House and to the country that unfortunately this country must make the difficult decision of having to say goodbye to His Excellency, the Deputy President Rigathi Gachagua, because, Mr. Speaker, the reasons that have been listed have consequences by law of what you do when this happens. The National Assembly has demonstrated before us, Mr. Speaker, that on charge 1, that there are various articles of the Constitution, either through his utterances or his actions, Mr. Speaker, that have led other Kenyans to seriously believe and feel lesser Kenyans, Mr. Speaker, something that we thought we had slayed. We thought that we had worked so hard to build a cohesive society where it didn't matter after a political contest, Mr. Speaker, of who eventually wins, that you'd feel comfortable, you'd feel safe, you'd want to do business in any of our 47 counties, Mr. Speaker, and feel at home. Unfortunately, Mr. Speaker, listening to the utterances, reading through the response, Mr. Speaker, and the pleadings by his lawyers, and the pleadings and the admission, Mr. Speaker, by his own affidavit, Mr. Speaker, that either my good friend, the Deputy President, doesn't appreciate the higher calling that the office he occupies demands of him, or he has completely refused, Mr. Speaker, to accept the dictates of our Constitution. And when you get to that law, that place, Mr. Speaker, where there is conflict between man and our Constitution, then man must give way for our Constitution to thrive. That is a demand of a public office. Mr. Speaker, I know this is not an easy exercise. I have agonized and sat there wondering whether there could be other ways we could resolve this issue. And I know for a fact that there have been attempts, Mr. Speaker, not just this time, but previously. I know for a fact, Mr. Speaker, that there have been occasions where either religious leaders, friends, people from business circles, Mr. Speaker, have attempted actually to mediate through some of these conflicts. But unfortunately, Mr. Speaker, instead of getting better, things have gotten worse. What is the essence of this session that we are having? Mr. Speaker, after listening through an impeachment process, the Senate sits as a jury to make a decision whether to find guilty or acquit. But like has been observed many times, and I have reminded this House on all the occasions when I have moved impeachment motions the last few years, Mr. Speaker, is an impeachment is political and legal conjoined together. It's about political accountability. It's about legal consequences of our actions as well, Mr. Speaker. There are political challenges, Mr. Speaker, that must be addressed. There are legal issues that have been raised as well, Mr. Speaker, which I want to believe when my colleague senators get the chance to address this House and convince each other. Perhaps people are watching and wondering, what is it that senators are doing at this hour? I believe that all the 67 of us that are here have had occasion to peruse through the evidence, listen, and this is a chance to share your thoughts about what you think and what is the proposed solution. I'm not sure, Mr. Speaker, whether my colleague senators will find the Deputy President guilty on all the 11 charges, or 1 or 2, legally speaker, or none. Mr. Speaker, I'm being quickly reminded by my colleague here that is possible. And that is fine, because it is based on what you had, what your mind is convinced about these particular charges that have been drawn, and what you think is best for this country, Mr. Speaker. I don't intend to be long, because I know, Mr. Speaker, we have agreed that we will do this not for a very long time. And I know there's so many of my colleagues that want to speak on this particular issue. But there are about 2 or 3 charges that I want to just focus my thoughts on, Mr. Speaker, and perhaps leave the rest to hear, to be convinced this way or the other by what my colleagues will pick. There is, Mr. Speaker, charge number 8, serious reasons to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, divisive and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. We have institutions that are charged with the responsibility of making sure that we are a cohesive society, Mr. Speaker. By statute, actually, after the 2010 Constitution, we set up the National Cohesion and Integration Commission. And it was our sincere hope, Mr. Speaker, that that commission perhaps will help us, especially we that are leaders, learn better from our utterances and do things, say things that leave the rest of Kenyans feeling that they are proud patriots, that the things that we do make them feel at home in this republic. It's unfortunate, Mr. Speaker, that despite this commission, for example, being funded by taxpayers, I have not seen them live up to their expectation, and perhaps part of the challenges that will emerge even after this impeachment process, Mr. Speaker, is to audit how some of these institutions continue to draw from the exchequer yet not live up to their mandate. In fact, Mr. Speaker, I saw them issue the other day, I think, a statement saying, oh, if you carry out this impeachment process, it will divide the country. I want to tell that Reverend Kobe, I think his name is chairman, you better resign. I have never seen a public officer that is as disgraced as that gentleman. Why do I say so, Mr. Speaker? I remember in our days, last time, Mr. Speaker, this is the same institution that was so vigilant that will ban us even from coining phrases like hatupangwingwi and say that those phrases are divisive to the country. But I've seen for the last 2 years, Mr. Speaker, these narratives and clips that we are being shown, being whipped and hurting Kenyans on a daily basis, and have kept quiet about it. But finally, when the National Assembly has moved to say that we must put a stop to this, they finally show up on stage and say, oh, this will divide Kenyans. Mr. Speaker, surely, don't Kenyans deserve better from their public institutions, Mr. Speaker? I hope, Mr. Speaker, that at the end, by the end of this particular exercise, all the commissioners of that particular institution, Mr. Speaker, will find it fit to resign so that we can have Kenyans who understand how we can build a more cohesive society than those that are gatekeepers of those that push divisive narratives, Mr. Speaker. Mr. Speaker, we have been invited as well and have been challenged that on charge 10, that there is gross misconduct by openly or publicly insubordinating the president, who is the head of state and government. And I listened to one of the lawyers urge us and say, where is the complaint from the president? Surely, does the president need to complain to you, Senator Onyonka, to notice that there is a dysfunction in that particular office? That if there is a lack of symphony in action, in word, in deed, Madam Speaker, between the president and the deputy, and there is a continuous spat, such as what has been witnessed the other day, then constitutional consequences might follow, so that you clean up and have an institution that works for the greater interest of all the people of the Republic, Mr. Speaker. Finally, Mr. Speaker, I know not everybody agrees with those of us that hold the view that the Senate has been sufficiently convinced by these charges, either one of them, all of them, or none that I say. But what I find difficult, Mr. Speaker, is to accept the proposal by those that want to reduce this House and claim that Parliament is a gathering of just a few people. And I have watched many people say that, pundits on the television, including none other than the Deputy President himself, who on many occasions, including last weekend in Embu, has said that his only faith is in the courts of the Republic of Kenya and nothing about this particular House. Mr. Speaker, perhaps it will be important for somebody to remind him, what is the history of Parliament? Parliament is a gathering of all Kenyans. I have said many times, Mr. Speaker, that because it is not possible for all the 50 million Kenyans to meet at one place and agree on issues, Mr. Speaker, they agreed to do so through their representatives, Article 2 of our Constitution, Mr. Speaker. And therefore, a gathering of a House of Parliament, Mr. Speaker, cannot simply be wished away by being described that a few members either overturning or undermining the will of the people of Kenya. I believe Kenyans speak directly through the election or indirectly through their elected representatives, who are the people in the National Assembly, in the Senate, in our county assembly. And therefore, Mr. Speaker, when institutions of accountability are dispensing their constitutional mandate, such as what we are doing today, Mr. Speaker, if you respect our constitution, then respect the outcome and the processes that have been initiated and concluded in houses of parliament, Mr. Speaker, just as you do with courts of law. And I appreciate, Mr. Speaker, that on many accounts, I know this process has attracted close to 30 petitions in our courts of law. And I agree with the learned judges that have, Mr. Speaker, made a determination that you allow Parliament to conclude on its processes such that anybody who's not satisfied with the outcome, Mr. Speaker, can exercise their right to appeal. And therefore, Mr. Speaker, in the interest of time and knowing that many of my colleagues want to speak to this particular issue, I want to conclude it at that and request that the Senate Minority Leader, retired Justice Stewart Mazayo, the Senator for Kilifi, does go ahead and second this motion. I thank you, Mr. Speaker.
Asante Bwana Spika. Bwana Spika, kwanza nataka kuunga mkono hii hoja ambayo inahusikana na ile kesi ambayo iko hapa ya kuweza kumngatua kwenye mamlaka naibu wa rais. Bwana Spika, katika kanuni zetu za kudumu kipengele cha 145 kinasimulia ama kinaongea juu ya vile rais ama naibu wa rais anaweza kuondolewa katika mamlaka. Bwana Spika, kitu cha kwanza ni kwamba katika mashtaka haya yote yaliyoko mbele yetu, ukosefu wa nidhamu au heshima kwa Wakenya. Bwana Spika, ni jambo la kusikitisha kuona ya kwamba mtu kama naibu wa rais anaweza kusema Kenya ni kampuni, na kwamba Kenya pia vile vile iko na zile wanaita nafikiri zabuni amani shares, na kwamba ikiwa wewe hukuweza kufanya kitendo kama hicho walichokuwa wakitaka wao cha kupiga kura, basi wewe utangojea sana ili uweze kupata maendeleo. Bwana Spika, tukiangalia zaidi tunaona ya kwamba mtu akiwa naibu wa rais, yeye anakuwa kiungo muhimu sana cha kuweza kuunganisha taifa. Sasa wewe ukiwa kama naibu wa rais na umechaguliwa, kazi yako wewe waliokupigia kura, ambao hawakukupigia kura, wewe maendeleo ni lazima yafike kwenye mashinani ya kote nchini. Na wewe ni ndugu, ni baba, ni babu, ni mzee wa nchi hii. Kila mahali unapokwenda unatakana kuheshimika katika nchi yetu. Lakini jambo la kusikitisha ni kwamba, na sio mara moja, sio mara mbili, pengine ambapo pengine ulimi uliteleza, lakini ilikuwa ni kila siku mahali popote anapokwenda katika hii miaka miwili ambayo tumekuwa nayo katika uongozi wa Kenya Kwanza. Yeye akiwa kama naibu wa rais amekuwa anahubiri. Hata amekwenda maeneo ya ndugu yangu, na mimi namjua huyu ni Mkenya kabisa, ndugu yangu Cherargei, akatamka tena maneno kama hayo mwisho. Na sisi tunasema kwamba maneno ya kuweza kutenganisha Wakenya ama kuwapatia kwamba sisi tumepata, kwa hiyo kule wale wengine watabaki. Nchi ya Kenya ni nchi moja, na kama kulipa ushuru, kila mtu analipa ushuru. Pia sisi kama watu tunaotoka pande za pwani, pande za Kisumu, pande za Western, pande za kila mahali katika Kenya, watu wote wanalipa ushuru. Kwa hiyo nafikiri kwa maoni yangu ni jambo la kusikitisha kuona ya kwamba naibu wa rais anaweza kutamka vile aliweza kutamka ya kwamba Kenya ni kampuni na lazima uwe na zabuni ya kutosha ili uweze kupata maendeleo. Bwana Spika, vile vile mimi nitaongea kwa upande ule ninaotoka wa Kilifi, mahali panaitwa Vipingo, mahali ambapo yeye ana hoteli ya familia. Manake hoteli ilikuwa ya ndugu yake, lakini hatimaye yeye akaweza kuichukua ile hoteli. Sitaenda kwa upande ule wa mwingine wa kwamba pengine ilikuwa ya nani, lakini ilikuwa ya hiyo familia. Kitu cha kusikitisha ni kimoja tu. Katika maendeleo ale ambayo tunahitaji sana ndani ya Kilifi ni barabara. Na mojawapo ambao sisi tulikuwa tunalalamika zaidi upande ule ni kwamba barabara iligeuzwa na ikatoka barabara ya kutoka Mombasa mpaka Malindi, katikati ikageuzwa na ikaenda ndani mpaka kwa hoteli ile inaitwa Vipingo Resort Limited or something like that, ikaenda mpaka kule. Hiyo ni mali ambayo ingekuwa ilifaidisha zaidi watu wa Kilifi, hususan kwenye wakulima na wafanyabiashara na wananchi kama kawaida kupata maendeleo ya kuona barabara hizo, lakini yeye akaigeuza na ikaenda kwake. Mimi mwenyewe nilipata nafasi ya kwenda huko, Bwana Spika. Bwana Spika, utaona kwamba barabara inahepa Mikanju, inahepa mpaka Miembe ikienda kwenye hiyo hoteli, ambapo sio jinsia ya vile barabara huwa zinatengenezwa. Bwana Spika, hapo tukaona kwamba ni kiukaji wa nidhamu. Bwana Spika, vile vile ningependa kusema kwamba si sote ni watu ambao tunaamini kwamba kunaye Mungu, na ukimkosea Mungu yeye mwenyewe huwa anajua kuna wakati fulani atakuja kukuadhibu. Bwana Spika, tumeona ya kwamba wale ambao walikuwa wamekosewa hivi sasa kuna malipo ambayo yanaendelea. Bwana Spika, tukiangalia haya malipo ni kwamba imetokea kwamba zile mali zote, watoto wote wale wa yule ndugu yake mkubwa aliyefariki. Jambo la kusikitisha kuona ya kwamba mimi ama ndugu yangu yoyote hapa ndani ya Senate hatuombi, lakini ukifa kama mali yako haitakwenda kwa watoto wako, inaenda kwa ndugu yako na bibi yake na watoto wake. Tunaona hiyo pia ni ukosefu wa kuona nidhamu ndani ya familia ambao wewe kama kiongozi wa familia unatakana uilinde na uitunze. Naona kwamba wameweza kupata maendeleo. Bwana Spika, ya mwisho ambao nataka kusema kwa hivi sasa ni kwamba wajane wanapolia Mwenyezi Mungu hujibu, na nafikiria wakati wa kujibu sasa umefika. Kwa hiyo asiweze kulaumu mtu yote. Hapa ndani ya hili bunge tumeangalia na hakuna kwa upendeleo upande huu ama upande huu. Tunasema ya kwamba haki itendeke. Mwisho nataka kusema ya kwamba pia kuna ile ya kwamba ikiwa tuko katika timu kama wewe uko katika cabinet, vile vile Bwana Spika, tunaona ya kwamba katika yeye akiwa kama mmoja wapo wale watu ambao wanaketi katika kamati ile ya kuangalia katika nchi ya ujasusi, yale NIS, alitamka mambo ambayo yalikuwa hayafai ya kuweza kulaumu kiongozi wa ujasusi, ambapo haikuwa na maana yoyote. Kama kulikuwa kuna nia ya kusema kitendo kama hicho, angekuwa alimuita kamishna yule wa polisi IG, njoo hapa, na akamuita yule mkuu wa ujasusi, njoo hapa, na akaketisha pamoja. Je, wewe mkuu wa ujasusi uliweza kupeleka ripoti yako kwa mkuu wa polisi? Ama akaulizwa, yule akajibu akasema amepata ama hakupata. lakini kwenda kwa mkutano wa hadhara na kuanza kusema mtu fulani hafanyi kazi ndani ya ofisi yake, hilo lilikuwa ni kosa kubwa sana, na ambalo huwezi kuficha siri ya yale yanayotendeka katika ujasusi, katika ile kazi zao za ujasusi. Bwana Spika, kwa vile mimi ninaona njia ambayo ameelekea na kazi zake hakuweza kuelekea kisawasawa, na mimi kwa maoni yangu, na najua ndio maoni ya wengi, nimeonelea kwamba hapa sababu hizi ambazo zililetwa ya kwamba aliweza kukosea utendakazi wake aondolewe katika mamlaka. Naunga hoja hii. Asante Bwana Spika.
Honorable Senators, I now propose the question. They're aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution, and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into brackets 25, dated the 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, and the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, on the grounds of his proposed removal from office by impeachment on the Deputy President of the Republic of Kenya. Now, therefore, pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate resolves to remove from office by impeachment His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, on the following grounds. 1. Gross violation of Articles 10, 2A, B, and C, 27(4), 731A, and 2B, 751C, and 129(2) of the Constitution, and Article 147(1), as read together with Article 131, 2C, and D of the Constitution. 2. Gross violation of Articles 147(1) and 152(1) of the Constitution by undermining the President and the Cabinet and the effective discharge of the national government's executive mandate. 3. Gross violation of Articles 62, 10, 2A, 174, 186(1), 189(1), and the 4th schedule to the Constitution by undermining devolution. Gross violation of Article 60, 161 of the Constitution of the institutional and decisional independence of judges. 5. Gross violation of Articles 3(1) and 148(5)(a) of the Constitution on the fidelity to the oath of office and allegiance. Number 6. Serious reasons to believe that His Excellency the Deputy President has committed crimes under Sections 13(1)(a) and 62 of the National Cohesion and Integration Act. Number 7. Serious reason to believe that His Excellency the Deputy President has committed gross economic crimes under Section 45(1), 46, 47(a), 3, and 48(1) of the Anti-Corruption and Economic Crimes Act, and Sections 2, 3, 4 and 7 of the Proceeds of Crime and Anti-Money Laundering Act. Number 8, serious reason to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Number 9, gross misconduct that is incompatible with the high calling and dignified status of the office of the Deputy President and a member of the Cabinet and the National Security Council. His Excellency the Deputy President has publicly attacked and undermined the work of the National Security Intelligence Service and its officers. Number 10, gross misconduct by openly or publicly insubordinating the President, who is the head of state and government. And number 11, gross misconduct by persistently bullying state and public officers. Now, honorable senators, the floor is open to debate. The Honorable Senator Fernandi, Senator Samson Cheranke. As we have already agreed, you have a maximum of 5 minutes. You need not take the maximum 5 minutes.
Thank you, Mr. Speaker. I want to say from the onset, this is very momentous. This is the true test of Constitution 2010, because in history we are used to impeaching governors, not the Deputy President, Mr. Speaker, sir. On this process that has ongoing, Mr. Speaker, although as I begin, I want to wish my brother and friend Rigathi Gachagua a quick recovery after that unfortunate incident. Mr. Speaker, the process largely has gone on well until the adherence of Article 50, Mr. Speaker, where we have not succeeded in giving fair hearing to the to Deputy President, Mr. Speaker. The reading of Article 145, and I want to bring to the attention, 4, does not specify the timeline on which the Deputy President removal can be listened. It is only by the special committee that it provides for 10 days. So, Mr. Speaker, that was very unfortunate, Mr. Speaker, in the principle that justice should not only be done, but to be seen to be done, Mr. Speaker. Many Kenyans are asking questions, Mr. Speaker, what really happened? Number 3, Mr. Speaker, in observation, we didn't even allow state officers, a full-time governor, Mr. Speaker, to participate. This matter was decided in Constitutional Petition 204 of 2019, where state officers were barred by Justice Eric Ogola, Mr. Speaker. When you look at the issues, Mr. Speaker, because of limitation of time, on various grounds, like, for example, on the grounds for renovation of the office of the Deputy President, the funds were appropriated by the National Assembly. Yet the same National Assembly is accusing the Deputy President, who is not even an accountant. The accountant is a different person, Mr. Speaker. Or even on the KEMSA issue on the bully, in the grounds that they have been set, Mr. Speaker, they are saying that the Deputy President bullied KEMSA, Mr. Speaker, but there is no proof that that tender was awarded to the specified companies that were provided, Mr. Speaker. On even the aspect of devolution, the chairperson of Intergovernmental IBEC is the Deputy President of the Republic of Kenya, Mr. Speaker. It is unfortunate that we are coming to circumvent the same law and accuse the Deputy President of undermining devolution, Mr. Speaker. Even on Kambini Vipingo Road, Mr. Speaker, no one adduced the evidence that this road is either public or private, Mr. Speaker. Mr. Speaker, on the aspect, even on unexplained wealth, Mr. Speaker, you saw the mover did not give us a wealth declaration form from EACC to show us unexplained wealth of Deputy President, 5.2 billion, Mr. Speaker. So, Mr. Speaker, the grounds that have been adduced before the House stands on the quicksand, Mr. Speaker. And if you realize, on the 11 grounds, the mover was on a fishing expedition, Mr. Speaker. And therefore, I don't know, because they say, Mr. Speaker, even when you read, I know impeachment proceedings either political, because it is impeachable, because they are neither high crimes, criminal, but based on the test of probabilities, Mr. Speaker. Mr. Speaker, and therefore, even when you look at many other aspects, Mr. Speaker, I want to challenge members, even as we go and vote, Mr. Speaker, If you see, as Francis Mboga, the play that was written in 1976, Mr. Speaker, they say, Mr. Speaker, if the madness of the nation disturbs a solitary mind, Mr. Speaker, it is not enough to say that man is mad, Mr. Speaker. Where we are at crossroads as a country, Mr. Speaker, whatever the outcome today, this country must move on, Mr. Speaker. We must proceed, Mr. Speaker. I know after today, the decision that we'll make today is not about the Deputy President. It is about the justice to Deputy President, justice to the people of Kenya, justice to each and every Kenyan who voted for the Deputy President, Mr. Speaker. And I want to finish by reading the book of Zechariah, chapter 8, verse 16, Mr. Speaker. I am preaching today, Mr. Speaker. And may it get to the souls, Mr. Speaker. Amen. Zechariah, Mr. Speaker, 8, verses 16. And even Glenn Washington, Mr. Speaker, and Morgan Heritage in Reggae, they say a man is not guilty until it is accused of being. Mr. Speaker, in Zechariah 8, verse 16, these are things that you are to do. Speak truth to each other and render true and sound judgment in courts. Senate, my colleagues, by the time you cast your vote, think about it. It is not about Rigathi. It is not about anybody else. It is about the Republic of Kenya. Our children, our nation, Mr. Speaker. I finish by saying...
Senator Enoch.
Thank you, Mr. Speaker. Mr. Speaker, there is a reason why my colleagues call me bishop, others call me pastor. Mr. Speaker, the book of Deuteronomy, chapter 19, from verse 18 to 19. It says that the judges shall inquire diligently, and if the witness is a false witness and has accused his brother falsely, then you, the judges, shall do to him as he had meant to do to his brother. So you shall purge the evil from your midst. Mr. Speaker, I did not know that I would be a senator in Kenya at such a time as this, being called upon to judge between the National Assembly and the Deputy President of the Republic of Kenya through a motion brought here by one Honorable Mwengi Mutuse. But Mr. Speaker, here we are, and where duty calls, I will answer the call with courage and guided by a deep desire for that which is good for our nation. Mr. Speaker, I would have expected that the crumbling relationships within the Kenya Kwanza administration would perhaps have been handled within their PG or their NEC and resolved there. But because they have chosen this path, Mr. Speaker, they have made their bed, they must lie on it. Mr. Speaker, the mover of the impeachment motion must have a very dim view of the Senate of the Republic of Kenya. He comes to us with innuendos, falsehoods, sensational statements, and dropping of numbers without a shred of evidence. So, Speaker, he begins his own illustration by saying sometimes in 2023. He goes on, the Speaker, to speak about at another forum in September 2024. Mr. Speaker, we are debating an impeachment motion of the Deputy President of the Republic of Kenya. The least that these judges would have expected, the least that this country would have expected, is due diligence on the mover of the motion. Getting every event and every date right. In fact, going down to the minute, to the second. This is a serious issue, Mr. Speaker. But Mr. Speaker, because of time, I will say two things. One, let it be known to this House and to this country that those of us who subscribe to the ideals of the Azimio One Kenya Alliance are totally and grossly opposed to the idea of a government of shareholding. We don't subscribe to that idea. We believe in an all-inclusive government where every person and every region have their space in this country. But Mr. Speaker, when that matter was presented to us as an accusation, as a ground for impeachment of the Deputy President, during cross-examination and going through the evidence table before the Senate, it is clear to this House, it is clear to this country, that the idea of a government of shareholders is a foundational policy of the Kenya Kwanza administration. The signature for that policy is appended by none other than the party leader of that coalition, the President of the Republic of Kenya, the Speaker of the National Assembly, the Chief Cabinet Secretary, and Mr. Speaker, I would dare say, don't drag the Speaker of the Senate to this because he's not part of this. Mr. Speaker, you cannot punish the Deputy President, the principal assistant to the President, for undertaking the role of being the assistant to the President. He is just expounding on a policy that his boss assigned and made public. Mr. Speaker, oh my goodness. Mr. Speaker, lastly, if you allow me,
Senator Metho.
Thank you very much, Honorable Speaker. From the onset, allow me to say that I rise to oppose the motion of the removal by way of impeachment of the Deputy President of the Republic of Kenya. And Honorable Speaker, for the last 2 days, today and yesterday, we have been treated to a charade of allegations, accusations, which, in my opinion, have not been substantiated either by the mover of the motion, the Honorable Mwengi Mutuse, or the advocates who he came with, or the advocates that are on record for the National Assembly. And Honorable Speaker, I am actually quite surprised that one of the advocates who appeared to represent the National Assembly tells us that the Honorable Mwengi Mutuse, his was only to allege. This is not a trial. He didn't have to substantiate. He only needed to allege, and out of the allegation, then it should be carried, and we need to remove Honorable Deputy President from office. Honorable Speaker, looking at the evidence that the Honorable Mwengi Mutuse put in his motion, and the cross-examination that was here, the evidence that he brought to the House, he had 22 companies that he had listed. And when questions were running to him, what problem do you have with the company number one? I don't have a problem with it. Maybe you will have a problem in future. But the Deputy President must be removed from office. What do you have what problem do you have with company number two? I don't have a problem with it, but it might have a problem in future, and the Deputy President must be removed from office. And he kept telling us, I don't have a problem with the next one, the next one, the next one, the next one, but the Deputy President has to be removed from office. Honorable Speaker, I posed a question to the Honorable Mwengi Mutuse. He alleged that the Deputy President has a dairy farm in Nyandarua County. The fairest thing, or the least that anybody would do to such an accusation, you need to tell us where in Nyandarua is this land, at least remotely tell us what is the title number, so that even if, as the area senator, if I want to verify that indeed the Deputy President has a dairy farm in Nyandarua, there is something that I can look at. Honorable Speaker, he said, I don't know, but the Deputy President has to be removed because it is time to remove the Deputy President. On the question about Meru, where is the title number? I don't have it, but the Deputy President has to be removed from office. his wealth is 5.2 billion. Have you done a valuation? I don't have a valuation. I don't have a valuation. I don't mind. The deputy president has to be removed from office. There is no evidence that I have in record. I don't mind. The other funnier question that we had, Honorable Speaker, is that the deputy president has an allegation of insubordination. And the insubordination can only be sanctioned by the immediate supervisor of the deputy president. The immediate supervisor of the deputy president is the president. Is there any affidavit that the president has complained that there has been insubordination by his own deputy? Nothing. But the only thing that I would want to hold on to on this particular allegation of the deputy president having been alleged to have insubordinated his immediate supervisor. Since this motion of impeachment started, we have not had any comment from the president, either saying what has been alleged by Honorable Mwengi Mutuse is true or not true. So I want to believe that beyond the owner of the motion of the Honorable Mwengi Mutuse, the president is the bigger owner, because he has not denied that this is there has been an insubordination. And my comment would be this: this divorce that the president is looking for, you shall get it, but it will be painful, it will be hurtful, it will be catastrophic, it will have casualties. At the final vote that will be casted today, we might be the first casualties. But the casualties of today are not necessarily the casualties of tomorrow. And out of the vote that shall be taken, I'm speaking to our partners in the coalition and the other people who are here from ODM and the other parties. This vote that you shall take today, it is not in vain that the senator for Nyandarua, it is not in vain that the senator for Kiambu, it is not in vain that the senator for Muranga, it is not in vain that the senator for Laikipia, it is not in vain that the senator for Kirinyaga, with strict instructions from the people who elected this government, have told them to come and oppose the motion that is on this floor of the House. Honorable Speaker, I'm being disrupted. The point that I wanted to make is, it is not in vain that we have been instructed not to sanction this divorce. But if it comes, we shall take it in our strides. I want to tell the people who are here, the vote that you shall cast here, we shall not put it in our minds. We shall put it in our hearts. The people of the region that I have mentioned are at their lowest. We are calling on the senators who are here. It is time to stand with us. Finally, this motion had to be processed in a haste. We had to try a man in hospital because the only crime that Gachagua has committed is a political crime. So he had to be removed out of the way, whatever it will take, whether he's in hospital, whatever it will take, he has to get out of the way. That can only happen if it has the direct sanctioning of the President of the Republic of Kenya, His Excellency William Samoei Ruto.
Senator Tom Ojenda.
Honorable Speaker, it is with a heavy heart that I stand in Senate today to comment on the motion and the 11 charges that have been preferred against the Deputy President, His Excellency Rigathi Gachagua. During today's session, when the advocate for the Deputy President made a presentation, I posed a question to the advocate. And the question, Mr. Speaker, sir, related to the share question which informs count one. Count one is on gross violation of Article 10.2, Article 73, Article 75, 129, 147, and 131 of the Constitution. Mr. Speaker, sir, it is inconceivable that certain regions of this country, in view of the Deputy President, cannot and do not form part of the so-called, Mr. Speaker, sir, the shareholders in this country. To me, Mr. Speaker, sir, the shareholding question and paradigm that the Deputy President has so eloquently, for the longest time possible, stuck to since the election, is the lowest, Mr. Speaker, sir, that he has gone. It is the lowest, Mr. Speaker, sir, because this morning, the advocate was unable to respond to the shareholding percentage for Kisumu County, Siaya County, Migori and Homa Bay counties, Mombasa County, and many other counties, including West Pokot, Trans Nzoia, Mandera, Marsabit, and Vihiga counties. Mr. Speaker, sir, the shareholding question violates expressly Article 10(2)(b) of the Constitution.
Senator Tabitha Karanja. You have 2 more minutes. It's a system flow.
Mr. Speaker, I thought that was rigging. I thought that was rigging. But Mr. Speaker, sir, may I move to just conclude, to move? Mr. Speaker, sir, the presidency of this country, and we have moved under Articles 145 to 150 of the Constitution to impeach the Honorable Deputy President. The embodiment of the role of the President at Article 131 of the Constitution, Mr. Speaker, sir, the President is the embodiment of this country. He represents this country, and therefore, Mr. Speaker, sir, any coalition agreements of any nature must crumble in the face of Article 131 upon election. The President and his deputy, who is his assistant, must, Mr. Speaker, sir, embrace the principles of inclusivity and Article 10 and be the face and represent all the people of this country. Submissions made by councils for the National Assembly to the effect, Mr. Speaker, sir, that any instrument, be it a political agreement deposited with the registrar, Mr. Speaker, sir, that violates this principle of necessity, Mr. Speaker, sir, are unconstitutional. And it is in the face, Mr. Speaker, sir, of this first count that I will vote in favor of the impeachment of the Deputy President. Mr. Speaker, the other counts that are set out and that relate to violation of the principles of national cohesion, Mr. Speaker, sir, have been proven by the submissions made before this House this afternoon. Violation of Article 147 and 152 of the Constitution have been proved as set out in the charges framed by the National Assembly. Mr. Speaker, for the first time, let me say this, that this country must pull together in one direction. And that direction, if the President, Mr. Speaker, sir, and the Deputy cannot work together, then the interests of this nation cannot be safeguarded by allowing the Deputy President to continue being in office if his ideals are clearly in contravention or oppose the ideals that are held by the President of this country. We must support His Excellency President Ruto to run this country in a coordinated manner that Mr. Speaker, sir, brings together all the citizens of this country in a manner that coalesces all the 45.
Senator Tabitha Karanja.
Thank you, Mr. Speaker, sir, for also giving me this opportunity. And I want to take this opportunity and convey my pole to the Deputy President, and we wish him a quick recovery. The impeachment process is always very tedious and very tiring. Going through what His Excellency, the Deputy President, has gone through is not anything that you'd wish your relative or yourself to go through. So we tell him pole, and we wish him a quick recovery. Would have wished if he was here, at least when the senators are talking, he can represent himself. But unfortunately, the procedure must go on because we are time bound. In this leadership, we must make decisions for the people of Kenya. As myself, Stabitha Karanja, the Senator of Nakuru County, I pray to God to give me wisdom to make the right decision for my people. I represent a county that is a home for 42 tribes. Nakuru represents Kenya. Meaning, I must make the right decision to ensure that there is peace in our county. But I want my Nakuru people to trust me, Nakuru people, the people I represent, that I will make the right decision for them. When you look at the economic front, we all know the people who lead the economy of this country. Let's say the manufacturing, the hotels, insurances, the finance institutions. Unfortunately, I also come from that world. I came from the business world. The people driving this economy, all what they want is to ensure that there's stability in this country. So that there's a stability that can guarantee conducive environment for them to do business. The deputy position, the deputy president's position, or even the deputy governor's position is a position that we need to think about. If you look, it has a history that every deputy president is unlikely that they survive. But we need to have the firing and hiring to be given to the same person that hires. Rather than having those people bringing, after firing, they want to fire, they bring them to the floor of the Senate. I wish we can go back to the Moi regime, where they used to be sacked and nothing changes. They hire as another one tomorrow, the following morning. Fortunately, the political formation in this country have representation from different communities. I know we are all asking where we are, but when the boss says he doesn't want the person that is hired, a manager, it is very, very hard to say that you can save that person, because even if you save him, where is he going to work? He may even find the offices are locked. So I think you make the right decision to ensure that this country moves, because all what we are looking for is stability of this country. And I know when I'm in this floor, if we're unlikely that we don't save the deputy president of the Republic of Kenya, the one we have, that deputy president came from one community. I just pray that that position will be returned to the same community. Thank you, Mr. Speaker, sir. Asante.
Senator Okoit Omtata.
Thank you, Mr. Speaker. I stand here not to defend a good man. It's not important whether His Excellency the DP is a good man or a bad man. I stand here to defend the oath of office that I took to defend the Constitution of Kenya. And that includes giving the devil his due. When the people of Kenya, during public participation, were screaming Kufa Makanga, Kufa Ndereba, they were opposing selective prosecution. They said if Parliament has to hold people accountable, it should not be selective. And I stand here to look at whether this House has complied with the Constitution. Article 150, Clause 2, on the removal of the Deputy President. The grounds for impeachment are set out in Article 145. And the pursuant to Article 145, it is purely a political process, but bound by law, especially Article 25, Clause C, which requires that somebody is given a fair hearing. So the removal of the president by impeachment on any ground under Article 145 is a grave matter that involves overturning the sovereign will of the people as expressed in a democratic election. Even more profoundly, it means that the person so removed is prohibited for life from enjoying the rights under Article 38, Clause 3, Paragraph C, to be elected and hold office, to vie for, be elected and hold office. So the constitutional bar that must be cleared for the removal of the president from office is high. The Constitution requires that the removal must be well-founded in law, and that's why it prescribes the thresholds. And it must be objective. It is not a simple matter of numbers in the National Assembly and in the Senate. An impeachment is not a vote of no confidence. We must distinguish that. A vote of no confidence is a simple matter with no standards. It's just a political thing that you make, and somebody resigns from office, but he can come back and get to office again. This is an impeachment. So, Article 150, Clause 2 provides that to remove the deputy president, the provisions of Article 144 and 145 relating to the removal of the president, the deputy president, of the president shall apply with the necessary modifications to the removal of the deputy president. The Constitution does not anticipate a situation whereby we apply Article 145 on the removal of the deputy president without modifying it. The phrase is, shall apply with necessary modifications. What modifications has this House made, or the National Assembly made, or Parliament as a collective made to Article 145 before applying it to the deputy president? Can we impeach the deputy president using the standard for impeaching the president, when we know very well that the president is immune to prosecution, and therefore the certain standards that apply to him won't apply to the deputy president? So given that the deputy president has not enjoyed those immunities, how are we protecting him? How are we ensuring that this process is constitutional? It's my submission there's a total failure on Parliament to have proceeded to impeach the deputy president without making the necessary modifications to Article 145. And we have seen the potholes we have fallen into. It's okay for the president because the president is immune from judicial processes. But is it okay that the deputy president should be prosecuted using the same standard used for the president? And in the drafters of the Constitution,
Senator Ali Roba. Senator Ali Roba.
Thank you very much, Mr. Speaker. I'd like to time so that I don't lose my apologies. Thank you very much, Mr. Speaker. Yesterday, the Council for the Deputy President had really spent a lot of time in trying to bring out non-issues, leaving out the critical substance of the case against the Deputy President. And as I was seated here, I was honestly hoping I'll get an opportunity to get some clarification from the Deputy President. And unfortunately, that never happened. But since we are here and the public are watching, there are issues that need to be responded to. On the issue of serious allegation that is to do with the proceeds of crime and anti-money laundering, in the affidavit of the President, the Deputy President himself acknowledged that Christo Company belongs to him. And he also further acknowledged that he has transferred Christo Company to his sons. And he went further to acknowledge in his own sworn affidavit that he has borrowed 600 million shilling in order to purchase Outspan Hotel from Abadeas. But in the evidence that is filed, that is before us, he only provided a letter of offer from a bank and resolution of the company. But he failed to provide, and all of us understand the loan process and how tedious it is. The deputy president failed, and if you are accused and you are threatened to be removed from the office of the deputy president, I believe that the least that was expected of the deputy president and his legal team is to, get with clarity a closed loop by providing the evidence that is required. For example, there is no provision in that in the evidence and that is filed before us of what happened after an offer was made. Normally it is followed by an agreement, a loan agreement. That evidence of loan agreement has not been filed. It is followed by a collateral document that was used. And, the need to get the collateral document through the legal perfection in terms of valuation report of that asset itself. He has not provided the charge document that indicates that that loan has been charged. In the evidence that is filed, he has not provided evidence of the fact that there is money credited to Christo account. And he has not further provided evidence of money leaving Christo account to go to Abadeas for acquisition of Outspan. And the legal counsel expects, by concentrating on non-issues with the petitioner, that these issues will be swept under the carpet. The other issue that I need to bring out, yesterday we were shown videos. The videos indicated utterances of the president in Muranga, where the president made a statement in trying to validate the statement of shareholding and the country being a company. They showed the president making a statement of nyinyi mumepata share yenu. But that was a statement of inclusivity in context, as opposed to the deputy president's statement everywhere he has gone, that is, assertive utterance of exclusivity within the population in this republic. Mr. Speaker, sir, Article 145 of the Constitution and 146, 2A indicates that should the unforeseen eventuality happens, where the president ceases to be, God forbid, the deputy president takes over to finish the term of that presidency. The question I kept on asking myself, can this deputy president, can I really call this deputy president my president in the context of this division that has been ongoing? Mr. Speaker, sir, when you are the second in command in the country and you sit,
Senator Karungo. Senator Karungo.
No, I want to speak from the floor. Thank you very much, Mr. Speaker, for the opportunity to oppose this motion. I stand to oppose, and I'll start from where I left by saying that children deserve the most honest and thoughtful answers. And allow me, when I give my point, to talk to my children and the children of patriots of this country, Mr. Speaker. Mr. Speaker, cutting off the neck does not cure headache, Mr. Speaker. Mr. Speaker, it is one thing to condemn a healthy person and another to condemn someone who is sick or bedridden. Today, we were told the Deputy President fell ill, and he requested for time for us to give him an opportunity so that we can hear him. But that opportunity was not granted because we're in a hurry And yes, I think we are. I don't know to where. Mr. Speaker, this is an impeachment in absentia. And I believe, Mr. Speaker, without contradiction, that probably it is a flawed process, Mr. Speaker. And for some reason or at some point, I was not able even to know who we are impeaching. Is it the Deputy President or the Governor of Siaya, Mr. Speaker? Why am I saying that? Because our standing orders, Standing Order 81 and Standing Order 80, says when a governor should appear before us. And we saw a governor standing there, Mr. Speaker. So sometimes I was asking myself, maybe the governor impeached himself by just appearing to us, Mr. Speaker. And I want to tell you, Mr. Speaker, when you listen to Mr. Mutuse, the main witness, when we ask him questions, he was saying this is just a prima facie, prima facie, prima facie. I'm not a lawyer. I Googled, and it says, prima facie says on first sight. So we are impeaching the Deputy President on allegation of at first sight. Mr. Speaker, we don't even love at first sight nowadays. But we have made the process of impeaching a Deputy President so easy than kicking out a nagging boyfriend or a nagging girlfriend. So I stand here from Kiambu saying that, Mr. Speaker, I'm not going to impeach the Deputy President because listening to the accusation here, they are not enough. They do not meet the threshold of removing somebody from the office. You ask Mutuse here, you had it. Mr. Mutuse, tell us. He says, I was not in an investigation journey. Mr. Mutuse, I just imagined. Mr. Mutuse, I don't know. Mr. Mutuse, I believe. Mr. Mutuse, Senate, believe me. Even if you don't believe me in one occasion or in one ground, just take one, the one that you love, Mr. Speaker. Mr. Speaker, it's sad that my brother, a person from my area or my region, the Deputy President of this country, is being impeached. And I want to talk to the majority leader, person I really respect, and also the senator for Bomet, Mr. Sigei. When we hope to save a brother, remember us when we ask you to save our brother, Mr. Speaker. Mr. Speaker, as I conclude on this issue, Mr. Speaker, he who assesses the integrity of others must exemplify an even higher standard of integrity on himself. I want to ask you members, please, as I go down to write your names or the sins on the ground, and I'm not calling myself Jesus, ask yourself, would you be the first one to throw the stone on the Deputy President? And Mr. Speaker, I am going to leave this by saying I'm going to vote on all 11 counts. No, 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 no. I'm going to vote no. And I'm going to leave you with one quote I've read from a member of parliament from Gatondo North, who has said, Mr. Speaker, and I read, the dog is not sick, it's just afraid, facing its last 2 hours of power forever, Mr. Speaker. Those are the MPs who kicked out the Deputy President. They are now calling him a dog. Maybe even this motion, Mr. Speaker, was brought by some people who are suffering from mental issues, Mr. Speaker. I'm going to say that because how do you call a Deputy President is a dog and he's not sick and he's only waiting to get out of power for 2 hours? I ask you, brothers, please do not play along the galleries. Respect the Deputy President, respect the people of Murima, and I leave you with Exodus 19, verse 12, Mr. Speaker. We were told if you touch a widow, you die. It says if you touch the mountain, you die. I vote no.
Senator Sifuna. Senator Edwin Sifuna.
Honorable Speaker, let me join you and the others who have sent their sympathies to His Excellency Rigathi Gachagua. We wish him a quick recovery so that he can come back. Honorable Speaker, I think it is a very unfair accusation that we are impeaching somebody whilst in hospital. It has been said here, Honorable Speaker, that nobody can predict when you can be taken ill. It can happen to any one of us. And therefore, we did not plan that the Deputy President would not be here to also be able to present his case. And as Senator Roba has said, many people were in fact waiting to also get some clarifications from some of the pronouncements that have come from the Deputy President. Honorable Speaker, I want to also thank the parties that have taken time to appear before us, the case by the National Assembly, and of course the very able representation of the Deputy President. Honorable Speaker, it is clear that the case by the National Assembly is not perfect. But I have agonized over some of the issues that have been raised by the National Assembly. And Honorable Speaker, allow me to begin with ground one, where the Deputy President is accused of violation of Articles 27(4), which, Honorable Speaker, makes it unconstitutional for you to discriminate on, among other grounds, Honorable Speaker, on the grounds of belief. Secondly, Honorable Speaker, there is also an express provision under Article 73 on the same, and Article 33(3)(d) that specifically deals with speech, Honorable Speaker, that constitutes advocacy for hatred on the basis of discrimination. Honorable Speaker, yesterday when I put this question to the legal team of the Deputy President, I was expecting a proper explanation, but of course, you all saw that they chose to throw snide remarks.
Senator Gataya and Senator Tabitha.
Please pause my time.
When Senator Tabitha, you're speaking,
pause my time.
Senators give you a pin drop silence. The same must be extended to the Senator for Nairobi City. Sit down, Senator Mofire. Proceed.
So, Honorable Chair, Honorable Speaker, yesterday when I put this question seeking clarification to the defense team, they chose instead to make snide remarks about appointments that have been made recently of members of my party, ODM. Honorable Speaker, I have agonized about some of the things that the Deputy President has said. In fact, in my entire time as an elected leader, I've met the Deputy President only once, and this is the second occasion when he was in the House. And both of them, honestly, were very sad events. The first one was a funeral, and these proceedings can also be likened to a political death if the House decides to impeach him. But Honorable Speaker, on that occasion, I did tell him to his face my position on some of the utterances that have come from him, that in fact, I strongly objected to those pronouncements. His legal team sought to hide behind these coalition agreements. I have agonized over what to do with an agreement, Honorable Speaker, that ousts the mandate of constitutional bodies. For instance, Honorable Speaker, you are told that in the agreement, positions that essentially are supposed to be available to all Kenyans through advertisement by the Public Service Commission, like permanent secretaries, have already been dished out. So what am I supposed to do with a contract that ousts the mandate of the PSC, a constitutional body? What am I supposed to do with a contract that ousts the mandate of this House, Honorable Speaker? For instance, to vote for the person who sits in the chair that you sit in. And if memory serves me right, Honorable Speaker, members who are not signatories to the coalition agreement of Kenya Kwanza, in fact, participated in voting for you to become the Speaker. And many of them were members of my political party, ODM, although, of course, I was not one of them. Honorable Speaker, there is a position in law about what to do with illegal and unconscionable contracts. I feel that the Deputy President wasted an opportunity to give clarification on his pronouncements, that, Honorable Speaker, he chooses to hide behind a contract that I consider unconstitutional is something that I have agonized over. Honorable Speaker, one of the questions that was posed to him is what, I remember a discussion about which is what are the strongholds of ANC and Ford Kenya. And somebody said that it is Western Kenya. Honorable Speaker, as SG of ODM, I know for a fact that Busia County is an ODM county. In fact, if you look at the statistics at the Register of Political Parties, the county with the highest membership in ODM is not Homa Bay or Siaya. It is actually Busia County. So the question I'm being asked by my members from Busia is, Honorable Speaker, if a member of ODM who resides in Busia wanted to be a permanent secretary, does he take his application to the local Ford Kenya office so that he can access the 30% for Western Kenya? And that is the agony, Honorable Speaker, that people are going through. Honorable Speaker, there was also the conversation around the public attacks on a judge. As a lawyer, as an advocate of the High Court, sworn to defend the Constitution. I agonize over what I'm supposed to do with public attacks on judicial officers, Honorable Speaker, people that I appear before seeking justice for my clients. Honorable Speaker, we have a discussion around also attacks on intelligence institutions in our country and the Director General of the Intelligence. Honorable Speaker, it was argued here that in fact, as a member of the National Security Council, the Deputy Speaker has a forum, the Deputy President has a forum to bring up.
Senator Karen Nyamu.
Thank you, Mr. Speaker. I can assure you, Mr. Speaker, none of us is enjoying these proceedings of an impeachment motion against the Deputy President, and particularly those of us from the government side, the Kenya Kwanza coalition. And for obvious reasons, Mr. Speaker, because he has been our leader, we have been in the trenches with him, fighting for this government. And so it has come to this, and I can assure you we are not particularly very excited about it. I personally have interacted with him on numerous occasions. If you look in the internet, Mr. Speaker, you will see photos of me dancing with the Deputy President, Mr. Speaker. I have followed these proceedings very keenly, all the 11 counts. One, the gross violations of the Constitution, Article 10(2), the one that talks about the conduct of public officials, including the Deputy President. The one that talks about him being a principal assistant of the President and an extension of the presidency, Article 147, that talks about his insubordination, and one that Sifuna has talked about, Article 160, that deals with undermining public institutions, and particularly the judges, Mr. Speaker. I have been born and grown up in Nairobi County, in Eastlands particularly. And where I come from, when we grow up, we are not even aware of each other's tribe. Our neighbor could be from any other tribe. And so when I hear the Deputy President talking and allocating shares to citizens, I am aware that he's excluding more than half the population of Nairobians from service delivery, the same people that me and Sifuna are always here fighting for, every day, for allocations and for services, Mr. Speaker. And as if that was not enough, he was in the CBD the other day, addressing Nairobians in the Kikuyu language, assuming that all Marikiti traders are Kikuyus. Mr. Speaker, nothing can be further from the truth. And sowing seeds of tribalism in Nairobi is very, very dangerous. If you have seen the slum setup, where people live together, all tribes together, I do not want to imagine if you sensitize these people and make them aware of their tribes and their lack of shares in their own country, Mr. Speaker. And finally, in future, I want to call upon presidential candidates to make it a very critical attribute of their running mates to have political maturity and to have a national outlook, Mr. Speaker. Because to some extent, we want to put some blame on the president, because we are wondering what he looked at when he picked his running mates. Thank you, Mr. Speaker.
Senator Kajwang.
Mr. Speaker, as I make my comments on this motion, I'd like to wish the Deputy President of the Republic of Kenya, Rigathi Gachagua, quick recovery. He is still the President of the Republic of Kenya as at 9:19 p.m. on the 17th of October until any decision is made. He's still the Deputy President of the Republic of Kenya. We pray that God gives him the strength and God gives him good health to continue pursuing that responsibility. Mr. Speaker, the Council for County Assembly began his opening statement and his National Assembly, that is the Venerable James Orengo, with a quote from Scripture. Mr. Speaker, allow me also to go to Scripture. And this time I will go to the book of John. In the book of John, chapter 8, we get the story of the adulterous woman. Mr. Speaker, Jesus Christ is teaching his disciples at the temple early in the morning, and the scribes and the Pharisees early in the morning drag a woman to his presence and say that this woman has been caught in the act of adultery. The Bible says that she has been caught, and I quote, in the very act of adultery. Mr. Speaker, what surprises me in this passage is that the woman who was caught in the very act of adultery has been produced, but the man who contributed to the adultery was not brought before Jesus Christ in the temple. Mr. Speaker, we have a man who has been brought before us for impeachment. We have been told that he's been a political adulterer. We have been told that he has grossly violated the Constitution and the laws of the Republic of Kenya. Mr. Speaker, adultery takes two. It takes two to tango. Like that woman in the book of John, I don't know whether they went for the men who cajoled her, who seduced her, who connived with her, and who paid her for the act of adultery. Mr. Speaker, in this Republic of Kenya, we must drain the swamp of adultery. And today, just like back in the days when the law of Moses required that a woman who had been convicted or accused of adultery ought to be stoned to death, unfortunately, Mr. Speaker, it looks like the same punishment was not prescribed for men. It was just for women to be stoned to death, and yet it takes a man for a woman to commit adultery. Tonight, because the Constitution of the Republic of Kenya is just like the law of Moses, it says if you are found guilty of political adultery, you should be stoned to political death. It is called impeachment. You are sent into political purgatory for 10 years. You cannot run for office. Mr. Speaker, we must deal with the law as is. The law as is requires us that the woman or the man accused of adultery must be stoned to death in this chamber. That is the law as it is. But Mr. Speaker, we must make sure that we bring those other men and women who commit and who encourage people to go into adultery so that they also face the same sentence and they also face the same judgment. Mr. Speaker, I am convinced that political adultery has been committed in the case before us. There has been a conversation about a dubious shareholding structure of the Republic of Kenya. If the Republic of Kenya was a corporation, as we have been told, or if it was a political party, then we would have 56 million equal shareholders from Moyale to Vanga, from Nyatike to Nyandiwa, from Bumala to Malaba. Mr. Speaker, it cannot be restricted to a geographical entity called a mountain. Mr. Speaker, I am convinced that political adultery has been committed in the intimidation and threats to judicial officers. I am convinced that political adultery has been committed in public attacks on our intelligence service. Mr. Speaker, where I come from, if you find your father naked, you don't proclaim his nakedness, you cover him. And we cannot then proclaim the nakedness of our intelligence service. Mr. Speaker, I am convinced that the Deputy Speaker has committed political adultery. Sorry, the Deputy President has committed... I am sorry, Deputy Speaker, has committed political adultery. And Mr. Speaker, for...
Your time is up. Your time is up, Senator Murango.
Asante sana mstahiki Spika. Kwanza ningetaka kumwombea afueni haraka naibu wa rais. Alafu niseme hivi. Mstahiki Spika, fisi anapotaka kula mtoto mwanawe husema kwamba ananuka kama mbuzi. Mstahiki Spika, mashtaka iliyo mbele yetu leo ni dhahiri shahiri ya kwamba ni fisi anayetaka kula mwanawe. Mstahiki Spika, wakati Mheshimiwa Karungu Adhangu alikuwa anaongea hapa leo na kuambia ombe msamaha, alikuwa amemwambia naibu mkurugenzi mkuu wa idara ya jinai kwamba anapojibu ajibu na wanao. Mstahiki Spika, mashtaka ambayo imekuwa hapa, kampuni zote zimekuwa hapa, zilikuwa nyingi, zilikuwa za watoto wake Rigathi Gachagua. Ama kweli chambilecho mkuki kwa nguruwe, kwa binadamu mchungu. Kwa sababu mstahiki Spika, hakuwezi kuwa na umbaguzi wa wanawe naibu rais, lakini kusiwe wale wengine wanapewa heshima tofauti na hiyo. Mstahiki Spika, mimi nimetoka Kirinyaga na najua mashtaka yote ambayo yako hapo 11. Kuna jambo moja ambalo mpaka ufanye kama utadhirisha mashtaka, na ni ushiriki wa umma ambao tuko na ushahidi mbele yetu. Mstahiki Spika, katika ushiriki wa umma ambao tuko na mbele yetu, isipokuwa picha za maofisi za CDF, alafu na takwimu ambazo zimetoka katika bunge la kitaifa, ambalo wale wote ambao walikuwa wametia sahihi kumondoa naibu ya rais ndio walioongoza katika ushiriki wa umma. Mstahiki Spika, ningeuliza itakuwaje, itawezekanaje mtu ambaye ametia sahihi kumondoa naibu wa rais halafu anaongoza katika ushiriki wa umma? Mbuzi atapata haki wapi katika mahakama ya fisi? Mstahiki Spika. Mstahiki Spika, ningetaka niseme ya kwamba ni rais kuangalia mashtaka na kuyaona kama inafaa kwa naibu wa rais ambaye ako hospitali. Najua ya kwamba naweza kuwa nimesimama hapa napoteza kuni nikichemsha mawe. Najua ya hivi. Lakini fisi alisema siku moja, hata aliambia mawe siku moja, hata kama hujaongea umesikia chenye nimesema. Mstahiki Spika, katika mashtaka yaliyo hapa, na sisi tunafaa kuongozwa na ushahidi, sio riwaya, sio hekaya za mbunwasi, sio fasihi. Mstahiki Spika, lakini tunazo hapa Mstahiki Spika, zote ni hekaya za mbunwasi. Hakuna ushahidi wote ambao tumepewa mbele yetu, lakini siwezi kusimama hapa halafu niweze kumhukumu naibu wa rais, kwa sababu pia katika kitabu ya Korosai 3 mstari wa 13 inasema ukihukumu wengine wa hukumu venye wewe utataka kuhukumiwa. Sasa Mstahiki Spika, itakuanje kwamba walioorodhesha mashtaka yaliyo hapa na kosa kuleta ushahidi tunafaa tuamini leo? Ni chuki ama ni uchungu gani ambao wako nao na naibu wa rais? Mstahiki Spika, unajua akuchukiae huwa anakuambia unamtifuria vumbi hata wakati unaogelea. Mstahiki Spika, mahali nilikotoka mimi nataka kitu ya kwanza kufanya ni kuwakilisha watu wangu, na waliniambia kwamba ushiriki wa umma ambao uko hapa hawakuhusishwa vilivyo, kwa sababu walioenda kule mashinani kufanya ushiriki wa umma walienda kufanya ushiriki wa umma wakijua matokeo yake. Mstahiki Spika, na kwa hivyo mimi nimeambiwa na watu wangu kutoka Kirinyaga yale mashtaka yote ambayo yamewekwa hapo, na kwa sababu tumekuchagua wewe uende pale utuwakilishe, tafadhali ukienda yote usikumbalie na hata moja. Mstahiki Spika, Mswahili usema lilompata peku na ungo ni lilo. Mstahiki Spika, wewe ni Mswahili, unajua kwamba ungo ni uteo ambao ni mpya, peku ni uteo, ungo ni uteo ambao ni mpya, peku ni uteo ambao unapepetea ambao ni mzee. Namwambia siku ya leo maseneta tukimhukumu naibu ya rais, yanayompata leo hata nyinyi mjue siku moja inaweza kuja ikampata, na ambaye atachukua msumari wa kwanza kumpigilia naibu wa rais, ningeomba kwamba asiwe ni mtu kutoka mlima. Huyu ni ndugu yetu, na kwa hivyo tunapokuja kumsurubisha katika msarambani, afadhali tuangalie akisurumbiwa, lakini mmoja wetu asichukue nyundo na msumari na nyundo kwenda kumsurumu. Mstahiki Spika, najua ya kwamba kuna wale ambao wanaelekeza vingine visivyo bwana. Mswahili usema usiwe vitatange kuwatosa wengine ndemani. Kama uko na msimamo tayari, usije ukapeleka mwenzako katika huo msimamo wako. Tunafaa kuzingatia ushahidi, tunafaa kuangalia kwa haki, kama maombi yetu ambayo tuko nayo katika Seneti, kwamba tutaangalia kila kitu kwa haki na uaminifu. Asante sana mstahiki Speaker.
Now, honorable senators, we had a consensus to terminate at 9:30. But again, breathe in and out. But again, I'm asking with your consensus if we can push it for another half an hour so that we terminate at 10. Is that okay? You know, honorable senators, we have to vote for 11 counts individually. So we will do an extra half an hour, then we terminate. The Honorable Olekina, Senator.
Thank you, Mr. Speaker. Mr. Speaker, this evening, let me disabuse this notion that an impeachment process is an attack of the mountain region. Mr. Speaker, an impeachment process is a vital process of holding public officers, state officers, accountable. Mr. Speaker, I've heard on various occasions from my colleagues, those who oppose this motion, that we are targeting the mountain. I beg to differ, and I do so with the following findings.
There is a lot of movement in the chamber,
Mr. Speaker.
Honorable senators, and Senator Olekina's. Let's take our seat, please. And let us hear the Honorable Senator in silence.
Thank you, Mr. Speaker. Let me begin again by saying I want to disabuse this notion that an impeachment, given the task to be able to hold public officers accountable. Today, we are discussing the impeachment of a deputy president. Tomorrow, we might be discussing the impeachment of a president. We have constantly debated impeachment of governors here. I've never had at one given time when people come up and say we are targeting a particular community. We are not, Mr. Speaker. Mr. Speaker, we have been entertained this afternoon or the last 2 days with the defense alleging that the shareholding utterances made by the deputy president is that he was referring to the shareholding of a coalition agreement. And Mr. Speaker, we were demonstrated here that the Kenya Kwanza coalition agreed upon how they can be able to share different, positions in government. In fact, I thought they would say that the Speaker of this House was also negotiated. I believe when the Speaker of this House was proposed to be voted for, he was voted for by all the senators. And never have I seen the Speaker giving preference to the people of the coastal region. So, Mr. Speaker, I find I'm not convinced by the defense that the shareholding being uttered by the Deputy President is based on a coalition agreement. Mr. Speaker, the defense attempted to respond to the allegation on ground 8, whereby they say that the utterances of the Deputy Speaker violate Section 132 of the Penal Code. It is important for us to know what Section 132 of the Penal Code says. It actually makes it illegal to utter, print, or publish words or acts that brings into contempt the lawful authority of a public officer. The decision made by Justice Esther Maina in her capacity as a judge of the High Court is protected by the position that she holds. So it is a bit unsensical for the Deputy President to go out in public, instead of following the due process of the law, to be able to go out and appeal the decision of that judge. Until today, Mr. Speaker, the coercion which was used to be able to return the 200 million shillings back to the Deputy President, that money must go back to the public. Mr. Speaker, the Deputy President has got a forum. Article 240 of the Constitution puts him as one of the key members in the National Security Council. He has got a forum to be able to go out there and express his dissatisfaction with the NIS. When he calls a press conference and outright says that the Director General of the National Intelligence has completely brought that service into a halt, he was exposing the secrets of this country, and what he was doing is that he was actually saying that we have got no control. Mr. Speaker, if for anything, today I'll cast my vote based on various issues. One, on shareholding. Two, on the violation of Section 132 of the Penal Code. Three, on the issues of coercion. I listened to the gentleman from Kempsett this afternoon when he said that he had to sit for hours at ESCC to be able to come out with one billboard. One. He was called on the 11th. When the defense were trying to justify that, instead of actually reading the recommendation made by the Senate, they were going through the submissions of one of the witnesses who appeared before my Committee of Health. So, Mr. Speaker, I'm convinced.
Senator Seki. The senator was elected by the people of Kajiado.
Thank you very much. Thank you very much, Honorable Speaker. I also want to put my voice to this motion of the proposal to removal of the Deputy President of the Republic of Kenya, Honorable Rigathi Gachagua, as a motion by Honorable Mutuse. I want to say that the grounds that has been put to this House from number 1 to number 11, Honorable Speaker, I thank the legal counsel of the Deputy President for interrogating the witnesses, more so Honorable Mutuse being the lead witness and the mover of the motion. Honorable Speaker, I want to put to this House that I am unable to see evidence that has been put in place for the 11 counts, 11 grounds in this motion. Honorable Mutuse was unable to demonstrate on issues that has been raised in this motion. Particularly, can go to 1 or 2, the motion or the counts 7 or charge 7, where the Deputy President was alleged to have a 5.2 billion within his assets within that small period of time. Honorable Speaker, I understand that this witness was not able to explain and demonstrate that the Honorable Deputy President got the 5.2 billion because of the contracts that he has done with the government. He wasn't able to demonstrate that this money, 5.2 billion, was received or was the Deputy President received because of this, from this company, from another company, or this other company. There was no evidence on this count. Honorable Speaker, the kind of impunity I've seen in the issue of listing 22 companies without evidence of what the track of the monies or funds that has been done or that has been used to demonstrate that these companies are what the track of the monies or funds that has been done or that has been used to demonstrate that these companies are doing business with government was not there. This is impunity of a high order. To bring 22 companies and you are unable, as a move of the motion, to explain that this company A, company 1 to company number 22 have received or got money from government or from government institutions. But you just put it on the motion and it becomes something to impeach the Deputy President. Honorable Speaker, we have seen where the Deputy President is alleged to have conspired with a company, Agro-Brick Investment Limited, where the control of State House, as an accounting officer of the State House, signed the contract, and it is brought to the motion that this contract and this company is alleged to have been a company to remove the Deputy President. Honorable Speaker, this House this afternoon received a report from the legal counsel of the Deputy President that the Deputy President is sick. Now, we are ready.
Senator Faki.
Asante Mheshimiwa Spika kwa kunipa fursa hii kuchangia mswada wa kumbandua naibu wa rais kutoka katika ofisi yake ya naibu wa rais wa Jamhuri ya Kenya. Mheshimiwa Spika, kwanza pia mimi nijiunge na wenzangu kumtakia afueni haraka naibu wa rais, kwa sababu tulikuwa ni matarajio yetu kwamba jioni ya leo angekuwa hapa kujitetea kwa madai kadha wa kadha ambao ameletewa katika bunge hili ili kuweza kutakasa jina lake. Mheshimiwa Spika, nimeweza kuangalia mashtaka yake 11 na baadhi ya mashtaka ambayo nimeona kuwa yamenigusa ni kwanza ni shtaka la kwanza ambapo ni kusema kuwa Kenya ina wenye hisa na kwake wenye hisa ni wale ambao walipigia kura Kenya Kwanza katika uchaguzi wa mwaka 2022. Mheshimiwa Spika, hiyo imebagua makabila zaidi ya 47 katika nchi yetu. Na sisi ambao tutatoka pwani, ambao kutoka mwanzo pwani ilikuwa si koloni ya Kenya, ilitupa mshtuko mkubwa kwa sababu tuliona kwamba tunazidi kutengwa katika mamlaka ya Jamhuri yetu ya Kenya. Mheshimiwa Spika, shtaka la pili ambalo limenibamba ni la kuhusu ukiukaji wa sheria, na hapa nitaangazia shtaka la pili na shtaka la 6 ambapo amekiuka sheria inayohusiana na uwiano katika nchi yetu ya Kenya na vile vile pia kuleta makabila na jamii zote pamoja. Mheshimiwa Spika, la 3 ni ukosefu wa nidhamu, swala la ukosefu wa nidhamu katika kumshambulia hadharani mkurugenzi wa shirika la ujasusi nchini mwetu. Mheshimiwa Spika, hili litokea mnamo tarehe 26 mwezi wa 6 mwaka huu ambapo naibu wa rais alikuwa Mombasa na akatoa taarifa ambazo vile vile pia hatua za kurekebisha zikachukuliwa. Mheshimiwa Spika, tunapoangalia makosa yote haya ni kwamba haya yasingeweza kumfika naibu wa rais kwa sasa, kwa sababu masuala haya ambayo yameangaziwa hapa yaliangaziwa na Senator Sifuna alipoleta mswada wake wa kumkosoa naibu wa rais, lakini mswada ule ulikufa ndani ya bunge hili la Senate. Mheshimiwa Spika, masuala ya ukiukaji wa kiapo haya, Mheshimiwa Spika, hayana nguvu kwa sababu wakati alipokuwa anaapishwa siku ya kwanza aliapa viapo viwili. Kwa hivyo hatujui ni kiapo kipi ambacho alikikeuka wakati Mheshimiwa Muthusi alipokuja hapa na kuzungumzia masuala hayo. Mheshimiwa Spika, nikimalizia nitamnukuu Senator Orengo aliposema kwamba katika bunge lililokwisha kwamba mapinduzi yanakula watoto wake. Kwa Kiingereza, revolutions eat their own children. Na hii tunaona kwamba mapinduzi yameanza kula watoto wa Kenya Kwanza, wakianza na mtoto mkubwa kabisa ambaye ni naibu wa rais. Kwa hivyo ni masuala ambayo yameendelea katika bunge hili. Bunge lililokwisha tuliona hapa Profesa Kindiki aliteta sana hapa, lakini vile vile mapinduzi yakamla. Kwa hivyo ni kwamba lazima tujenge siasa katika nchi yetu ambazo zitakuwa ni siasa za kusonga mbele. Tukichaguliwa kama viongozi, tuzungumze masuala ya kitaifa. Tusizungumze masuala ya vijijini mwetu, wakati sisi matarajio wa Kenya wote ni kwamba tunazungumzia masuala ya kitaifa. Kwa hiyo Mheshimiwa Spika, napongeza pia bunge hili la Senate kwa kuonesha ukakamavu na vile vile pia umahiri mkubwa wakati tumeweza kusikiza kesi ya naibu wa rais. Labda kwa siku za usoni tutapata pia fursa ya kusikiza kesi ya rais wa Jamhuri ya Kenya katika bunge hili letu. Asante Mheshimiwa Spika kwa kunipa fursa hii.
Senator Oroba.
Thank you, Mr. Speaker. First of all, I want to say that this is not about a relationship. It's not about a friendship that has deteriorated. I have been hearing people say, if it's about a relationship, if it's about a marriage that has broken, why don't they go back and make peace and come together? No, Mr. Speaker. These two individuals, His Excellency the President and the Deputy President, did not come together so that they can live happily ever after and have children, Mr. Speaker. They came together so that they could deliver development to the people of Kenya, Mr. Speaker. So this, what we have been doing here for hours and hours, it pains me when I hear people saying, about adultery and relationships and what, and I'm wondering, no. We have been here because of 11 counts, Mr. Speaker. A very serious impeachment motion because of not 2, not 3, but 11 counts, Mr. Speaker. In my condition, I have had to sit here and go through all 11 counts to understand which one actually has been substantiated and which one holds water. So no, this is not about a relationship. And we should not expect that because they came together, they should now go and sit somewhere and make peace now and stop disturbing us. No, Mr. Speaker. 11 counts of an impeachment motion is something very serious, Mr. Speaker. And it's very unfortunate that of the 11 counts, about 4 counts, Mr. Speaker, were not even substantiated, Mr. Speaker. Very shocking. When you have a team of legal experts sitting down bringing 11 counts, at the very least, they should have even substantiated 9, Mr. Speaker. But 4 counts, ground 2, when you talk about undermining a cabinet decision, how did we not have the witness come here to speak so that we can be able to understand? Some of us, we don't sit in cabinets, and we need to understand what a cabinet decision is, how it is undermined. Mr. Speaker, the witness was not produced. We had another witness who did not come here in terms of undermining devolution. Governor Sakaja signed an affidavit, but then did not appear, Mr. Speaker. People must respect the Senate, because when we are sitting here to analyze 11 counts, Mr. Speaker, honestly, in all fairness, they should at least be substantiated to some level. However, Mr. Speaker, I have lived through the post-election violence of 2007, 2008, and it is very strange that 2007 I was also pregnant, Mr. Speaker. And when I remember, Mr. Speaker, the things that triggered the post-election violence, Mr. Speaker, in 2008 of January, it was such utterances such as Musiguze Mlima, Mr. Speaker. They started as a joke, and before you knew it, matatus were being stopped and people were being asked, get off the matatu and showcase your IDs, and arms and limbs were being chopped off, Mr. Speaker. So we might think it is a joke, this shareholding narrative, Mr. Speaker, but having lived through that post-election violence. And I remember very well, Mr. Speaker, that I even had to choose the people who are operating, you know, on me in 2008 because I was afraid. You know, as Kisses, we love everyone. People always think we are traitors because we welcome everyone. So at that time, the attack on us was from both sides, Mr. Speaker. And so therefore, I do not take this shareholding narrative as a light thing. I do not take this Musiguze Mlima as a light thing, Mr. Speaker, because I have been affected directly. And on that count, Mr. Speaker, I definitely have seen that it has been substantiated. We have seen the evidence, and we have even seen repeated utterances of causing divisiveness in this country, Mr. Speaker. And I want to say today, Mr. Speaker, this country is not about one person. It is not about William Ruto. It is not about Rigathi Gachagua. This country is about the 50 million Kenyans who have to live in peace and under the national unity, Mr. Speaker. And for that reason, Mr. Speaker, I want to say that on that shareholding narrative, I hold my ground, and I will definitely vote that he should be impeached.
Senator Kavindu.
Thank you, Mr. Speaker, for giving me this opportunity. Let me start by telling His Excellency, the Deputy President of this country, Pole Sana, and we wish you a quick recovery. Two, Mr. Speaker, I want to quote a scripture which has been quoted here, John 8:7. Jesus told the people who took that woman before him, whoever has no sin to be the first to take the stone and throw at that woman. And when he bent down, when he came up, there was none of them. All the men had gone, only the woman was standing there. And he told her, go in peace, your sins have been forgiven. Mr. Speaker, when I talk like this, I'm saying that the other day we had the Deputy President publicly ask for forgiveness. And the Bible in the book of Matthew 14, Matthew 6, verse 14 and 15, says that if we don't forgive men their sins when they sin against us, our Heavenly Father will never forgive us our sins. And talking like this, Mr. Speaker, I want to say the mover of this motion, Honorable Mutuse, could not substantiate the allegations. He was asked questions, and people even outside on media are laughing and asking what kind of a lawyer is he, because he could not answer many of the questions, because I think he was not aware of what of the motion. To me, it seemed like it was drafted by somebody else and he was given just to table it. Mr. Speaker, I want to say, even the last speech of the National Assembly, they said on impeachment, it is not necessary or important to substantiate every allegation and even to make sure that you have all the evidence of the allegations, because this is not like court. And I thought, as a Senate, we sit here as a court. And whatever ruling we give here is acceptable. And so I wonder why one would stand and say that they could not, it is not a must that they substantiate beyond reasonable doubt. I believe if we are impeaching a person, we should, all the accusations must be substantiated and beyond reasonable doubt, because that is one's career we are about maybe to ruin. And this person has a family. This person has a career. When I think of Waititu, when I think of Songo, for 10 good years, they cannot stand on any elective office. And
Order,
I had...
Honorable Senators. Senator Methu, you are heard in silence. Senator Fonandi, you are heard in silence.
Thank you, Mr.
Extend
Speaker.
the same treatment to Senator Kavindri.
Thank you, Mr. Speaker. And Mr. Speaker, it was just the other day I had Majority Leader and many of us here say that Songo was impeached for no good reason. How do we reverse what we have already done on this, in this Senate? So, Mr. Speaker, I want to say, before we impeach anyone, we must substantiate all the charges and make sure that it is not something that we are going to eat back our words and start saying we did a mistake. Mr. Speaker, I stand here to say no to this motion.
Senator Kathure Murungi.
Thank you, Honorable Speaker, for this opportunity also to make some comments, one or two comments on this important exercise. Mr. Speaker, many Kenyans are wondering why the Deputy President is being impeached. And they are saying if he is to be impeached, him and the President should be impeached at the same time. Mr. Speaker, the articles in the Constitution, our Constitution has given the National Assembly and the Senate this mandate to do this exercise of checks and balances to our public officers. And Mr. Speaker, Article 145, which we used this afternoon even to determine whether to proceed or not, is very elaborate on how to the process of impeaching the Deputy President or the President. So, Mr. Speaker, we are here because the Senate actually has been, on several occasions, we have brought deputy governors, and now the Deputy President. Mr. Speaker, kindly protect me from this. Honorable Speaker, Mr. Speaker, kindly protect me from some noise from behind.
Senator Fonandi.
So, Mr. Speaker, I was saying...
Just move to your seat, your normal seat.
I was trying to say that, Mr. Speaker...
It may be lonely, but please stick there. Proceed.
Mr. Speaker, this House has brought deputy governors, and now the Deputy President. Mr. Speaker, what we are doing is a constitutional mandate. And therefore, I will ask Kenyans that they should bear with the Constitution. It is the Constitution which has brought us where we are. I want to thank the parties that were here for the last 2 days, the parties representing the Deputy President and the parties representing the National Assembly, Mr. Speaker. All these senators have been sitting as judges for the last 2 days and nights. And Mr. Speaker, it is only that this is a court, like a high court. Only that judges in the high court or the courts do not discuss the cases that they handle, but they meet and discuss, and then they make the decision. And then the decision is led by maybe the president of the court. But because now we make a decision through a vote, that is why, Mr. Speaker, we find ourselves here. And this evening, these jurists will make their decision in one or the other. And Mr. Speaker, what I would request Kenyans from today, whatever decision will be made to maintain peace, love, and unity, as was envisaged since independence in 1963. Because, Mr. Speaker, where we are, a decision will be made by the Senate in one way or the other, either to impeach the Deputy President or to appoint, or not to impeach, not to impeach, Mr. Speaker. And I want to talk to the people that represent the Meru community. I want to assure them that whatever decision their senator will make is for the best interest of the Meru people. And I want to assure them that their future will be bright, if not more bright, Mr. Speaker. And what they need is service delivery, not individuals. Whatever decision that I'll make is for their best interest, because they elected me to make some decisions. Some are soft decisions or hard decisions. But what they need at the end of the day, they will ask their senator for 5 years, what have you done for us? But as I finish, Mr. Speaker, I want to encourage all of us in a verse from the Bible, Thessalonians chapter 5, verse 18, which says that in every situation, no matter what the circumstances, be thankful and continually give thanks to God. For this is the will of God for you in Christ Jesus. So whatever you do, thank God. Whatever happens to you, thank God, because we always should give thanks to God. Thank you very much, Mr. Speaker.
Senator Christo Lasige.
Speaker, the Parliament of Kenya has gone through a great deal in a very short amount of time, many firsts, and it is utterly painful for me to know that the world keeps seeing us time and time again under such lugubrious circumstances. However, Speaker, it has taught me many, many lessons, and it's also reminded me of many that I've known for several years, one of which I was taught by Tony Evans, which is, if all you see is what you see, then you don't see all there is to be seen. Speaker, I have never met the Deputy President. In fact, in the last 2 days, the first time we've ever shared any space together. And to be honest, I don't think that we have much in common. I personally feel like there is a lot to be desired in his leadership style, for me personally. However, instead of going to the Bible, I want to go instead into my own experience and draw some parallels. Mr. Speaker, of course, people know that I have glaucoma, and I've been fighting and battling it for several years of my life. And Speaker, when I first got my diagnosis when I was just a teenager in high school, I was told that it was imminent. There was no running away from my condition. And I didn't know at the time that I had anything that was going on. I was just going about my life, but inside of me and around me, there was a condition that was building up and building up and building up, and I had no idea what was going to happen in the future. Mr. Speaker, now I've been left blind, and I cannot see in front of me even when I put my hand in front of my face. Mr. Speaker, the parallels I draw with my life and the current hearing that we are sitting in today is that the Deputy President did not foresee this happening to him either. Mr. Speaker, I have also drawn parallels of feeling out of control, which I assume that he feels. Being given a diagnosis that seems imminent, that he cannot stop. Mr. Speaker, I also feel that he is probably feeling fear. That's what I've heard. Mr. Speaker, feeling betrayed, feeling angry. And I felt all those feelings because of a situation that I can draw parallels with in this hearing. And Mr. Speaker, I have been fighting and fighting, pleading and praying, trying everything in my power to mitigate, to stop, just like he has been doing in the last several weeks that this has been going on, Speaker. And it's funny that it's Blindness Awareness Month this month in October, because there are many lessons, like I said, that I have learned, and I wish that the public will also take from this experience. Mr. Speaker, I hope that the public understands that when they have their back to the wall, when they've been in any kind of battle, even when they feel isolated, there is something called golfer's elbow, which I learned. Golfer's elbow is the idea that, or is a condition that golfers usually have when they hold on to the grip of their club too tight for a long period of time, and they end up injuring their wrist all the way up to their elbow because they're holding on too tight to an outcome, too tightly. And I've learned that sometimes you just have to let that go. And I hope that the public can take that away from this situation. Mr. Speaker, we must move away from hegemony, the idea of being dominated by one group or a person or a company or a state, because we are a democratic republic, and we need to move away from such ideology, such utterances, such behavior, Mr. Speaker. However, in the 11 counts, I have seen many that have no evidence, and I've seen some that do have some evidence. But I have not been particularly given confidence by the witness-in-chief, the mover of this motion, when I saw him up on the stand, Mr. Speaker. Although none of us can relate to what it's like to being a deputy president in this room for sure, we can definitely relate to the lessons that I've just mentioned. Mr. Speaker, make decisions today that will not betray you tomorrow. That's one. I also want to share that even though you're in a battle, whatever that might be, financial, personal, medical, whatever it is that you're going through at the moment, and you feel like your back is on the wall and everything, all the odds are against you, remember that it gets better. You do better. You will experience better. And we will become better, Mr. Speaker. I will finish, and I hope that the senators will remember what I said to them yesterday from the Bible, Proverbs 17:15.
Senator Newto.
Mr. Speaker, thank you very much, Mr. Speaker. I think I cannot thank you more for affording me this opportunity at this late hour. Mr. Speaker, I stand right from the onset to say that I oppose this particular motion, Mr. Speaker, and I have reasons for doing so. Mr. Speaker, the key witness or the mover of the motion came before this House yesterday, Mr. Speaker. And although I'm not a lawyer, but I know that it is there in the rules of natural justice that whoever alleges must prove. The Honorable Mutuse was not able to prove any of the allegations or any of the grounds that he laid against His Excellency the Deputy President, Mr. Speaker. Mr. Speaker, Kenyans were and are watching these proceedings. They were able to see the cross-examination and to hear the cross-examination of the Honorable Mutuse, Mr. Speaker. And I want to urge this House, Mr. Speaker, that if we want to uphold the dignity and the honor of this House, that Kenyans were and are still watching, you cannot impeach the Deputy President of the Republic of Kenya, Mr. Speaker, on allegations, on grounds that were not able to, that the mover was not able to prove, Mr. Speaker. And that is what prompted the question, I think, by Senator Wambua, which later was asked by Senator Wakia Umtata, which you were able to stand down because it had already been asked, whose motion was Mutuse's? Because it was not his motion. He had no proof of any or for any of the allegations, Mr. Speaker, and that is why this House, in order for us to uphold, like I've said, the dignity and honor, we need to vote no to this motion, Mr. Speaker. Mr. Speaker, many that have spoken before me have talked about the woman, the adulterous woman that was caught in the Bible. Senator Kajwang put it even better, that they did not bring the man that she was caught in the act with. Mr. Speaker, we need to ask ourselves, how good are we? How clean are we? Are we qualified to throw the first stone, Mr. Speaker? I think that is the first question that we should ask ourselves, that as we judge the Deputy President, how good are we? How many mistakes, how many offenses have we ever committed? How many sins even have we ever committed? And God forgive us, and our fellow human beings also forgive us, Mr. Speaker. But the most moving thing, Mr. Speaker, is that we did not give the Deputy President an opportunity. I know, of course, the motion to defer this particular, to adjourn up to Saturday did not pass. But, Mr. Speaker, under Section 50 of our Constitution, Mr. Speaker, we, 50-0, Mr. Speaker, we need to give any person, 50-0, that is 50, Mr. Speaker, 2F, to be present and when being tried, unless the conduct of the accused person makes it impossible for the trial to proceed. Mr. Speaker, the Deputy President was taken ill, according to what the council reported to this House. And, Mr. Speaker, we did not give him an opportunity. Mr. Speaker, I draw your attention also to our Constitution, Article 145, Clause 5, the President shall have the right to appear and, not or, and be represented before the special committee, Mr. Speaker. We did not give him that opportunity. Mr. Speaker, because I can see my time is wearing out, if not for anything, Mr. Speaker, I ask this House, you cannot condemn a sick person. Any one of us can get sick. I want to appeal to my colleagues, Mr. Speaker. Nobody chooses when to get sick and when to be in good health. We cannot afford to judge a person, to condemn a person when they are in hospital, Mr. Speaker. And so I want to appeal to the members of this House that if not for anything else, you consider that the Deputy President has been taken ill and show the necessary compassion. And Mr. Speaker, I want to, my majority leader is here, and he made a statement that was very disturbing, that even those that are saying that it can bring division should...
Senator Mogeni.
Mr. Speaker, sir, first on my own behalf and on behalf of the people of the great county of Nyamira, I want to send a message of quick recovery to His Excellency President Rigathi, and we wish him a speedy recovery. Mr. Speaker, the Bible says in the book of Ecclesiastes 3, verse 1, that there is a season for everything. There is a season to be born politically and a season to die politically. That's biblical. The Speaker, I've agonized. Mr. Speaker, I've gone through a lot of soul searching. Mr. Speaker, as I listened to the evidence that was tendered against, as I listened, Mr. Speaker.
Just pause the time for Senator Mogeni. Let us allow Senator Mogeni to be heard in total silence, please.
As a lawyer and a person who witnessed the birth of the 2010 Constitution, Mr. Speaker, I strongly believe, Mr. Speaker, that Kenya belongs to all the 42 plus tribes, Mr. Speaker. And what has disturbed me, Mr. Speaker, for the 2 days I've sat here, Mr. Speaker, what would happen to my community in Kisii and in Nyamira if we ran our government through this theory of shareholding? Mr. Speaker, as I speak tonight, Mr. Speaker, the people of the two counties of Omogusi, Nyamira and Kisii are victims of that theory of shareholding. That community, Mr. Speaker, called Omogusi, has got no even a single PS serving in government, Mr. Speaker. Mr. Speaker, as we speak this evening, Mr. Speaker, the Omogusi people, Mr. Speaker, have been the biggest victims of this theory of shareholding. Mr. Speaker, the Constitution that we enacted in 2010, in Article 27, Mr. Speaker, clearly states that we should not discriminate, Mr. Speaker. I hope, Mr. Speaker, when I cast my vote tonight, I'll be sending a message from the people of Nyamira, Mr. Speaker, that a government is formed for all the tribes in the Republic of Kenya, Mr. Speaker. I've agonized, Mr. Speaker, on the issues that have been brought in this motion, touching on the widow and the children of the late Governor for Nyeri, Gachagua. And Mr. Speaker, I wondered if adverse statements and inferences have been made touching on the conduct of the Deputy President against the widow of the former governor and the children of the late governor, the nephews of the Deputy President. Why, Mr. Speaker, I ask as a father, why, Mr. Speaker, did the widow and the children of the late Governor Gachagua swear an affidavit to dispel all the things that have been said against a scheme of swindling those children? Why, Mr. Speaker? Why didn't they swear an affidavit, Mr. Speaker? That has troubled me a lot. And as I cast my vote tonight, Mr. Speaker, I'll be casting my vote for those children who lost their mother, who lost their father, but who were not given an opportunity, Mr. Speaker, to appear before this House and tell us, Mr. Speaker, that there has not been any wrongdoing from the deputy president to those children. Count number 1, count number 8 is about the utterances that were made by the deputy speaker. I hope, Mr. Speaker, that the person who will occupy that coveted position of deputy president will reflect on what John says in chapter 3, verse 5. Mr. Speaker, the Bible says that the tongue is a small part of the body, but the tongue is also fire, and it's a world of evil among parts of the body. If the deputy president had checked his utterances, Mr. Speaker, perhaps we will not be having this motion this evening. So, as we vote tonight, Mr. Speaker, let's also learn. Let's also learn from what the tongue has done to Honorable Gachagua. I will vote, Mr. Speaker, where I'm convinced that allegations against the deputy president have been proved. I reserve my vote to be cast at the right time.
Senator Boni.
Thank you, Mr. Speaker. Mr. Speaker, the position of the Deputy President of Kenya is very high. It is a very high calling. And therefore, Mr. Speaker, as we make a decision on the Deputy President of Kenya, I want to remind him that of those to whom more is given, indeed, more is expected of them. And he should not feel that he is being victimized because, Mr. Speaker, the highest standard of this Constitution in 2013, by dint of lack of integrity, the Deputy Chief Justice, Nancy Barasa, lost her job merely because she pinched the nose of Kwamboka. The Deputy President indeed did worse than pinching the nose of somebody. Mr. Speaker, the Deputy President, seeing the allegations against him, I can't imagine that he moves around with the moninga of man of faith and truthful man. Mr. Speaker, if really we must talk about faith, may I remind the Deputy President of a man of faith, a man of letters called Bill Paul. Bill Paul said, man of faith, that integrity is like virginity. You lose it only once. And when you lose it, you can never get it back. The Deputy President has lost that virginity of leadership. Mr. Speaker, coming from a community that paid for the price of inflammatory speeches in Likoni, in Molo, and in Trans Nzoia, if I had time, I would discuss what some of my relatives went through, including Pastor Liai from Ichina village. Mr. Speaker, during the tribal clashes of 1992 and 1997. I would like to remind the Deputy President of the post-election violence of 2007, 2008. One of the reasons why we had to have this progressive constitution that will be removing him, hopefully, this evening from office. Mr. Speaker, even as we ask the Deputy President to leave office, we must insist that the DCI and the ESCC and other investigative institutions must pursue this matter beyond this vote. I have on mind, Mr. Speaker, the activities of the intricate web
of companies, up to 22, so to speak. The reason I believe young Mutuse could not bring all this, dear senators, colleagues, is because effort requires money, requires time to do all that research. Some of them you have to do clandestine for you to get information. I believe that if the deputy president had taken the dog, we were going to completely undress him. We would have asked him to justify what activities each and every one of those companies was doing. It's part of the reason why he stepped down, Mr. Speaker. Mr. Speaker, I have evidence, which I don't wish to be part of the case, that as soon as the deputy president's brother died, the wife went to the corporate branch of the cooperative bank and started crying there that the manager should stop the deputy president from operating these accounts. Mr. Speaker, finally, the deputy president must be investigated for the role.
Senator Eddy.
Mr. Speaker, I thank you, and I recognize the pressure of time. Mr. Speaker, I am here because of the kindness of the people of Migori County who sent me here that at such a time, Mr. Speaker, I need to be cautious of the Article 125 of the Constitution, which requires us as a House that in matters such as this, Mr. Speaker, we must behave like judges, because under Article 125 of the Constitution, Mr. Speaker, we sit as a high court, Mr. Speaker. And in the words of Socrates, Mr. Speaker, a judge is required to listen courteously, to answer wisely, to consider soberly, and definitely to decide impartially, Mr. Speaker. There were 11 charges, Mr. Speaker, that were put before us, Mr. Speaker, and they were put to us in the context of Constitution 2010, Mr. Speaker. The Constitution 2010, Mr. Speaker, came in the backdrop of two very important historic moments in this country, Mr. Speaker, that I must reflect on, Mr. Speaker. Number one, Mr. Speaker, is the section paper number 10 of 1965, Mr. Speaker. That section paper number 10, Mr. Speaker, divided this country into those who are important and those who are not important. The language that was used then, Mr. Speaker, was the idea of northern frontier district, Mr. Speaker, that then discriminated upon some communities, Mr. Speaker, against others, Mr. Speaker. Number two, Mr. Speaker, in 2007, Mr. Speaker, this country was divided on the basis of ethnicity, Mr. Speaker. And therefore, I rise to support this motion if my grounds, Mr. Speaker, after listening courteously and considering soberly, Mr. Speaker, are more than half of the charges, Mr. Speaker. And I find that ground 1, 5, and 6 on the utterances of the deputy president, Mr. Speaker, violate Article 91 of the Constitution and Article 232 of the Constitution. We cannot have political parties, Mr. Speaker, that are founded on the basis of ethnicity and dividing national resources on the basis of ethnicity, Mr. Speaker. Number two, Mr. Speaker, that would make the ground number 4, which actually also happened to be reason number 4 for why the deputy president must leave office, Mr. Speaker, the violation of Article 160 of the Constitution, Mr. Speaker, of undermining the judiciary, Mr. Speaker. There was an imminent threat to the judges there, Mr. Speaker. You realize that in my judgment, Mr. Speaker, I excuse ground number 8 on the basis of the fact that there was no proof that there was a petition that was not filed, Mr. Speaker. But on the threat, Mr. Speaker, I think that the Deputy President stands impeached, Mr. Speaker. Ground number 9, Mr. Speaker, on NIS, Mr. Speaker. We know that this country has faced serious terror attacks, Mr. Speaker. And the moment the Deputy President, Mr. Speaker, showcases the secrecy of deficiency in our security infrastructure, Mr. Speaker, and you know that under Article 240 he has platforms to be able to express himself, Mr. Speaker, it is a violation of the Constitution, Mr. Speaker. Lastly, on ground number 11, Mr. Speaker, on bullying KEMSA official, Mr. Speaker, it has been proven here beyond reasonable doubt, Mr. Speaker, that the Deputy President is not a member of the company that was listed. He's not an employee of that company, Mr. Speaker, yet he goes ahead and makes calls on behalf of that company, Mr. Speaker. That is impeachable. Lastly, Mr. Speaker, I must call the Council of the Deputy President to order, Mr. Speaker, especially Council Paul Muite, Mr. Speaker, for actually practicing law in deceit, Mr. Speaker. You cannot say that at the level of the Deputy President, Mr. Speaker, he was okay in this house the entire time, and then when asked, you are saying you cannot be able to account for his whereabouts, and you know that the Deputy President, Mr. Speaker, also must be able to be taken care of by the DG of Health, Mr. Speaker, who could have given us a document to be able to substantiate whether the Deputy President is sick, Mr. Speaker. While I say sorry to the Deputy President, Mr. Speaker, I think this kind of deceit should also be tantamount to further impeachment, Mr. Speaker. I do therefore say that on ground 2, 3, 7, 8, and 10, they are not substantiated. But on ground 1, 5, 6, 4, 9, and 11, Mr. Speaker, this is a fight against tribalism that is done by one individual that then we must...
Senator Osotsi, unfortunately, you only have 4 minutes because we terminate at exactly 10:30.
Thank you, Mr. Speaker. Mr. Speaker, I'll be so quick. Mr. Speaker, when the Deputy President was here, I remembered the saying of a famous philosopher, 19th century, Lord Acton, who said, power tends to corrupt, and absolute power corrupts absolutely. Mr. Speaker, a few of us here served with the Deputy President in the National Assembly. And when we were there in the National Assembly, the Deputy President was a very humble man, very simple, very social, and was rare to talk. But listening to the judges and having seen what has been happening around, this is not the same man. This is a different man. So indeed, I want to agree with this philosopher that power tends to corrupt and absolute power corrupts absolutely. And this is, it may affect all of us here. So there is something we need to learn from what has happened today. Mr. Speaker, I also want to congratulate the members here for their decency and maturity in conducting a fair trial. Mr. Speaker, it is not true that the Deputy President has not been given a hearing. We had to adjourn this House for 2 hours to wait for the witness to come. He didn't come. And Mr. Speaker, you know that the tradition of this House, that sometimes we receive written submissions. We do that in our committees. We do that in public participation. So the members who are saying that he was not given a fair hearing is that is not true, because this House tried as much as possible to get the Deputy President to come. Mr. Speaker, a lot has been said about various laws and articles of the Constitution that the Deputy President has violated. But one important article of the Constitution that runs through all the charges, Mr. Speaker, is Article 131 of the Constitution, which read together with Article 147, clearly says that the Deputy President is a symbol of national unity. That is not the case, Mr. Speaker. Mr. Speaker, if you go ahead, Article 131(2) says that the Deputy President, by dint of Article 147, should respect and uphold and safeguard the Constitution. That is not the case. The Deputy President should promote and enhance the unity of the nation. That is not the case. The Deputy President should promote respect for diversity of the people and communities in Kenya. Mr. Speaker, that is not the case. So if there is any piece of law that is going to send the Deputy President home, is clear violation of Article 131 of the Constitution, because the Deputy President is a principal assistant to the President and therefore exercises powers of the President as per Article 131 of the Constitution. Mr. Speaker, if there is one charge, because we have 11 charges, that is going to send the Deputy President home, it's charge number 1. I listened to the evidence that was brought here by his counsel. That evidence of the coalition agreement of Kenya Kwanza was not sufficient, was not convincing. And in fact, Mr. Speaker, the Deputy President conveniently hid for...
Your time is up. Majority Leader, you may now move to reply.
Mr. Speaker, sir, I beg to hereby reply, having listened to the contributions of my colleagues on this very important motion on trial by impeachment of the Deputy President, Honorable Rigathi Gachagua. I want to thank colleagues that have taken time to give their views, both in support and those opposing this motion, because that's how you grow a democracy, Mr. Speaker. We may not all have to agree on the same subject matter, Mr. Speaker, but the chance to even speak and say what you feel about an issue is an important attribute. Indeed, Mr. Speaker, I agree with the contribution that was made by one of the advocates for the Assembly, that comparing what you're doing today with previously what used to happen, where in the 1 o'clock news, vice presidents will be changed without any notice. And the elaborate process, Mr. Speaker, that we have gone through up to this point is great for our country. Mr. Speaker, I appreciate the National Assembly, the team of the Deputy President, Mr. Speaker, that has presented us with information to help us make a fair judgment of this case. Mr. Speaker, I strongly disagree with those that hold the view that the Senate hasn't been as fair to the Deputy President as perhaps they would have expected. To the best of my knowledge, Mr. Speaker, I think as a House, we did the best that was within our means. We granted the opportunity, was given sufficient notice, Mr. Speaker. It is only in the unfortunate circumstance of this afternoon where he was taken ill, Mr. Speaker, and I'd wish to take this time to extend my message of goodwill to him and wish that he can quickly recover and get on with his other duties, Mr. Speaker, both as a human being and should, whichever way this vote goes, Mr. Speaker, because it's not in my hands, but in the hands of the 67 jury that are here, Mr. Speaker, that he shall continue to thrive. I wish him well, Mr. Speaker. Like I observed earlier, this is a friend, and friends wish each other well under all circumstances. Mr. Speaker, you know, just as a final thought, I thought about the journey of the Deputy President and the tribulations that have occurred to him as occurrence to either his conduct or utterances. And I'm reminded of a book I once read, Mr. Speaker, by Senegalese satirist Osman Sembene, a book called Hala, where, Mr. Speaker, a very rich businessman by the name El Haji looks and desires a beautiful young lady by the name Ngone, and finally takes her in as a third wife. Unfortunately, on the same night that he marries her, he develops erectile dysfunction, Mr. Speaker, and is not able to consummate the marriage. Sometimes in life, Mr. Speaker, when you fall down, you have to prepare to get down before you eventually can rise up, Mr. Speaker. I do hope, Mr. Speaker, that even in this particular process, the Deputy President will emerge stronger, better, as a human being, as a leader, and that there can be better days ahead for him. With those very many remarks, Mr. Speaker, I beg to reply and wish that our colleagues in this House make a decision in the best interest of the country. I thank you, Mr. Speaker.
Thank you. Now, honorable senators, these are the guidelines on how we're going to move forward. One, all honorable senators are eligible to cast their votes. Secondly, the threshold is 45 senators. So there ought to be 45 senators in the chamber. And we are going to vote for the charges separately. So we're going to vote 11 times. I now direct that the bell be rung for 2 minutes.
Good evening. These are live proceedings from the Senate chambers, and the senators are done debating the motion that was moved for the removal from office by impeachment . You're watching live pictures from the Senate, where debate has been concluded. Good evening. You are watching live pictures from the Senate chambers, and the senators are done debating the motion that was moved seeking the removal from office by impeachment the Deputy President of the Republic of Kenya, and now they are preparing to take a vote on the 11 charges that were brought forward against the Deputy President. Charge 1, gross violation of Articles 10, Sub-Article 2A and B and C, Article 27, Sub-Article 4, Article 73, Sub-Article 1A and 2B, Article 75, Sub-Article 1C,
Clerk, has the bell stopped ringing? Sergeant at Arms, kindly close the doors and draw the bar. Clerk, can you do a head count to confirm that we have a minimum of 45 senators in the House? Order, honorable senators. Majority Leader, you may take your seat. Now, honorable senators, we are moving to division. I will first put the question. Voting shall be electronically, and we shall be voting on separate charges. So we're going to vote 11 times this evening. I'll proceed to put the question. Honorable senators that are aware that the National Assembly on the 8th of October 2024 resolved, with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution, and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into brackets 25, dated the 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. Further, whereas pursuant to Article 145, as read with Article 150, 1B and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 150, 1B and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on the grounds of his proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, therefore, pursuant to Article 145, as read with Article 150, 1B and 2 of the Constitution, and Standing Order 78 and 79 of the Senate Standing Orders, the Senate resolves to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on the following grounds. 1. Gross violation of Articles 10, 2A, B and C, 27(4), 73(1)A and 2B, 75(1)C and 129(2) of the Constitution, and Article 147(1), as read together with Article 131(2)(c) and D of the Constitution. 2, gross violation of Article 147(1) and 152(1) of the Constitution by undermining the President and the Cabinet and the effective discharge of the national government's executive mandates. Number 3, gross violation of Article 6(2), 10(2)(a), 174, 186(1), 189(1), and the fourth schedule to the Constitution by undermining devolution. Number 4, gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. Number 5, gross violation of Articles 3(1) and 148(5)(a) of the Constitution on the fidelity to the oath of office and allegiance. Number 6, serious reason to believe that His Excellency the Deputy President has committed crimes under Section 13(1)(a) and 62 of the National Cohesion and Integration Act. Number 7, serious reason to believe that His Excellency the Deputy President has committed gross economic crimes under Sections 45(1), 46, 47(a)(3), and 48(1) of the Anti-Corruption and Economic Crimes Act, and Sections 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. Number 8, serious reasons to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, defensive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Number 9, gross misconduct that is incompatible with the high calling and dignified status of the office of the Deputy President and a member of the Cabinet and the National Security Council. His Excellency, the Deputy President has publicly attacked and undermined the work of the National Security Intelligence Service and its officers. Number 10, gross misconduct by openly or publicly insubordinating the President, who is the head of state and government. And number 11, gross misconduct by persistently bullying state and public officers. As I've already indicated, honorable senators, voting shall be done electronically. So at this juncture, I will ask honorable senators to pull your cards out of the delegate unit. Sergeant at Arms, kindly go around and pick all the unattended delegate cards. Sergeant at Arms, if you're done collecting the unattended cards, we're good. Now, honorable senators, you may log in back. As indicated earlier, we'll be casting our votes 11 times. So the vote you're going to cast at the moment is for charge allegation number 1, which is gross violation of Articles 10(2)(a), B, and C, 27(4). I had already read it out. So from this moment, it's beamed on the screens. So honorable senators, once you've logged in, you may now proceed to vote. Senator Tabitha Keroche, may you move to dispatch and get some assistance. We're now going to allegation number 2. It's been beamed on the screen. You may now vote. We shall now move to ground number 3, allegation number 3. Can you beam it? There we are. Honorable Senators, you may now proceed to vote on allegation number 3. We are now going to allegation number 4. Let it be beamed on the screen. Honorable Senators, you may now proceed to vote on ground number 4. Honorable Senators, we are now moving to vote on charge number 5. You may now proceed to vote on charge number 5. Honorable Senators, we are now moving to allegation number 6. Honorable Senators, you may now proceed to vote on allegation number 6.
Ladies and gentlemen, the scenes that you view on your screen right now are absolutely unprecedented. The last 72 hours have been historic in our country. We are witnessing scenes that no one ever imagined, or perhaps only imagined, but now we're witnessing them live and direct from the Senate. Folks, the Deputy President, Rigathi Jeffrey Gachagua, stands impeached. The voting is still going on, but by the look of things, it is done. After a long period of debate, a long period of accusations and counter-accusations, a long period of defenses, and counter defenses, the Senate has voted to impeach the Deputy President. Earlier on, you will be glad to remember that the Deputy President failed to appear in the afternoon session of the Senate, where he was expected to be cross-examined in a session similar to what happened to the mover of the motion, that is the Honourable Member for Kibwezi West, Mwengi Mutuse. Yesterday, the Deputy President failed to appear before the Senate this afternoon, and soon after we were informed that his disappearance was due to an ailment that occurred rather suddenly. And after that, political intrigue, legal intrigue ensued, and we were informed that he will indeed not be showing up today, and matters changed to be a matter of discussion as to when actually the hearings or the sittings should be adjourned to. The Deputy President's team, of course, adopting and advocating for Tuesday, but of course the National Assembly team, as well as a decent number of senators, pushing for that decision to be made today to continue. Consider, of course, that this process was time-bound by the Constitution. The absolute latest time that this decision needed to be made was on Saturday, which was different from what the Deputy President's defense team was advocating for, and it led to them opting to walk out of the session, ostensibly to hear from their client, but effectively to depart from the sittings, leaving the senators to decide all by themselves. Folks, count 7 out of 11 is currently on your screen. It's being voted upon. And as you have been able to see, the voting is happening electronically. You can see every senator appending their vote to each of these charges. And as we speak right now, count 7 out of 11, it looks as if by far the majority have voted to impeach the Deputy President. What next? That's your question as well as mine. We will assuredly line up a strong contingent of opinion leaders and experts in all our subsequent broadcasts to be able to inform you, good people, of what exactly this means. These are unprecedented times. We have impeached governors, deputy governors, but never in this country have we impeached deputy presidents. The Senate is now moving to ground number 8. You can see the scenes playing out right in front of your screens, and we are able to even see the tablet, the computer readout with the voting tally as it comes in. Once again, folks, we've never impeached a deputy president before. This is almost unheard of, even on the continent of Africa, and has only happened a handful of times across the world. We are setting precedents in a way that has never been seen before. Believe it or not, you are on the front seat witnessing history right here from the home of Untold Stories, TV 47. Ladies and gentlemen, the battle is by no means over. By all indications from the defense of the Deputy President, legal efforts, petitions are already underway. Up to 30 by this afternoon, the count of 30 by this afternoon, all across the country in different courts, different petitions, seeking to have a say in this matter, this historic matter. The names of the ladies and gentlemen that are voting right now will forever be etched in the history of this country as a contingent that oversaw the impeachment of a deputy president. And also the names of the ladies and gentlemen, the members of the legal community, the lawyers, the counsels, senior counsels and junior counsels alike will also be etched in the history of this country, in the annals of history, as those that oversaw this particular process. Ladies and gentlemen, remember, as this is happening, by the accounts of the senior counsel, Paul Mwite, and his team, the Deputy President is still at Karen Hospital. We haven't been updated otherwise. We understand and perhaps even assume that he's still admitted at the Karen Hospital, suffering from what we were informed to be severe chest pains. Folks, the voting is still ongoing at the Senate. All eyes are glued and all ears are attuned to this situation as it's happening. I can tell you, from those of us here at the home of Untold Stories, TV47, we have burnt the midnight oil. We have melted many candles, so to speak, to be able to bring this to you live and direct. Our teams are far spread and far stretched to bring you all of this live and direct. Folks, front seat of history, unbelievable, unprecedented scenes indeed. There were 11 counts, 11 charges against him, charges that warranted, according to the mover of the motion, the impeachment of such a senior officer. We expect the National Assembly to meet tomorrow morning, as they have already announced at 9 o'clock tomorrow morning. They will be having a special sitting, ostensibly to discuss the results of this very motion, this very voting exercise that you're looking at right now. What will transpire then? You can only find out right here on TV47. We shall be there bright and early to be able to give you the scenes and the sounds and the intrigues of what will happen in the lower house, the National Assembly. We also are warming up to a holiday, a national holiday happening on Sunday, Mashujaa Day, Heroes Day. And I'm telling you folks, never in our history have we had a holiday as anticipated as the one that is coming up. Because this will be the first time the nation sees its president, and hopefully this president will be expected to speak on the matter that you're witnessing right now. All along, the president has kept mum, absolutely mum, not commenting even a single word on what's happening right now in the country, on the fate of his deputy. We've listened to religious leaders, we've listened to political leaders, we've listened to lawyers and governance experts, we've listened to all and sundry on this matter. The citizens have pronounced themselves and are still pronouncing themselves. This is a matter that has attracted a lot of debate, a lot of disparate opinions and thoughts, very, very varied on this matter. It is history in the making, and in the days to come, we shall be having all sorts of debate, all sorts of conclusions, and all sorts of insights, really, on what's happening and exactly what is the impact of this as we speak. Folks, the people in that room that you see on your screen right now have been there for hours, more than 12 hours, folks, since the dawn of this day. And right now, well past the dusk, heading into close to midnight, actually, just about 50 minutes to midnight, the voting is still ongoing at the Senate. What do you think about what's happening right now? I ask you. The SMS number, I believe, should be on your screen, or if you are an ardent viewer of TV47, you know it's 22047. Please do let me know what you think. I'd very much like to sample your feedback on what is happening right now. But folks, once again, this matter cannot be overstated. These are historic times. Historic times indeed. A sitting deputy president halfway through the tenure of this government is being, or rather has been, impeached right in front of our very eyes in the Senate. Remember, this motion was moved by the member for Kibwezi West, Mwengi Muchuse, who's come under quite a significant amount of fire for the credibility of the 11 counts, many of which members have said have not been able to be proved. But really, the proof of the pudding is in the eating, and we can see right in front of our very screens that the members are voting, and they are voting quite convincingly on this matter.
Honorable Senators, we're moving to charge number 10. You may now proceed to vote. Senator Boni, proceed to dispatch and cast your vote. Honorable Senators, we're now moving to the final charge, charge number 11. You may proceed to vote. Honorable Senator Methu, proceed to dispatch. Senator Karen Nyamu, likewise. Senator Alan Chesang, proceed to the dispatch. Senator Karungo, proceed to the dispatch. Bayo. Senator Miraj, proceed to dispatch and cast your vote. Senator Ojenda, proceed to dispatch.
Ladies and gentlemen, you're witnessing history in the making. Deputy President Rigathi Gachagua becomes the first impeached deputy president. This is, of course, after the Senate upheld multiple charges during the historic trial. It should be remembered that earlier on, he did fall ill on the second day of the proceedings this afternoon, just when he was expected to come in for cross-examination. And of course, the team, his legal team's request for extension of that particular or adjournment of those proceedings or those hearings was denied, and it led them to actually step aside or withdraw from the particular process. Let's have a look at some of these charges and how the Senate and the senators have actually voted. The first charge was that of gross violation of the Constitution, and this was gross violation was upheld, ladies and gentlemen, with 53 senators voting in support and 13 opposing. The second charge of undermining the president and the cabinet was he was actually acquitted of this, as 39 senators voted against it. In the third charge of interfering with the Nairobi County government and devolution generally, it was rejected with 45 senators voting against it. And the Senate was also able to find the Deputy President guilty of undermining judicial independence through public attacks on a judge.
Ayes 54, nays 13, abstention 0. So the ayes have it. Charge number 2, ayes 28, nays 39, abstention 0. So the nays have it. Charge number 3, ayes 19, nays 45, abstention 3. So the nays have it. Charge number 4, the ayes at 51, nays at 16, abstention at 0. The ayes have it. Charge number 5, ayes 49, nays 16, abstention 2. So the ayes have it. Charge number 6, ayes at 48, nays at 18, abstention 1. So the ayes have it. Charge number 7, the ayes 13, nays 53, abstention 1. So the nays have it. Charge number 8, ayes 27, nays 40, abstention 0. So the nays have it. Charge number 9, ayes 46, nays 20, abstention 1. So the ayes have it. Charge number 10, ayes 22, nays 45, abstention 0. The nays have it. Charge number 11, the ayes 18, nays at 47, abstention 2. 27-4, 73-1A and 2B, 75-1C, and 129-2 of the Constitution, and Article 147-1 as read together with Article 131-2C and D of the Constitution. 4, gross violation, ground number 4, gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. Ground number 5, gross violation of Articles 3.1 and 148(5)A of the Constitution and the fidelity to the oath of office and allegiance. Ground number 6, serious reasons to believe that His Excellency the Deputy President has committed crimes under Sections 13(1)A and 62 of the National Cohesion and Integration Act. Ground number 9, gross misconduct that is incompatible with the high calling and dignified status of the office of the Deputy President and a member of the Cabinet and the National Security Council. His Excellency, the Deputy President, has publicly attacked and undermined work of the National Security Intelligence Service and its officers. Now, Honorable Senators, pursuant to Article 145(7) and 151(b) and 2 of the Constitution and Standing Order 78(8) of the Senate has resolved to remove from office by impeachment His Excellency Rigathi Gachagua AGH, the Deputy President of the Republic of Kenya. Accordingly, His Excellency Rigathi Gachagua AGH ceases to hold office. I thank you. You may rise, Honorable Senators. Now, Honorable Senators, there being no business on the order paper, the Senate stands adjourned until Tuesday, the 22nd of October, 2024 at 2:30 p.m.
Ladies and gentlemen, at exactly 11:32 p.m. on this day, the 17th of October, 2024, the Speaker of the Senate, Amason Jeffer Kingi, has officially announced the impeachment of Deputy President Rigathi Gachagua on at least 5 of the 11 counts which were preferred against him. This broadcast has been coming to you live from TV 47, the home of untold stories. You must understand that this has been a long journey over the last 72 hours, 11 charges, each of which has been voted upon individually and electronically after an afternoon full of drama, twists and turns, political and legal. We've seen senators looking like they're agonizing over the morality or the ethics behind some of these charges, and each of them wrestling with their souls on which decision to make. But finally, once again, 11:32 p.m., Amason Jeffer Kingi, this Honourable Speaker of the Senate, has announced the impeachment of Deputy President Rigathi Gachagua and his removal from office. If I may just take you through some of those charges and how they were voted for or against. The first charge was gross violation of the Constitution. It was upheld with 53 senators voting in support of it and 13 of them opposing it. We had the second charge, which is undermining the president and cabinet. And this was, the deputy president was acquitted, with 39 senators voting against this motion. The third charge of interfering with Nairobi County government and devolution by extension was rejected, with 45 senators voting against it. We also had the fourth charge, which the Deputy President was found guilty of, which is undermining judicial independence through public attacks on a judge, which had the support of 51 of the senators. Number 6, which was the breach of oath of office, was also upheld by the Senate, with 49 senators supporting the charge and 16 voting against it. Number 7, which was the one about making inflammatory public utterances. In this, he was convicted, 48 votes supporting the charge. He was acquitted of committing gross economic crimes and conflict of interest, with 52 senators supporting this premise. And he was also acquitted of misleading the public with insightful remarks, with 40 senators against this. The Senate convicted Gachagua for undermining the National Intelligence Service, with 46 senators supporting the 9th charge, of course, and 20 opposing. Out of the 11 charges, we've got 5 that were actually supported by the Senate. Our reporter, Elizabeth Mutuku, has really been burning the midnight oil, literally. And she is actually at the Senate, and she's been able to gather this information for us, in addition to what you have been able to see live and direct. This is history in the making, ladies and gentlemen, and I'm sure in the next few minutes we shall be able to reach out to Elizabeth. But back to the tally once again. Number 10, gross misconduct and insubordination. He was acquitted of this. And charge number 11, of course, gross misconduct and bullying of state and public officers. He was actually acquitted of these charges. 5 out of the 11 charges. Charges number 1, number 4, number 5, number 6, and number 9. He was actually found guilty of, and officially, as at 11:32 p.m., by the announcement of the Speaker of the Senate, Amason Jeffer Kingi, the Honourable, Deputy President Rigathi Gachagua ceases to hold office by way of impeachment. In the next few minutes, we shall be connecting. In the next few minutes, not quite yet, but in the next few minutes, we shall be connected to Elizabeth Mutuku. Any moment now, we shall be able to connect with her. She is on the ground. She is at the Senate, and she's connecting with some of those senators, and she shall be able to gather a number of them to give us some reactions, some responses, views and reviews, if you may, on what just happened. Understand this, the senators have been there for the better part of the day. As a matter of fact, for the entirety of this day. And it's been quite long hours there. And the senators have actually made history by impeaching the deputy president for the very first time. We are keen to understand what their views are, what their reactions are to this historic event, to this meteoric event, if you may. Elizabeth Mutuku will be joining us any time now. She should be joining us any time now from the National Assembly. If I may be able to just sample some of the quotes from the Speaker of the Senate, the result of the division indicated that the Senate has upheld the following impeachment grounds. Ground 1, that is gross violation of the Articles 10. Now, I will interrupt myself to go over to Liz Mutuku, who's joining us live from the Senate. Elizabeth, it's been an absolute cracker of a day, very long hours. What is the situation right now, the Senate? Who have you been able to speak to, and what do they have to say? Elizabeth, if you may.
Well, Victor Muyakane, is an historic moment here in Senate where we've witnessed the impeachment of Deputy President Rigathi Gachagua by senators passing 5 grounds, which, according to them, they have been substantiated despite of the hiccups of the day, ups and downs, and what we witnessed, even the councils from the DP side, even walking out of these chambers, but still what was to be done has been done by senators, and they believe that they go home having done what is right according to what they are mandated by the Constitution. Remember, this happens at a time when the Deputy President is not feeling well, according to his counsel and according to a statement which has been given. According to senators whom we've managed to speak to, this goes down as one of the best cases, or rather best, according to them, best impeachment which they've executed since they started, or rather historic, since they started impeachments in this House. But then I'd like to hear not from me, but other senators, what they have to say about the whole situation. Remember, this happens when DP Gachagua and his team still feel aggrieved over what has happened in this Senate. But allow me, as I say, to hear maybe from one of them and maybe to hear what they have to say.
Rais ni cheo ambacho kinaashiria umoja wa taifa la Kenya, na endapo tunaona jamii zetu haziwakilishwi kutosheka. Tuko na two tiers of government. Tuko na magavana ambao wako katika gatuzi zile, waweze kuzungumzia mambo ya matatizo katika gatuzi zile, lakini haiwezekani mtu mmoja katika mamilioni ya Wakenya ambaye rais alikuona utakuwa mwenzake uweze kumsaidia katika kufanikisha ajenda zake katika taifa hili.
Leo ukikwenda nyumbani unaweza kusema kwamba umeridhika?
Kwa hakika, japo kwa unyonge, kwa sababu Rigathi Gachagua aliyekuwa naibu wa rais alikuwa mwendani wetu, alikuwa rafiki yetu, lakini nimeamini kwamba vile walivyosema, kuna watu unaweza kuwa unawapenda na unawataka kuwa nao katika maisha yako, lakini kulingana na ufinyu wa mawazo yao, basi inakuhitaji wewe kufanya maamuzi magumu. Nina hakika pale alipo rais wangu wa taifa la Kenya, hata yeye hana raha, kwa sababu huyu hakuwa kipenzi katika wale wengi ambao walikuwa wamependekezwa kuwa naibu wa rais, lakini kwa mapenzi yake, kwa wisdom yake, akaona huyu ndo angekuwa mwenzake. Lakini yale ambayo yalikataliwa wakati ule yamekuwa vindicated na wakati, na imeonyesha kwamba hakuwa na ukomavu wa kutosha wa kuweza kuwa naibu wa rais. Kwa sababu tuangalie leo hii, ikiwa rais atakuwa ametoka mamlakani labda kwa njia ya kifo, je, ni nani atatuacha katika mikono yake? Kwa sababu hiyo na mengine mengi ambayo nimeyazungumzia hapo awali, tumeona heri tumpumzishe, na tunampenda sana naibu wetu wa rais, lakini katiba imetushurutisha kwa vile vipengele na zile kanuni ambazo yeye amezikeuka.
Na wale ambao hawajaridhika hasa upande wa naibu wa rais, kwa wale wamesisitiza kwamba licha ya kuwa kura ambayo umepiga, the day today remains one of their saddest moments.
I'll tell you one thing, kwenye siasa dadangu, hata watu wa Raila wamekuwa wakilia kwa sababu ni ushindani, lakini huu ambao tumeuona leo, ambao kwa mara ya kwanza tumeona, ni kwamba katiba imesimama kutetea wananchi na kuleta amani katika taifa hili, kwa sababu kauli alizokuwa akizungumza hata akiwa anajibambana.
Senator, how are you?
I'm fine.
I know you had your own objections on what was happening today. I will not say substantially objections, but I know very well you had your own reservations on the whole process. What do you take of this?
First of all, the process was flawed in that we applied the procedure for impeaching the president on the vice president without modifying it as required by the Constitution. And the reason is that the president is immune from prosecution, and therefore matters of law enforcement and criminal charges can find their way to the floor of the House. But the vice president is not immune to prosecution, and those kind of allegations should not be allegations for impeachment, should be allegations that are tested through law enforcement and the courts. Number two, I think that it was wrong to allow the proceedings to continue when somebody had been taken ill, and it seemed like I asked for some time to do that. He should have been allowed to go, and then we come back on Saturday and look at it. Number two is that during proceedings under the plenary, there are no timelines set. The timelines are set for committee, and we chose to go by plenary, which means the timelines under the committee were not applicable to timelines under the plenary. The only thing that was applicable was Article 259 Clause 8, which says that if the Constitution does not prescribe a timeline within which something is supposed to be done, then it has to be done in the shortest time possible. So I don't think we were fair, and that's why I did not accept any of the grounds, and I voted not all the grounds. They also did not meet the evidentiary threshold. There was a lot of, it was like the mover was simply playing around, and he didn't know what to do. The evidence produced was very, very low, and that's why I said, could we be going for a censure motion? And I asked the mover whether he knew the difference between a censure motion and an impeachment motion, and he conveniently did not answer me, because to me, as a censure motion, it was a motion that I could have supported and censured the Prime Minister, the former DP, and called him to order and said, what you are doing is wrong, please check it. I could not condemn him to political death.
From where you are seated, do you think DP Gachagua and his team has enough grounds maybe to challenge this in court and emerge victorious?
Yeah, they've got good grounds to do so. The only thing I felt a bit let down is that they walked out. They should have sat through and chosen not to participate. They should not have walked out, because now when they walk out, how will they show that whatever happened was not good for them? But I think they've got good grounds for appeal, but you know, the courts will have to make the final decision. But I don't know. I don't think that he may have a chance, given the politicization and the state capture, especially of the Supreme Court, which is totally captured by the state. I don't see him having a chance.
I know Kenyans had a lot of hope in the Senate. Do you think they have lived up to standards?
In terms of decorum and whatever we did, I think we did, but I think there was undue influence and pressure from outside the Senate. And the unfortunate part is that the independence of the houses is not there. The Senate is slightly just more independent than the National Assembly, but we have a long way to go to be able to gain the full independence because decisions are made outside the House and they tend to just be validated in the House. Yeah.
Thank you so much, Senator, for getting a minute at least to hear from you. Again, we are listening to various views from different leaders, and now I'd like to speak to one of the senators here, even as walking. Hi, Senator, how are you? I'd like to hear from you. Today we've gone through the process of impeachment, and today DP Gachagua stands impeached. But from where you are seated, how was the process? How do you feel about the whole process today?
First of all, I want to congratulate the Senate for demonstrating maturity in the debate. I also want to thank the parties that were involved in this process for also demonstrating really high levels of professionalism. On the matter of the impeachment of the Deputy President of the Republic of Kenya, Rigathi Gachagua, I would say, and I've said it before, every count, every ground that was brought against the Deputy President in the impeachment motion ran short of the threshold for impeachment. Remember what we are saying here is that we are saying that if this process, which is not complete, I mean, he has an opportunity to go to court, Court of Appeal, Supreme Court. Once this process is completed and whatever happens maybe is finally impeached, we are saying that this person now cannot hold office, public office, for the next 10 years. It's not a small thing. And this is the Deputy President of the Republic of Kenya. A lot of the grounds, actually to me, all the grounds that were brought before the Senate were not substantiated. This was just a theater for political play. Somebody has decided that Gachagua cannot continue being Deputy President. They have mobilized their numbers, and here we are. He has been impeached by a majority of senators sitting, but I want to thank God because I have personally voted no to every count that was brought.
Majority of Kenyans had hope in Senate to live into the standards and to ensure that at least they do the right thing. From where you are seated today going home, are you satisfied that Senate has done justice to Kenyans?
Now, one of the things that I must say is that I'm bound by the decision of the majority of the senators. So the decision then becomes a Senate decision. I'm bound by that decision. But personally as the representative of the great people of Kitui County in the Senate, I can say without the fear of contradiction that everything that we did today, the voting out of Rigathi Gachagua from office, for me, we did not serve justice to Gachagua. We have not listened to what the people, the majority of Kenyans are saying. The majority of Kenyans are saying that, yes, Gachagua may have come short on some issues, but for heaven's sake, where we should have started this motion was from the top, the president himself. And the government of William Ruto has been impeached by the court of public opinion. We should have listened to the voice of the people on the ground. But as I said, a decision has been taken by the majority. I'm bound by that decision. Yes.
Right, that is Senator Kio from Kitui, who says that they are bound, or rather he is bound by the decision of majority, but then he's not satisfied with whatever was done here in Senate. However, he believes that there are many avenues for Deputy President to be able to seek for justice. Remember, he's been impeached with 5 grounds being substantiated. But then I would like to hear from other senators. Allow me to look around and even see whether I'll get someone who I can speak to, at least to hear their views. Remember, this process has gone for 2 days, and we've been here, camping here, to ensure that at least you get to hear what what really has taken place. And also allow me to get someone else. As I said, I know there are many senators from both sides who are very much willing to speak to us. Remember, Deputy President Rigathi Gachagua and his council, he wasn't present because he fell ill, and his council walked out of the chambers in what they said that they couldn't stay behind, knowing that or rather justice will not be served. I know majority of senators voted and they say that this is the right thing, and rather they have accorded Kenyans justice, and we've been following this. And I know very well, away from just following this, there are many things which are in play, including tomorrow, a day where we are expecting to have a special sitting, and there have been also speculations that we are likely to have a name, maybe probably from, or rather Gazette notice in who is going to be a replacement to Deputy Rigathi Gachagua. And we really, as majority of senators who are voting, remember in their debate, each and every moment they kept on saying that we are wishing the very best and quick recovery to Deputy President from wherever he is, but this is our stand and we ought to do this. Remember also, Speaker of the Senate, that is Emerson Kingi, he kept reiterating, as well as the council from National Assembly, that it is about the timelines which have been set by Constitution, among other issues. I would like also to hear from Mheshimiwa Ruku, who is here. Hi, Mheshimiwa, how are you? I know you've followed keenly what has happened in the Senate. What do you have to say about this?
The Constitution of the Republic of Kenya is supreme. We have seen Article 145 and 150 of the Constitution coming practice or being put in place by the National Assembly and the Senate, where things are not going to be the same as far as the democracy of our nation is concerned. Kenyan democracy is a constitutional democracy, and you're going to see all the institutions established under our democracy becoming more stronger with this action moving forward.
From where you are seated, we've strengthened our constitution and our democracy more.
More. We are making our institution, as well as the state officers, to be more accountable to the people, to be more mindful on what we say, what we do, how we conduct ourselves when we are holding some of these offices in trust of the Kenyan people. Article 10 of our Constitution talks about the national values and the principles of governance. These are very serious national values and principles of governance, which every state officer given in an office must always remember that I'm holding this office in trust of the Kenyan people, and I have always to be mindful as far as the national values of our republic and the principles of governance of our republic as far as they are enshrined under the Article 10 are concerned. I think we have witnessed the rebirth of our nation.
From where you're seated, and majority of Kenyans are wondering, by impeaching DP Gachagua, are we going to cure what exactly we've witnessed, especially when it comes to cohesion, tribalism, among other key issues, which were repeatedly articulated through National Assembly as well as the Senate?
This will no doubt go a long way in curing some of these issues. We cannot have a very serious office of a deputy president or president who is championing ethnicity on a day-to-day basis, who is mentioning the names of other tribes more than the name of our nation Kenya. It is a turning point of our democracy. Things will never be the same as far as our democracy is concerned moving forward. We are going to be more mindful for those who are holding some of these offices in trust of the people of the Republic of Kenya. Having said that, we are requesting the President to move with speed and nominate a person who is going to occupy that office.
Now that you've spoken of President nominating that person is going to occupy that space, there is also the question of Mlima Kenya, West and East, and majority have their own views. But where do you stand when it comes to this?
We are not concerned about Mount Kenya East and West. What we are concerned is someone who can be able to occupy that office and show direction, leadership, be the proper principal assistant to the president. And this person is Professor Kithure Kindiki.
That is where you believe we're going to get the right leadership, according to you.
He has all the necessary qualifications. He has the required demeanor to bring the people of Kenya together and to assist the president in carrying out the mandate.
There are people who also have been proposed from Mount Kenya, Kangata. We've heard all these names among other people. Why do you think it's time for East?
I have no issues on those who have been proposed. Even me, I can occupy the office of the deputy president. But for now, we are saying the qualified, proper person to hold that office is Professor Kithure Kindiki. He has all what it takes to hold that office for now.
Should President maybe fail to nominate or rather appoint him to replace DP Gachagua, are there likely to be differences when it comes to his voters and his support in the Mount Kenya region?
We took an office to be arranged to have allegiance to the president. Whatever the decision he makes, we will respect that decision. In any case, he is looking for his principal assistant. It's not our principal assistant. It is his principal assistant. He is the end of state and end of government. So whatever the decision he makes, we respect it. But we are respectfully asking him, Mr. President, please, you have a person who can be your proper principal assistant in Professor Kithure Kindiki.
Thank you so much, Mheshimiwa Ruku. Are you anticipating for that tomorrow?
We expect to debate the nominee tomorrow morning, 9:30 in the morning.
Have you seen the order paper or have you heard of it?
I have not seen the order paper, but I'm going to government printers to ensure it is out.
Thank you so much. There has been Mheshimiwa Ruku who says that he's looking forward to see the name of Professor Kithure Kindiki in the list, or rather than that name presented tomorrow. And he says that he will make sure that he goes to the printers list to ensure that he gets properly to see who exactly is going to replace DP Gachagua. This comes even as DP Gachagua is in hospital. I remember earlier on there was an update on what was happening. And remember, as I said earlier, senators were sympathizing with the situation of Deputy President and what happened to him. But then even as I update you on what is happening, I know there are many leaders who I would like to speak to on what is happening around this area. Remember, this is an historic moment. It's something which has not been witnessed and will go down in the history as momentous and being the first deputy president to be impeached in the 2010 Constitution. I know a lot of senators still opine that he has reprieve in courts. If should that happen, definitely we're going to follow up. But tomorrow in the morning, we are looking forward to be in this house, that is National Assembly, and bring up updates on what is happening in this house, and especially if, as Ruku says and other members, there will be a name of a nominee to replace DP Gachagua. Back to you in studio.
Right. Thank you so much, Elizabeth Mutuku. Ladies and gentlemen, that has been Elizabeth Mutuku, our senior presenter and political reporter, coming to you live from the Senate, Nairobi. She's gathered some of the views of some of the senators who were in that room and voted for this particular motion to impeach the Deputy President, Rigathi Gachagua. And I would not like to repeat what she said, but I can assure you that we will be right here tomorrow morning when the National Assembly, the lower house, is able to sit and debate what the Honorable Ruku implies is the nominee, the new nominee for this particular position. We shall be telling you all of that later on. But just a recap of what's been happening, the Deputy President, as at 11:32 this evening, or rather we are now on Friday morning at 12:01, a minute past midnight, we're now in Friday. But last night on Thursday, 11:32 p.m., the Speaker of the Senate, that is Amason Jeffer Kingi, the Honourable, announced that by virtue of the vote, the Deputy President Rigathi Gachagua stands impeached. There were 11 charges. The first charge was that of gross violation of the Constitution for discriminatory utterances, and it was upheld by a vote of 53 against 13. The second charge was undermining the President and the Cabinet, and he was acquitted of this particular charge with 39 senators voting against it and 28 supporting this charge. The third charge was interfering with Nairobi City County Government and devolution by extension. He was acquitted of this by 45 senators voting against it and 19 supporting it. The fourth charge was undermining judicial independence through public attacks on a sitting judge. This charge was upheld. He was found guilty of this, with 51 senators voting to support this and 16 of them voting against it. The fifth charge was breach of oath of office and allegiance. It was upheld by a vote of 49 senators and 16 opposing votes. The sixth charge, ladies and gentlemen, was inflammatory public utterances violating the National Cohesion Act. And of course, this was upheld with 48 senators supporting and 18 opposing. The seventh charge, which was gross violation, or rather gross economic crimes, including conflict of interest and amassing a approximately 5.2 billion fortune illegally. He was acquitted of this charge with 52 senators voting against it and 14 senators voting to support it. The eighth charge was misleading the public through false, malicious and insightful remarks. He was acquitted with 40 senators voting against it and 27 voting supporting it. The ninth charge was undermining the National Intelligence Service. This charge was upheld by 46 senators voting against it, voting for it, and 20 senators opposing this. That's the ninth charge. The 10th and penultimate charge was open insubordination of the President, and he was acquitted with 44 voting against this charge and 22 in support. The final charge of gross misconduct, where he was accused of persistently bullying state and public officers, the charge was quashed, with as many as 18 senators voting to uphold it and 47 voting against it. Should be noted that about 2 of the senators voted, or rather abstained from the vote. Once again, folks, it cannot be overemphasized. These are historic times. But we've heard from some of the senators there that there still remain some options for the Deputy President to be able to save himself and the integrity of his tenure in office. And those options exclusively lie in the courts. He has the option of going and appealing the decision by the Senate, as well as the decision by the National Assembly in the courts. But tomorrow, ladies and gentlemen, the lower house, the upper house has spoken, that's the Senate. Tomorrow, the lower house, which is the National Assembly, will be congregating at approximately 9 o'clock in the morning for a special sitting. The actual contents of this very special sitting are yet unknown for certainty. However, we've heard some, what in Swahili we say, duru za kuaminika. We've had some comments and some speculation around the mission for the National Assembly tomorrow morning, and the vast majority of the people who are commenting on this, including some of the members of Parliament, including the member Jeffrey Ruku, a lot of them say that it might be a sitting to discuss the nominee for Deputy President, the new nominee. Even before the dust settles on the impeachment of Deputy President Rigathi Gachagua, it looks like the impeachment might just be followed by the conversation on his replacement. Once again, the Deputy President Rigathi Gachagua stands impeached. Now, the Star newspaper tomorrow has already put up the headline, or rather the front page. And the front page reads as such: Grace to Grass. 53 senators vote to kick out Rigathi Gachagua as 13 reject the motion late in the night. This is going to be from the front page of the Star, followed by page 2, 4 and 5 of the Star newspaper. And the front page, of course, if you would purchase the Star newspaper tomorrow, you will be able to see the front page, and the Deputy President looks there quite pensive with bags under his eyes, a man under siege. This was when he had the opportunity to actually speak in front of the Senate. The Star newspaper, of course, also has page 4 is going to be talking about the choice of the next deputy president, which will have a huge impact on the rest of the president's term. That cannot be debated, of course, and we shall be giving you feedback on that. Another part of that Star newspaper tomorrow is going to be talking about which way for Mudavadi if the president chooses the Interior CS Kithure Kindiki. And I would imagine the opposite discussion will also be happening in case the president chooses to make another choice. Now, the front page of the Star, still in keeping with that, have you understand that we do have an understanding, a memorandum of understanding between TV47 under the auspices of Cape Media Limited, the parent company, and Radio Africa Limited, which owns the Star newspaper. We have an understanding, which is why I am choosing to let you know what's coming up tomorrow morning in your copy of the Star. I believe it's out right about now. It also says an uncertain future, of course, and there are fears of a heart attack as senators vote to remove the Deputy President Rigathi Gachagua. These are historic times. It's been an incredibly long day for our journalists, for our crew members who've been on the ground covering this absolute cracker, absolute historic, significant, historically significant moment in our country. They've been covering it for you across the day from morning till now. And I believe it's high time we are able to just give them a bit of a rest, because early tomorrow morning they shall be marshalling and being able to capture and relay to you the happenings at the National Assembly. Once again, folks, historic times. The Deputy President of the Republic of Kenya has been impeached with 5 out of the 11 counts, or 11 charges, 11 accusations that were leveled against him. This process has been fraught with dissent and debate. There's been many people who have actually come out to criticize the conduct of the lower house, the National Assembly, others to actually praise it. But one thing that has been critical is that these two houses, the lower house of the National Assembly and the upper house of the Senate, have found themselves charting uncharted waters, waters that have been unprecedented indeed. A critical matter of precedence has actually been set tonight with these debates and these discussions, and of course the decision that has been made. Our team has been on the ground to bring you this and other stories surrounding this, and we have prepared a few other stories. But ladies and gentlemen, we'll leave you with some of the views, some of the sights and sounds from the Senate earlier today as they deliberated on this very, very historic decision. Folks, my name is Victor Muyakane. On sign language is Rhoda Nyamai. Earlier on, we heard from the great Elizabeth Mutuku, who was joining us live from Senate, alongside her camera person and indeed the rest of the team. We have Liz Mutuku still, and she's talking to the Kiambu Senator Karungo Wathangwa. Let's join in and have a listen.
For this country, it's a sad day for our constitution. It's a sad day for the rule of law, because Kenyans had high hopes with the Senate, because you are being perceived as the upper house, and I believe that we were supposed to do better. The Deputy President of the Republic of Kenya was not accorded enough time to execute his case. And I do not understand what was the hurry, because we still had days. I know we had the timelines, but our timeline was expiring on Saturday. So we could have waited when he was told he was taken ill. We could have waited for tomorrow. We could have waited for Saturday. So the issue of rushing to make a decision without the deputy president today, and you know, he's a very active person, but yesterday we made him sit down for almost 16 hours, from 9 a.m. all the way to after midnight. So probably, because he's not used to sitting down, something could have happened. Today we made him to sit down from 9 to 2:30. And after lunch, we're expecting him. He was in high spirit. And you know, people are saying he was okay. We could see him laughing. People die laughing. People get accident laughing. And then you say, yesterday I was with him 2 hours and he is normal. So what I'm trying to say is, sickness does not knock to tell you that I'm going to attack you at 2:30, so be prepared. So I believe the deputy president was not accorded an opportunity to defend himself. And the Senate rushed to make the decision because they're in cahoots with the National Assembly to make sure that maybe probably we have a new deputy president hurriedly sworn in or vetted. But we are saying we are not going to back down. We urge the deputy president to go to court because we believe in the rule of law. And if he goes to court, I'm telling you, if the court accorded him the opportunity that we did, they will exonerate him. He'll be out of any ground and he will be exonerated by the court.
And from where you are seated, do you think justice has been served in the Senate, even with the 5 charges which have been substantiated?
You know, it was a premeditated thing. There is no justice at the Senate. They could say, vote yes on this one, vote no on this one. But you see, out of the 11 grounds, if you vote yes on only one, he goes home. So it was karata, pata potea. Weka hii, toa hii, weka hii, ndio tuonekana tulisema yes, tulisema no. But for me, I've said no in all the 11 counts. Reason, he was not given an opportunity to defend himself. So why do you impeach somebody who was not given an opportunity, and we are not out of time? So justice has not been given, and we urge Kenyans, please stay calm, wait for the courts of law, because I believe he is going to get justice. But those who are trying that, those who are trying, those who are financing, those who are pushing for his removal, just know, if Rigathi Gachagua can be removed, you'll be removed within 2 seconds. Yes.
And from where you're seated as well, there is the question of replacement and majority that it should be from Mount Kenya region. Do you think?
I don't care who's going to be the next deputy president. I don't care. Somebody whom we believed, somebody who can speak and stand against the president. What about anybody who is just looking for the seat? I see people who are saying, give me, give this, give that. Can you imagine if Gachagua can be taken out within the record time of 2 days? Who are you? You'll be taken within 20 minutes. So I don't care who's going to be the deputy president. I'm not interested. But all I want is to make sure that the deputy president, the current deputy president, because he's still the deputy president, gets justice at the courts of law.
Thank you so much, Mheshimiwa.
Ladies and gentlemen, that has been the Senator for Kiambu, Karungo Wathangwa, giving his vociferous views on the matter that has been in front of the Senate. He has been consistent in his views that the Deputy President has not actually gotten, due justice, as of course you have heard. I tell you, it's been a long day, and I understand a lot of you are still shell-shocked. You cannot believe what you see with your eyes. These are historic times, unprecedented times. Times that portend great changes in our future as a nation. Once again, I'd like to thank all of you for choosing us to inform you. If you go to our YouTube channel on TV47 Digital as well, we shall be able to show you shall be able to see our entire coverage of the day, and we ask you to go there and just kind of revisit what has been happening across your day. The time for analysis is coming. The time for insight and deeper conversation is coming, and we shall be right there to give you the front seat to history. Once again, my name is Victor Muyakane. On sign language, we have the Great Road in Nyamai. We also have just heard from Elizabeth Mutuku, our senior political correspondent and anchor. In the gallery, we have Emmanuel Inonda and his team. In the editorial team, we have the two Masharias, Gashuru and Wamugo, as well as, of course, the able leadership of our CEO himself, a journalist of long standing, Mr. Mwenda Njoka, and, of course, Eric Munene, the editor for the day. I remain yours, Victor Muyakane. I wish you a good night full of God's blessings and some peace tonight as we contemplate the changes facing us as a country. Good night, folks. God bless you.